Agnes, what's our script? Simon? We're meeting number 67? Yeah, with this, okay, all right,
You don't have the right here.
all right,
6-7. Yeah.
okay.
Bonjour, je déclare la séance ouverte. Je vous souhaite la bienvenue. On en est à la 67e réunion du Comité permanent de la sécurité publique et nationale. Inaudible.
Interpreters to check I call this meeting to order. How are we doing? Better? So welcome to meeting number 67 of the House of Commons Standing Committee on Public Safety and National Security. Still a problem, Mr. Calkins? Okay. All right. We will start by acknowledging that we are meeting on the traditional unceded territory of the Algonquin people. Today's meeting is taking place in a hybrid format pursuant to the House Order of June 23rd, 2022, and therefore members are attending in person in the room and remotely using the Zoom application. Pursuant to the order of the House of Tuesday, May 9th, 2023, the committee resumes consideration of Bill C-21, an act to amend certain acts and to make certain consequential amendments firearms. I would like to remind all members regarding some specific sections of the motion adopted on Tuesday, which have an impact on clause-by-clause consideration. Amendments filed by independent members shall be deemed to have been proposed during the clause-by-clause consideration of the bill. Not more than 20 minutes be allotted for debate on any clause or any amendment moved, to be divided to a maximum of 5 minutes per party, unless unanimous consent is granted to extend debate on a specific amendment. And at the expiry of the time provided for debate on an amendment, the chair shall put every question to dispose of the amendment forthwith and successively without further debate. If the committee has not completed the clause-by-clause consideration of the bill by 11:59 p.m. on Thursday, all remaining amendments submitted to the committee shall be deemed moved. The chair shall put the question forthwith and successively without further debate on all remaining clauses and amendments submitted to the committee, as well as each and every question necessary to dispose of the clause-by-clause consideration of the bill, and the committee shall not adjourn the meeting until it has disposed of the bill. Before we proceed, I would now welcome the officials who are once again with us. From the Department of Justice, Sandro Giamaria, Counsel, Phaedra Glushek, Counsel, Criminal Law and Policy Section. From the Department of Public Safety and Emergency Preparedness, Rachel Mainfield Dale, Acting Director General, Firearm Policy. From the Royal Canadian Mounted Police, Rob Daly, Director, Strategic Policy, Canadian Firearms Program. Kelly Paquette, Director General, Canadian Firearms Program, and Rob McKinnon, Director, Canadian Firearms Program. Also, I would like to welcome the officials from the Canada Border Services Agency, CBSA, and the Canadian Nuclear Safety Commission, who are not at the table at this moment. From the Canadian Border Services Agency, we have Jeff Robertson, Manager, Inadmissibility Policy Unit. Sorry, that's Inadmissibility Policy Unit. Strategic Policy Branch. From the Canadian Nuclear Safety Commission, Pascal Bourassa, Acting Director General, Directorate of Security and Safeguards. Pierre-Daniel Bourgeot, Counsel, Legal Services. These officials will join us at the table and be available to answer questions when we study the following clauses. CNSC are relevant to clauses 49 to 51, and CBSA relevant to clauses 52 to 63, 67 to 69. So, thank you all for joining us once again. Your participation is critically important to us all. We have a couple of, I note that Mr. Culkin, followed by Mr. Julian, are on a speaking list, but before we go into that, we have a couple of housekeeping items. First one being on NDP 1. The amendment of Ms. Demoff has a couple of grammatical concerns. I will ask the clerk to mention them, and perhaps we can change them on a unanimous consent basis. So, Mr. Clerk, if you would, please.
Thank you, Mr. Chair. As you recall, yesterday the committee adopted a sub-amendment to NDP 1, the protection order, and there was a new definition. And in French, it says ordonnance de protection.
Protection order means an order. It should be. It's a correction in the French language.
The accord is not done properly with the feminine gender, so it should be limité, E accent aigu, E. So we just need to add a D apostrophe at the start and an E at the end. So that's all that would be required.
So do we have unanimous consent to effect those changes? Oui, absolument. Done. Thank you.
Can I ask a question on that clause, Chair?
Very, very, very quickly.
Well, I'd need unanimous consent to do this, but my understanding, and folks weren't here last night, or maybe you were, Blaine, when Alex Ruff, or Glenn Motz was talking about courts not being the only ones who issue protection orders. And so because of time limits, we didn't have a chance to amend that. And I think we're actually not accomplishing what we wanted to accomplish because of the amendment that I put forward. So because I used the word court, we're actually limiting what we can do. And in addition, officials pointed out to me that we have not given them regulating powers. So I'm just wondering if there's unanimous consent for me to just provide some wording to change that, to fix it.
Do we have some unanimous consent on this matter? I believe we do. Go ahead, please.
Is that okay?
I just want the same courtesy when I want unanimous consent.
Well, let's start out on the right foot here.
All right.
So I think, I don't have it in front of me right now, but is there wording that we could add to it that would allow officials to still regulate? I think I came up with wording actually yesterday, and then we were ending, so.
So I'll give you some time to find that and sort that out. We consider the matter will be addressed on a unanimous consent basis. There is another matter, another error that we made, and this was a matter brought up by Mr. Paulus yesterday. This is on G21. There is a discrepancy between the English and the French, where the word, the clause, I believe it is clause 2 sub B on page 62 of the package, 52, okay, where clause 2 sub B begins with the word if in the English and where in the French. Why is the French side English? Go ahead, Mr. Clerk.
Thank you, Mr. Chair. The change is only done to the English version, so of course on the French side you'll have the new English version. So it says basically be where the justice is satisfied. On the English side, it should also say where the justice is satisfied, and it says if. So at the reprint is going to be a problem because we won't know which one to put there. So I asked Ms. Villedale what wording would be the preferable one, and she indicated to me that where would be on both sides the appropriate one.
So the request is to change that one word if to be where in the English version. And do we have unanimous consent to do so? Agreed? I believe we have a unanimous consent. Thank you.
Thank you.
Mr. Moff, are you ready to go? Okay, so on this is on the amendment you made previously, and we're kind of looking for unanimous consent to make some. We have a unanimous consent for you to propose some changes.
So currently it says a court. It was NDP 1, which was amending clause 15, Alex. So it would be by a court and then adding the words "or another competent authority." And then at the very end, we took out too much. I take complete blame for this. But it should still include orders that prohibit a person from, and that got deleted when we did the clause, I believe. So it doesn't really make sense. Is the orders that prohibit a person from still there? So it would just be that this includes but is not limited to orders that prohibit a person from, because the way it reads right now, it's according to what I submitted this includes but is not limited to being in physical proximity to a person. So it just didn't make sense. So it would be adding "or another competent authority," and then at the end, orders that prohibit a person from. And then at the end, is there standard wording available that regulations would be made based on this? We don't want to take officials' ability to make regulations away from them, which is what I understand we have done in this clause.
If I could make a suggestion.
Absolutely.
So then the original clause was worded, protection order has the meaning assigned by the regulation, and then I would add the language that you're comfortable with, which can include or, that kind of general intent is saying that, this is what it's intended to capture, but has the meaning assigned by the regulations.
I'm good with that.
Okay, so Mr. Calkin, you wish to respond to this?
Yeah, this seems to be a more substantive change than we originally expected. Can we get a get this in written format distributed to the committee so that we can actually see? I'm going back into this binder, and I can't even find NDP 1, so I'd like to actually see what's going on, if you don't mind.
Mr. Muff, can we do that, and we'll come back to this once that's available?
Yeah, that's fine.
Okay. Madame Michaud, allez-y.
Est-ce qu'on peut s'assurer que ce
Could we make sure that that is in both official languages, please? Could we make sure that the document we receive from Ms. Demoff is in the 2 official languages?
We'll do our best.
Il faut.
Il faut. Okay, so we will come back to that when everything is good. Monsieur Godin, on the same matter?
En fait,
As my colleague is having difficulty following, I'm new in the committee, but I would like to draw your attention to something. I don't know how we can fix the situation. Maybe the law clerk could help us. G21, paragraph 4, 11.1 on page 52. We worked on B, not on 4. Correct me if I'm wrong. We talked about if versus where. Mr. Julian, am I correct? That's what we looked at. I'm talking about paragraph 4, which is under 11.1. The English version says...
la version française.
The French version... The conditional is used in the English version, and the conditional is not used in French. Could the law clerk please confirm that everything is correct in the interpretation of that text?
Well, thank you, Mr. Chair. Oui, je peux essayer.
I can try. You need to know that drafting by the Department of Justice is done by an English language drafter and a French language writer. So it's not a translation. So you have 2 separate people writing the document at the same time. Sometimes in English you have if following the hearing of an application made under. In French, the formulation is different. So it's after the request that something will happen. So it's the same thing in practical terms when it comes to understanding the terms. Thank you for the answer. Today, we experienced something special in the House of Commons. For C13, we made corrections on commas and words. 10 motions were tabled by the government after the kind of work we do here on C21. So I just want to make sure that we don't repeat the same mistakes. So I'm just lifting the flag, and I want to make sure that we make sure that the meaning is the same, because it's a law and it's going to be interpreted later. So we have to make sure that there's less debate in court when it has to be interpreted. So I just wanted to flag the issue.
Good? You're good, okay. Merci, monsieur.
Thank you, sir.
So as we wait for the translation that Madame Demoff is undertaking, or the hard copy, Mr. Calkins, I believe, wants to move a motion on an amendment on Clause 30. Is this what you wish to speak of, Mr. Julian?
Yes, Mr. Chair, we could be looking at the same amendment.
Okay, so I have Mr. Calkin kind of on the list first, so
Yep.
we'll let him go ahead.
Yep.
And then after we're done Clause 30, I propose that we will go to Mr. Ruff, who will ask for unanimous consent to go back to Clause 18 to do his amendment. Mr. Calkin, if you please.
Thank you, Chair. Just to let you know, I have two amendments to this clause that I have to do separately because they're separate issues. And the first one I have to move simply because I did not have time in the 5 minutes to ask the question that I wanted to ask in regards to this Section 3 and authorization to carry. So what I propose, Mr. Chair, is to remove the word not between the words are and valid, so that it would read in English, authorizations to carry are valid outside the province where the holder of the authorization resides. And my reason for moving that amendment is I would like to ask the department officials a question regarding what this clause intends to do. My colleague, Mr. Jennis, when he was here, talked about people who live in close proximity to borders. I just want to understand clearly this authorization to carry that's being discussed here, is it for personal protection or is it for things like trappers for protection from animals? Would it be all of those, or is it for those very rare opportunities or rare instances where an individual is carrying a firearm for personal protection from another person, or where law enforcement can't readily respond? Is it both, or is it just the singular instance?
Thank you. It would cover all of the authorizations to carry for reasons under 20A or 20B. The intent, normally as it works currently today, if you have an individual, for example, the vast majority of them are for reasons of employment. So for example, it's a security guard that carries a handgun for a bank cash transfer company. They have one in Ontario. Well, then there's an agreement that happens also with the, for example, Quebec CFO, so that they can cross over to Gatineau and do their route cross there. And so there's an agreement. It's still an authorization in the province in which it was issued currently today, and that's what the intent was to capture those situations. However, the way it's worded, it would limit it in terms of where that person resides. So I think the intent would be to maintain the current regime, so there is a sort of geographical reality to the authorization to carry.
So I just want to point out, sir, that the clock is running, so if you could move the amendment,
I did. I believe I said I wanted to withdraw the word not.
Oh, okay. I missed
from the
that.
clause.
I apologize.
Sorry, Chair, if I wasn't clear.
Are you clear
So
with
my purpose for removing the word not, I want to speak specifically, and I appreciate your answer, but I want to speak specifically to those cases where it's not for the purpose of employment or the purpose of somebody who, through the course of their job, like a trapper or an armored car guard. I'm talking about in those rare instances where an individual has been given an ATC for personal protection for whatever reason. And if I read this correctly, This clause, if it's not amended, would limit the person's ability to travel in their country with their protective device that they've been authorized to carry to the area of jurisdiction for that chief firearms officer only. That means that they would not, they would essentially be, because I can't come up with the right words right now, they would be imprisoned in their own area of jurisdiction and not able. So I'm asking you from a charter perspective, under the Charter of Rights and Freedoms, under Section 6, mobility rights, that every Canadian citizen is granted the ability to travel freely in this country. And under legal rights, under Section 7, everyone is entitled to the right to life, liberty, and security of the person. These people would be issued this authorization to carry for that life, liberty, and security of the person premise. And that life and that security of the person premise only applies then to the jurisdiction of the chief firearms officer. It doesn't apply to the entirety of Canada. So is this clause actually charter compliant?
So I'll point back to, as I said, the intent was to sort of mirror the language that was originally there and adapt it because of the change of the authorizations to carry for protection of life. And we sort of recognized we did recognize yesterday that this did not capture the intent that was the government's intent when drafting the motion. However, with regards to charter, I will turn to my colleagues in terms of the implications.
Yeah, thank you for the question. Unfortunately, I don't think I can give charter advice, but just as a point of clarification, Section 6 of the charter it's not actually a freedom of movement guarantee. It provides a right to enter a province and take up residence in that province, right? So it's narrower than I think maybe you characterized it as kind of being just a bare right of freedom of movement. So I just wanted to provide that correction.
Mr. Cochrane, I'm going to have to get you off there.
Oh, well, thank you, Chair.
Mr. Julian, if you please.
Thank you, Mr. Chair. I understand what Mr. Calkins is trying to get at. I would not be voting in favor of his amendment, but would like to offer a possibility once we've considered his amendment, which is to change, to add the amendment and or works. So Clause 30 would read, authorized to carry are not valid outside the province where the holder of the authorization resides and or works. I believe, we can double check with the officials, but I believe that would cover border areas such as Mr. Janis raised yesterday. So that would be what I would offer once, if Mr. Calkins' amendment is defeated.
Okay, I can't go back to Mr. Calkins at this point. Are there any further discussion on Mr. Calkins' amendment? Seeing none, I will ask for a vote on Mr. Calkins' amendment. A recorded vote? Yes, please. If the clerk would conduct a vote.
Ms. Damov? No. Mr. Chung?
No.
Mr. Gair?
No.
Mr. Noor Mohammed?
No.
Monsieur Chifke? Monsieur Chifke? Monsieur Chifke, on ne vous entend pas.
Mr. Shefke, we can't hear you.
Mr. Calkin?
Yes.
Mr. Ruff?
Yes.
Monsieur Godin?
Oui.
Mr. Barlow?
Yes.
Madame Michaud?
Contre.
Mr. Julian?
No, contre.
4 people in favor, 7 against.
Right. So, thank you. So I know Mr. Cochrane has one more amendment, but I think Mr. Julian had his hand up right after. So we'll take them in order. So, Mr. Julian, if you wish to move your amendment, and then we can come back to Mr.
Thank you, Mr. Chair. Well, I would move that we add the words and or works at the end of the phrase. I would move that, but I do want to double check with our officials to make sure that that is an appropriate wording to resolve the issue that Mr. Jennis brought up.
Thank you. You could also consider mirroring the language that's in 20B of the Firearms Act for use in connection with his or her lawful profession or occupation. Works is a little simpler, but you could consider mirroring the language that's already in the Firearms Act.
Which would be?
For use in connection with his or her lawful profession or occupation.
Okay. And for use?
And you could also consider for the questions for protection of life of that individual or other individuals. So if you could, I think we might want to maybe just take a few minutes with my colleagues, if that would be all right, just so that we could consider.
How about we go, does your amendment interfere with this amendment, do you think? Nope. Okay, how about we go with Mr. Calkins' amendment while you guys sort that out? And we'll be efficient with our time. Oh, and Madame Demont.
No, I don't have a problem with that, but it probably involves asking officials questions, and they can't answer Mr. Calkins' questions and ours if they're thinking about something. So I think maybe we should let them put their heads together,
They have to
Chair.
sort it out. yeah.
Okay, so we'll suspend for a couple of minutes and
We were actually thinking,
get this
first
sorted
time
out.
ever, I think you and I had the same
No,
thought.
we've agreed before, Blaine.
So we resume the meeting with Mr. Julian has the floor. Mr. Julian, would you like to reread your amendment, please?
Merci, Monsieur le Président. Mais
Thank you, Chair. It's going to be very different from what I drafted, and I want to thank our officials for producing the bilingual version and so quickly. High quality document.
Sorry.
Chair?
Mr. Shipley, do you have an issue with translation?
No, I just wanted to mention on a point of order, I hear Mr.
Point
Taliba's
of, Mr.
concerned
President.
about my attendance at the committee. I've been here virtually the whole time.
Point of order.
Just as he is. I just
Point
want
of
to make
order.
sure he's not worried anymore.
That's not a point of order. That we need to keep that offline. We're underway with Mr. Julian's motion, and we'll need to carry on with it. Mr. Julian, please carry on.
Sorry, point of order, Chair.
Ms. DeMoff on a point of order.
Mr. Shipley needs the headphones if he's going to speak.
Absolutely. Mr. Shipley, please, you're going to have to dig up your headphones. Mr. Julian, please.
merci beaucoup, Monsieur.
Thank you very much, Chair. Happy to see you, Mr. Shipley. The amendment will read as follows. Clause 33, the authorization to carry provided for under 20A will not be valid outside the territory as established in the Commissioner's authorization. The authorization to carry provided for under 20B will not be valid outside the province of issue. That was a free translation by the interpreter. We don't have the version. So 20A, 20B, different ways of treating that authorization to carry.
That in hard copy that we can distribute to the committee? It's already distributed? Okay. Madame Michaud, allez-y.
Ms. Michaud. Thank you, Mr. Julian, for that amendment. My question, Ms. Medley, you somewhat answered the question, but I just want to make sure. Essentially, authority is given to the Commissioner of the province to decide, right? It's now up to the Commissioner. For as long as there are protection issues and someone needs an authorization to carry for their own personal protection, of course, that's very specific, individualized cases. The Commissioner will be able to prepare an authorization that's specific for the needs of those persons. So it's going to be the prerogative of the Commissioner. Great. Mr. Julian, you said it orally, but with the written version, there's a letter that's missing, an A. In the last sentence in English, after prévu and after alinéa. So there's an accent that's missing in the French. Thank you.
Thank you. Can we consider that corrected? Sorry, there's an accent missing in the French of Mr. Julian's. Madame Michaud, please, could you say that again, please?
Absolument.
In the last sentence, in the French version, the authorization to carry, there's a dash, and A with an accent is missing. So it should be added before it passes.
That's how you move this?
Oui.
Oui.
Tout à fait, Monsieur le Président.
Yes, indeed, Chair.
We have more. Carry on.
Thank you, Mr. Chair. So, dans la version française,
In the French version, authorization to carry provided for, there should be no S in the French, prévu in alinéa 20, is not valid in the territory established. And the établi should have an E and not a T. And then the authorization to carry provided there's no S under alinéa 20B is not valid outside the province of issue. That stays the same. So these are editorial changes in French.
Can we consider those changes are made and unanimously adopted? Thank you. Okay, so the debate on Mr. Julian's motion continues. Is there any further discussion on Mr. Julian's motion? Mr. Calkins.
Yeah, just a question for the officials in how this is interpreted. And I believe I'm working from a current copy of the proposed amendment by Mr. Julian. And the correction that was just made, because I've just got this now, was in the French language version. So there's been no changes in the English language version that would have been sent to
I believe that's correct.
Is that correct? So it says here, so it's changing now to read, authorizations to carry referred to in subsection 20A are not valid outside the geographic area set in the authorization by the commissioner. Can you explain to me, because I thought in the discussion that we had about these authorizations to carry, that authorization was granted by the chief firearms officer, not the commissioner. So why are we referring to the commissioner here instead of a chief firearms officer? I'm just looking for some clarification.
So there's an amendment in the bill to centralize the authorizations to carry for personal protection, to centralize those with the commissioner. That was a clause, I believe, that was passed last evening.
Yeah, that's right.
And so therefore, that one is to give discretion to the commissioner to set the geographic area according to the needs of that individual person. For people that will have an authorization to carry for reasons of their employment, the current process would exist where this chief firearms officer would be the ones that would issue the authorization to carry.
Can you just repeat that last bit, please?
For people that have an authorization to carry for reasons of their employment, the current process would continue in terms that would be the CFO, the Chief Firearms Officer of the province, that would issue it. And if they need to cross the provinces, then there's an agreement between the CFOs.
Thank you. So the geographic, so in the first part of the amendment, or second part of the amendment, says the geographic area set in the authorization by the commissioner. The amendment that I was going to move, had I not been bumped by Mr. Julian, would have been to add province or territory, because not everybody lives in a province. So in one part of the amendment here, we're talking about an authorization by the commissioner in the geographic area. And then in the second part of the amendment, it says authorizations to carry referred to in subsection 20B are not valid outside the province in which they are issued. Not everybody lives in a province. Even though the chief firearms officers now, which have certain authorities that the commissioner doesn't have, the province, or sorry, the territory, the Northwest Territories territory is no longer part of the joint Alberta area. So do we need to have an amendment in order to make this valid and legitimate, where we say province and territory, or province or territory in which they reside?
I would refer and rely on the Interpretation Act, in which province includes the territories.
So that we don't need to actually have that amendment made for clarification?
No.
Okay.
That's very good. Okay. Are there any further discussions on Mr. Julian's amendment? Seeing none, let us conduct the vote. All in favor, please raise your hands. All opposed? Carried. So, Mr. Calkin, did you have still another amendment to make?
Questions have been answered.
Okay, excellent. So we'll go back to Mr. Moff. Are we ready with Mr. Moff's amendment?
We are, but do you want to carry clause 30 and then we'll go to mine?
That's a very good idea.
Thank you.
Okay. Okay. Shall clause 30 as amended carry? Recorded vote. Mr. Clerk.
Voting no.
Ms. Damoff? Yes. Mr. Chung?
Yes.
Mr. Gaye?
Yes.
Mr. Noor Mohammed?
Yes.
Mr. Aldag?
Yes.
Mr. Calkins?
No.
Mr. Ruff?
No. No.
Monsieur Godin?
No.
Mr. Barlow.
No.
Madame Michaud.
En faveur.
Mr. Julian.
Oui, en faveur.
7 in favor, 4 against.
Great. Clause 30 does carry. Okay, so we have Ms. DeMoff's amendment, and then we'll get back to Mr. Ruff. Mr. Moff, do you wish to, I'm sorry, so your amendment is on NDP, on your previous amendment to NDP 1.
Correct.
Okay, are you ready to proceed with
I
that?
am.
Okay, please, and that has been distributed to the committee?
Yes.
Okay. Carry on, please.
So it would amend the first paragraph that we adopted yesterday, that will clean it up. It won't, it will allow officials to make regulations, but it will also expand who is issuing a protection order. So the new one, and I'll just read the first paragraph, Chair, if that's okay, because everyone has it. It would be protection order has the meaning assigned by the regulations, bracket ordonnance de protection, end bracket, but is intended to include any binding order made by a court or other authorizing entities in the interest of the safety or security of a person. This includes, but is not limited to, orders that prohibit a person from. Sorry, I think I might have an old one. Do I? I do. Could you correct the word? Sorry, I took the one that the clerk sent me, but I believe that's not the most recent one. So it's by a court or other competent authority in the interest of the safety or security of a person, not of. So I hope colleagues will support that. We've already passed the clause. This is just cleaning it up and making it more effective. And I'm
sorry, so you're amending your previous amendment. Is that what you're doing? The text of the previous amendment?
It's the text of what we passed in NDP 1, yes.
Okay, all right. Mr. Clerk, are you clear on this amendment?
Did you remove the term courts?
Okay.
No, it says by a court or other competent authority.
Oh, I don't have that. I don't know that. Est-ce que tu l'as, toi?
Just, thanks, Mr. Chair. Okay, sorry.
I don't have it. Okay, where is it?
I'm hoping we get back to.
Yeah, no, this is on Ms. Damos. Just.
Okay, carry on, and we'll
yeah, sorry.
get to sort out.
Just the email that's been sent. I've got two different versions here, and nothing that I can see shows the changes that and I know this was approved, but nothing shows the changes. So I'm having engaging from my colleagues, having a bit of a difficult time, and you know, I know for us, I want to thank our colleagues who are permanent members of this committee to allow us that if this is very important to our constituents. So I appreciate the time that they've given us to be a part of this. So, and I apologize if I'm going a little bit back, but the email and again, this is pretty critical to my constituents, and I know many of us, so I want to make sure I'm following this properly. And the email that I've been given, I have two different versions of new amendments, but nothing really highlights what the changes are. So to Ms. Damoff, are the two that you've been sent to us, can you just tell us which one we're dealing with and specifically to the change?
Do you have NDP 1 in front of you, John? So if you look at NDP 1, the paragraph that begins protection order,
yeah.
Delete that whole paragraph. Replace that paragraph with protection order has the meaning assigned by regulations or ordonnance de protection, but is intended to include any binding order made by a court or other competent authority in the interest of the safety or security of a person. This includes, but is not limited to, orders that prohibit a person from, and then the remainder of NDP 1 does not change.
Okay, so the two that were emailed with exactly the same.
No, that's exactly.
Were you next, Mr. Calkin?
ask some questions on this. Thank you for the clarification on what it is exactly the change is. Could the officials tell us with the proposed change that's happening right now, everybody understands what a court is. What would be the list of, other than a court, of the other competent authorities?
Yeah, thank you for the question. Unfortunately, I can't provide a comprehensive list, but I can indicate that there are various forms of provincial legislation that include protection orders of various sorts. Those can include conditions that you not possess a firearm, or any of, let's say, the conditions that are listed here. Those particular provincial statutes will set out who the issuing body is. So,
could you give me an example of something other than a court that could do this?
I can give you, it's a pretty obscure example, but it's from New Brunswick. They have, if I get the title right, it's called the Intimate Partner Violence Protection Act. They call them emergency protection orders. And the issuing body is a member of the provincial civil service. It's an administrative decision maker. So, and
are there any examples where this competent authority could be in place without a statute, either federally or provincially?
That's difficult to answer. In terms of the word competent authority, I can indicate that it's used severally throughout the criminal code in reference to bodies that issue orders that are not specifically courts. So it is a common term. It's a term that's been used.
I'm not worried if it's a court or not. I'm just worried that is it like I don't know the answer to the question I'm asking. I'm just simply I want to know that anything that's deemed a competent authority would be a competent authority under a provincial or federal statute. How could a competent authority exist without statute is my question. But is it possible? Does it exist in common law? Does it exist in religious type of law? Or does a competent authority actually have to be in statute?
So I think what I would go is point to the first sentence where we say has the meaning assigned in regulations, and that would give the government time to develop the regulations, also propose the regulations, consult, and exactly define what types of competent authorities and what types of orders. What that second clause would do is sort of signify the intent of the legislature to say what kinds of orders and protection orders are captured by the regulations. The intent when this was proposed was not to capture every single type of protection order, but those that were for the protection of victims of intimate partner violence, gender-based violence. And so by relying on that, defining in regulations, and the fact that it's going to have the meaning set in regulations.
Yeah, but a regulation can't exist without a statute. So I guess the answer to my question is there shouldn't be a competent authority anywhere that doesn't have the authority by regulation via statute or via the statute itself. But I'm thinking of there are other types of without getting into detail, there are other types of ways that we deal with justice and other types of issues in Canada. And I'm just wondering, those would not be considered competent authorities. It would have to be by statute. I'm getting the sense that, yes, it would have to be by statute and thereby regulation.
So, I think that's outside of my personal scope of expertise, but I think I would rely on the fact that as the government were to develop regulations, that, those questions would be answered, and then, what does that mean in terms of competent authority would be sorted out.
Thank you, Mr. Cochran. On y va maintenant, Madame Michaud.
Ms. Michaud, you have the floor. Thank you, Chair. In the French version, where you say or another competent authority, I wonder why maybe we should say tout autre, like any other. I don't know if that change in French will change the meaning. My colleague was asking me a question at the same time, so could you please repeat? No problem. When you say rendered by a court or any other competent authority, so instead of saying any other competent authority, we say something like tout autre, in English is really the same, but the wording is different in French.
La question est...
It's about adding the word toute in French. Instead of une autre, we say toute. So not another, but instead of using another competent authority, we say any other competent authority. So we're talking about all competent authorities. I think that should be okay. It doesn't necessarily change anything, right? Yes. At the very end of the paragraph, we say à une personne de. I think that de is not necessary. So there's an issue with the word de in French.
Make an amendment? No, we're good? Okay. Is there any other discussion on this amendment? Désolé, monsieur. Anyway. Seeing none, the clerk would like to read it back for the committee before we vote on it. So please go ahead, sir.
Thank you, Mr. Chair. I just made a few changes that Ms. Damov is aware of. So the amendment would read in English, protection order has the meaning assigned by the regulations. I remove the semicolon and ordonnance de protection because it's already at the end, but is intended to include any binding order made by the courts or other competent authorities in the interest of the safety or, instead of safety or security of a person, and the rest stays the same. So I changed the of for or, because it was misspelled there, and I just removed the reference to ordonnance de protection because it's already at the end, the reference to the French version. And I did the same in French, so it would read as follows: ordonnance de protection.
Protection order within the meaning of the regulations, and I removed protection order includes any binding order made by the court or any other competent authority in the interest of someone's safety, and that includes without limiting oneself to orders that are referring to a person, and I removed the de in French.
You can take that as the definitive version. Is there any further discussion? Seeing none, we'll call the vote. All in favor? All in favor? All opposed? Carried. Okay, so that wraps up NDP 1 and its amendments. Do we need to reapprove the motion as amended? No? Okay. All right. Let us redo the vote on NDP 1 as amended by Ms. Damov. A recorded vote on that? Absolutely. Is there any discussion? No? Would the clerks please conduct a vote?
Ms. Damov? Yes. Mr. Chang?
Yes.
Mr. Gair?
Yes.
Mr. Noor Mohammed?
Yes.
Mr. Adag?
Yes.
Mr. Kalkin?
No.
Mr. Ruff?
No.
Monsieur Godin?
No.
Mr. Stanley?
No.
Madame Michaud?
En faveur.
Mr. Julian?
Oui, yes.
4 against, 7-4.
Thank you. So NDP 1 as amended carries. Do we have to readopt the clause that it pertains to? Which clause was that? 15. Clause 15?
15, as amended.
Okay. Is it the will of the committee to adopt clause 15 as amended? All in favor, please recorded vote, please. If the clerks would
Ms. Damoff? Yes. Mr. Chiang?
Yes.
Mr. Gaye?
Yes.
Mr. Noor Mohamed?
Yes.
Mr. Haddad?
Yes.
Mr. Calkin?
No.
Mr. Ruff?
No.
Mr. Godin?
No.
Mr. Stanley?
No.
Madame Michaud?
En faveur.
Mr. Julian?
Oui, yes.
4 against, 7 in favor.
Thank you. So clause 15, as amended, does carry. Okay, so I'm going to give the floor now to Mr. Ruff, who I believe will be asking for unanimous consent to take a look at his amendment, which pertains to clause 18, I believe. So, Mr. Ruff, if you would please.
Thanks, Mr. Chair. Before I do that, though, I should have maybe done this as a point of order. I just think, in recognition of the tragedy that happened this morning, and especially considering this committee, we should just take a moment to recognize Sergeant Eric Mueller and his family and the whole law enforcement community for what they do on a daily basis to keep our community safe. My personal thanks to Mr. Chiang for his many years of service as a law enforcement officer. And if I just, it's terrible news when somebody makes a supreme sacrifice for our country and our community. So I just would ask the indulgence of the committee just to take a quick moment of silence, Chair.
Absolutely. Is that the will of the committee? So 1 minute of silence, please. And thank you, Mr. Ruff, for bringing that forward.
Thank you, Chair. So yes, Chair, I'd like to seek the committee's unanimous consent for me to be able to go back and move an amendment tied to Clause 18 now that we discussed at length last night, but I think we had the agreement that wasn't in the appropriate spot.
Unanimous consent of the committee? Agreed. Very well. Carry on.
Thanks so much, Chair, and thanks so much to the committee members. So I'd like to move that Bill C-21 and Clause 18 be amended by replacing line 1 on page 17 with the following. Everybody should have a hard copy, and it's basically the change now is going to happen in 1801, but in paragraph 19(1)B of the Act is amended by adding the following after subparagraph 3.1, wishes to transport the firearm to another individual or business who holds a license authorizing that individual or business to possess prohibited firearms or restricted firearms for purposes of storage for the time necessary for the individual to address a mental illness or similar problem. And so that's the really, and then there's subsection 19.2.1 of the Act is replaced by at the bottom of that. So as I discussed last night for those committee members that were here, really the purpose of this is to provide that clarity to the firearms community that they can understand that if they're dealing with a mental health challenge, especially for veterans dealing with PTSD and others, that it's an ability to seek, have their firearm temporarily stored with another licensed, appropriate licensed individual, and so that obviously they know that this is an option available to them, and that's clear to them, so that they can seek the help they do, so that they don't sort of turn away from seeking the necessary help. And as well, it provides initial clarity to our chief firearms officers across the country to know that this is a venue. And from my discussions with the officials, it would, especially within the firearms program, it would likely help them in a prioritization standpoint to address these types of requests when they come in. I'll leave my comments for now at that, Chair.
Thank you, Mr. Ruff. We go to Mr. Moff, followed by Mr. Julian, and then Madame Michaud.
Thank you, Chair. And I have to say it's a pleasure having you here at the committee, Mr. Ruff, and I want to thank you for bringing this forward. I do have some questions for officials, if they could clarify for me from a practical perspective how this will work and how that person gets their firearm back, because there's no requirement for if they have a mental illness. I'm assuming that individual determines on their own when they're competent to retrieve their firearm. But could you just go through the process of how this would work?
The individual would apply to the Chief Firearms Officer for the authorization to transport for temporary storage for the purposes as Mr. Ruff denoted. And the CFO would provide the time period that this firearm would not be in the possession of the individual who was originally in possession of it. The CFO would determine when the firearm would need to be removed from the temporary storage through the issuance of another ATT to remove it from temporary storage back to the individual who had the firearm registered, the handgun registered. And at that point, the CFO would make a determination regarding that individual if they still had the eligibility to hold that type of firearm.
So the amendment says that it would be stored for the time necessary for the individual to address a mental illness or similar problem. The individual's not disclosing that to the Chief Firearms Officer. Is that correct? They're just saying that I want to store the firearm. And then I guess the worry I've always had with this, and it's not that I'm not going to support it, but you have someone making their own self-determinations on when they should have a firearm in their possession. And one of the things we've talked about at length is the risk of someone who has depression or PTSD. The whole reason Mr. Ruff has brought this forward is so that they will seek help. But my concern around this is that you're self-determining when you have a mental illness and when you are healthy enough to get that firearm back. Am I correct in interpreting that?
My understanding of this amendment is they would self-declare, so that would trigger an eligibility process for sure. So a CFO would review the situation when the individual requested the firearms back.
But this amendment, they don't have to self-declare. Is that right, or they do?
Yeah, we would actually add it to one of the forms.
Okay, all right. So the form that you were talking about yesterday, where it's not listed, it would now be one of the options that they would choose, and so they would tick that off. So the Chief Firearms Officer would be looking for some kind of competence to return that firearm to the person, right? To take it out of storage?
Of course, we haven't operationalized it yet, but I'm envisioning that is probably what would happen, because it would be part of that form, so it would trigger that eligibility process and a review. I mean, the individual, the CFO could request that the individual seek a medical form to obtain the ATT to bring it back, the authorization to transport back to their residence. It's a little different than the ones right now because it's usually a set time. So I'm assuming that given that they check off that it's for an illness, that the end date would not be determined upfront.
Thank you, Mr. Moff. We go to Mr. Julian, followed by Madame Michaud. And Mr. Nur Mohammed will have maybe 25 seconds left at the end. So, Mr. Julian, go ahead.
Thanks, Mr. Chair. And Ms. Damoff asked a number of my questions. So it is possible, following this, that there could be a requirement to have a note from a medical doctor? But that's something that would be contemplated.
So currently through a CFO, they do eligibility processes all the time. And I think given the circumstances of this, it would trigger an eligibility review. And depending on the circumstances, they most certainly, I would think in most cases, request or seek some input from their physician.
Okay. They being the authority?
Yes.
Okay. But that would be something that would be part of the regs later on, or part of the application process?
It's part of our eligibility process now. It's a continuous eligibility process, so if something comes up throughout a license holder's 5 years, it always triggers an eligibility process. So a chief firearms officer will evaluate that information that's coming in, and sometimes it's, it could be an interview with the person. It could be going back to the individual and asking for seeking for the medical physician to answer some questions. It could be a number of things.
Okay. Thank you. Thanks for answering those questions. I'll be supporting this amendment.
Thank you, Mr. Julian. Madame Michaud, allez-y, s'il vous plaît.
Merci, Monsieur le Président.
Thank you, Chair. Most of my questions have been answered. We talked a lot about self-declaration, but the way I understand it, when I spoke with Mr. Ruff in the background, is that some people hesitate asking for help because they're afraid they may be reported, given that if you talk about your personal problems with a physician or a psychologist, they may alert the authorities. Is that one way to understand it? Because I think it's interesting. If the individual has made the self-declaration that he has a firearm and discussed this with their physician, they can say that I've removed the firearm. If the physician verifies with the authorities, he would realize that the firearms have been removed proactively. Thank you. I just wanted to understand what we mean by a problem similar to mental illness. I believe we are talking about PTSD, depression, or something like that. I feel it's too broad, or does not necessarily cause a problem because it's obvious the way it's written. I don't know if my question is clear. I think we are referring here to someone who, for the most common reasons now, we're talking about mental health, but maybe there may be other situations. Somebody during the self-declaration says there's a reason for which I should not have firearms at my home, and proactively for my safety and for the safety of all others around me, I would like to have that firearm removed from my place temporarily. Thank you very much. Thank you, Ruff, for educating me about this problem, and I'll be voting in favor of it. Thank you, Chair.
Merci.
Thank you.
Mr. Nur Mohammed, you have 25 seconds.
I'll speak quickly. I am really pleased that Mr. Ruff brought this forward. I've talked to him before, and I know that he was very keen to make this happen. It's a great amendment, and I look forward to supporting it. My only question really to officials is around, is there any concern about uneven application across the country from the CFOs in respect of the return of the prospective firearms, and how would we mitigate any risk there? Other than that, I think this is a really excellent amendment, and I look forward to supporting it.
consistent application is always a concern, but we would clearly define. We would clearly define standard operating procedures for everyone of how we envision it to operate.
Thank you, Mr. Nur Mohammed. We have Mr. Ruff again. You have 2 minutes and 52 seconds to go.
I'll be a lot shorter than that, Chair. Look, I just want to thank everybody for what I anticipate is unanimous support. This is important. I mean, I can talk offline, really some more of the rationale why I wanted to do this, because this is all about keeping, keeping Canada safer and at the same time reassuring our firearms community. And my final comments, I'd just like to personally thank the permanent members of my party on this committee for allowing me the opportunity to partake. Firearms and this bill means a lot to rural Canadians. I mean, it means a lot to all Canadians, but my point is they want to be here, and allowing us to be here and speak up for our constituents means so much. It means so much to my constituents, because I don't think there's a single issue I've in my 3 years of being elected that I've got more correspondence or feedback on. So the opportunity to participate in this debate is just greatly appreciated. My personal thanks to the permanent members of this committee that allowed me to be here tonight. Thanks, Chair.
Thank you, Mr. Ruff. Is there any further discussion on this amendment? Seeing none, all in favor? Opposed? That seems fairly unanimous. Thank you, Mr. Ruff, and congratulations. Now, I think we have to adopt Clause 18. Shall Clause 18 as amended carry? All in favor? Oui, absolument. Thank you. And once again, congratulations, Mr. Ruff. Okay. At long last, although I think food is arriving, we can proceed to forward. So we have, we go to now to new clause 30.1. Block number 10 is the first, is the next amendment. So I propose that we hopefully we'll get through this and then we can break for lunch. That's a good deal. Madame Michaud, s'il vous plaît, BQ 10.
Oui, merci. Thank you, Chair. It's simple. For colleagues who are just joining us, we unanimously adopted yesterday several amendments that require a valid permit for the magazine. So it's just for consistency purposes that I feel left. I could read it for the benefit of colleagues, but this is just for us to be consistent with the rest of the bill. Paragraph 64, 1.2 of the same law is followed by the following 1.2. The holder of the permit whose validity is extended as in paragraph 1.1 cannot before renewal use the firearm or acquire firearms, ammunition, and magazines. So everyone should be aware of this amendment for consistency purposes.
Merci. Is there any discussion?
Thank you.
Mr. Calkins?
Thank you, Chair. I find this addition, this amendment, absolutely frustrating and infuriating. As a hunter, I sometimes wait 8 to 10 years for the privilege of being able to pursue a hunt in my home province, and I would be outraged if through no fault of my own, the Government of Canada did not renew my possession acquisition license on time, and I drove 200 or 300 miles to a hunt that I pay $5, $10, $15, or $20,000 for, to find out that my magazine is faulty, and I cannot go to the store and purchase a replacement one because of a clause like this. This is the governing body that determines when an applicant gets their license renewed is the one that bears the responsibility. The reason the extension of 6 months was added on was because governments typically some can't meet the obligation of getting a license, a firearms license renewal processed in a timely fashion, even according to what the Firearms Center says it has on its website. I deal with this in my office constantly. The number of people in this country that follow the guidelines on the website, do a renewal, and do not get their licenses returned in time are now going to be, this is punitive, absolutely punitive to somebody who acts in good faith, not only in the acquisition of their license, but in the acquisition of their hunting permits, the application for, or the purchase that they have of a hunt. And so I'm asking the officials, if this clause becomes law, what we're in essence saying is unless you have to wait, doesn't matter, the hunt will not wait for you, the season in the province or territory that you're hunting in will not wait for you. You might even have only a week of a season. As a matter of fact, in January of this year, I had a 3-day elk hunt that I waited 10 years for. 10 years I waited for that opportunity. And if I would have lost the magazine for my Savage rifle, if this clause was law and I was by myself, I would not be allowed to go to the store because my pal was in the 6-month grace period. I would not be able to go to the store and get a replacement cartridge or magazine. Is that correct?
In the circumstances that you describe, yes, you wouldn't be able to purchase a magazine.
So,
I'd just like to point out that you wouldn't be able to use the firearm either.
Well, this
and
is
that's
part,
already in the Firearms
I
Act?
understand. I understand the notion, and I understand that she's making it consistent. But what I want to do is, I want to make it clear to every hunter who is being told right now by members of other political parties that these laws are not going after you as a hunter. Make it explicitly clear to you as a hunter that you will potentially be denied your hunt because you cannot use your gun, you cannot buy replacement ammunition, and you cannot buy a replacement cartridge or any part thereof of a firearm, even though through no fault of the hunter.
Mr. Nur Mohammed on a point of order.
Yeah, I wasn't Mr. Calkins said it will and it would or it will, and then they said potentially. I just want if you could in his statement, if you could just clarify what he is. Does he mean it will or if it potentially will? Because there's a difference there.
Thank you. I think that's debate, but if Mr. Calkins wants to clarify,
I just want to put on the record, and I am being crystal clear. If I'm not allowed because I've applied for my renewal of my PAL, it doesn't get processed in a timely fashion, I will be denied a hunting season, even if I have paid upwards of thousands of dollars for a hunt that I cannot get refunded. And I think it's incumbent upon the MPs that are here at this table to understand the consequences of not only this decision, but the decisions that have already been made earlier on by denying somebody who, through no fault of their own, is now going to be denied perhaps a once-in-a-lifetime opportunity. In some parts of this country, people wait their entire life to get an opportunity for one specific hunt. As a matter of fact, in BC, your opportunity to get a Roosevelt elk draw, you may never get one in your entire lifetime. And if you were to get one, this particular clause is punitive, absolutely punitive to the hunting community. And I'll cede my time, Mr. Chair.
We go now to Mr. Moff.
Thank you, Chair. If the officials could just clarify, this is just adding we made an amendment last night to add the requirement to have a license for a magazine. This is just updating a coordinating amendment to ensure that it's in compliance with the decision we made last night. Is that correct?
Yes.
So I just want to remind the Conservative members, and in particular Mr. Calkins, that the vote on in requiring a license for a magazine was passed unanimously last night, including by Conservative members. And I would like Mr. Calkins to go and look Reese Fallon's family in the face and tell her that the elk hunt is more important than her life. Because the shooter on the Danforth did not require a license to go and buy a magazine before he went and tried to slaughter people on the Danforth. So I'm sorry that Mr. Culkin doesn't like this amendment, but you know what? Conservatives voted.
Holder waiting for a renewal of their license.
Crosstalk, please.
I have the floor, Mr. Calkins. I have the floor. You're complaining about not being able to do something and waiting for 10 years. Reese Fallon will never see. She'll never be able to get married. She'll never be able to have children. And you're complaining about not killing an elk? I'm sorry, Mr. Calkins. I find that so offensive. I was very proud of members last night on this committee that we unanimously passed the amendment that Ms. Michaud brought forward to require a license for magazines. All this is doing is changing something that's already in the law to add magazines to it, and I would hope that members would support that. I'm sorry, Chair.
Madame Michaud, allez-y.
Merci, Monsieur.
Thank you, Chair. Let me recall that all Conservative MPs who were present yesterday during the first amendment on magazines and subsequent amendments were voted on unanimously. No need to cause hunters to be afraid. As our colleague said, they will not be able to use the firearm to hunt in any case. At some point, it's not our fault. The government is there to renew licenses. If the person applies at the last minute, well, it's unfortunate that he doesn't listen to the answers that are given to these questions. So I'm calling on him to vote in favor of the amendment. That's all I have to say. Yeah.
We have Mr. Steinley, followed by Mr. Julian.
Yeah, we'll turn down the political rhetoric a little bit here. And I just have a couple anecdotes from over the last couple of years. And my question would be, I wasn't here last night, obviously, so is the grace period shortened up for just on the...
Sorry, no.
And what exactly, how long is that grace period still?
It's still 6 months.
6 months. A couple of anecdotes over the last couple of years, and it happened to my neighbor, who is a very avid hunter, and he is very law-abiding, except he's had his guns and magazines and shells in his gun safe for the last 3 years because throughout COVID, he has not been able to get his renewal of his RPAL or his PAL through no fault of his own. And actually, at one point in time, they said, because people weren't getting the mail through Canada Post, is he had to send in his application twice now. And obviously that grace period was gone, so he missed 2 years of hunting through no fault of his own. So sometimes there are extenuating circumstances where law-abiding...
I'm sorry, Mr. Steinley, your time's up.
Oh.
Are there any further comments on Mr. Julian? Go ahead.
Yeah, I'm a little confused by the Conservatives on this. They voted for similar amendments yesterday, and so I'm confused that when they understood the sense of the amendments yesterday, that today those same amendments provoke a completely different reaction. I must say I've been somewhat dismayed by the intent of some Conservative members in the House to try to present the bill as still having the amendments that we forced the withdrawal of months ago. And Conservatives tried to take credit for it, but now they seem to be, at least in the House, were indicating that the amendments were still there. And I think that misinformation is not helpful at all. In this sense, I don't understand why they would vote for amendments, similar amendments yesterday, and now say today that this is that these are problems. It doesn't seem to be consistent at all. And I do recognize that this government is slow in a whole range of areas, including on renewal of licenses. That is true, and we've seen it in a number of different areas. I had similar concerns with the Harper government that was so slow in a whole range of other areas. And so that is an administrative issue that I think does need to be followed up on. But it's different from considering the bill and considering the amendments that are before us now.
Thank you, Mr. Julian. We go now to Mr. Nur Mohammed. You have 3 minutes and 19 seconds this time.
Thank you, Mr. Chair. And I won't need all that time. I guess I'm just, like Mr. Julian, I'm a bit perplexed. You know, we sat through a unanimous vote on effectively the very, very same amendment yesterday. And I just would love to understand why all of a sudden there seems to be an opposition to voting for something that everyone on this committee unanimously approved yesterday. I mean, this seems to be a fairly straightforward process, and I would love to actually understand sincerely. This is not a question asked out of malice. I would love to understand from my conservative friends why they were so willing to unanimously support something yesterday, but today are prepared to speak with such force and energy against the very same thing.
Thank you, Mr. Nur Mohammed. Is there any further discussion on this amendment? Sorry. Seeing no further discussion, I will call a vote. All in favor of this amendment, please raise your hands. Absolutely. Mr. May Clerk, if we can get a recorded division, please.
So, my apologies for the delay. Ms. Damov?
Yes.
Mr. Chiang?
Yes.
Mr. Miao?
Yes.
Mr. Nur Mohammed?
Yes.
Mr. Aldag?
Yes.
Mr. Shipley?
No.
Mr. Stinley?
No.
Mr. Perkins?
No.
Mr. Tokor?
No.
Madame Michaud?
En faveur.
Mr. Julian?
Oui. Yes.
7 in favor, 4 against.
Thank you. Congratulations. And so that is new clause 30.1. I suggest we break at this point for dinner. I think it's, are we ready for dinner there? Yep. But before we do so, I note that we stood clause 26 yesterday. I believe it was because of translation concerns. I'm not quite sure why. I'm going to ask during the break if we can figure out whether we can go ahead with that at this point. Anyway, let's take a break, 15 minutes for dinner. Suspended. Hey, everybody. Can we get going again? My 15-minute breaks seem to be 25 minutes, but... All right, I call this meeting back to order. So last night we stood clause 26 because Madame Michaud needed some point of order. Mr. Shipley.
Thank you, Chair. And I know I just got here, so I'm not trying to jump in. I did an intervention earlier tonight, and I wanted to apologize to my colleagues, the officials, but especially the interpreters, because I know they have a very tough job, and I didn't wear my headset. It was kind of a rush. I had a couple of people text me quickly and call me that Mr. Nur Mohammed was concerned about my whereabouts, so I didn't take the time to put on my headset, and I apologize for that. But I'm here now, and I would have apologized to him, but he's not here in person, so that's unfortunate. But I just wanted to especially apologize to the interpreters.
But he's right here, Mr. Shipley. He's right here.
Thank you.
Thank you. Okay. So, if Madame Michaud, if you're ready, we can go back to clause 26 and clear that up. And that would start with BQ 8.1 in my notes.
Oui, merci, Monsieur le Président.
Thank you, Mr. Chairman. Thank you to my colleagues for having suspended this clause yesterday because there were talks behind the scenes. We weren't sure whether this amendment was in order, properly speaking. I'll explain the intent of this amendment. We had this discussion on a number of occasions when the officials were with us. What happens when a firearm ends up on the Canadian market? Is it checked by the RCMP first, or is this done once the RCMP notices that it's already on the market and has to be classified differently? And Ms. Paquette told me that that's the case for unrestricted weapons. When they arrive on the market, there's not necessarily a process for it to go through the RCMP first. So we were wondering, in order to avoid having new weapons circumvent the new definition, this would be an additional safeguard. There'd be pre-authorization by the RCMP before the weapon ends up on the market. So given our discussion and our intention, this is how we drafted the amendment. I understand that maybe it doesn't cover the initial intent. That's why I want the official's opinion on this. I will read it, that Bill C-21 in Clause 26 be added by adding after line 26 on page 19 the following. A person may transfer or import a firearm only if it bears a Royal Canadian Mounted Police identification number. If the officials could explain what their interpretation of this amendment is, what the impact would be, and whether the intent I had really is achieved in this case. Thank you. So thank you for the question. It's not clear what identification number we're talking about because there's no definition of an RCMP identification number. So I think the intent, if I understand correctly, is about the identification number of the make and model. Ooh, don't pour water on it. It's the table of reference of firearms. The reason I'm laughing is because I'm known for spilling things all over the place, so that's why I always have a cover on my cups. So in this case, if this is adopted in its current wording, would it create a problem in the enforcement of the law? Well, it wouldn't be clear what identification number we're talking about. There'd be a lack of clarity. I'd also say that the government had intended last week that it would proceed with regulatory changes to require the identification, a reference number,
in the firearms table. Thank you. We also looked at whether there was some other way to include this amendment somewhere else in the bill, amend another clause. And that's be among the amendments I'll table later about chargers. Since there had been great unanimity yesterday about the chargers, I didn't want to risk voting against those amendments if I included this intention. So with your agreement, I don't know whether I need unanimous agreement, Mr. Chairman, but I would withdraw this amendment and remind us all that the minister made a commitment to establishing regulations under the Firearms Act to make sure that they are properly classified before they enter the Canadian market by requiring a valid number from the firearms registry. That would mean that they're classified properly, and the government would be aware of the presence of a new make and model before it enters the Canadian market. So that was the intent. I wanted to do this in a legislative manner. I understand it might be easier to do through regulation. So I count on the minister to fulfill that promise. If it's okay, I would like to withdraw this amendment.
You actually moved it, so I think you could withdraw it.
Alors, je la retire.
Okay, so I withdraw it. Thank you.
Okay. Mr. Julian would like to speak.
Mais pour dire la même chose.
I just want to say the same thing. Indeed, the minister must commit to closing those loopholes. I think there's consensus about that. Those loopholes shouldn't exist in a normal system.
There was just, I think, an issue on translation, because when Ms. Michaud was talking, the translation came through as a couple times we had unanimous consent on chargers yesterday. I'm not sure exactly what that meant. So could we just get some clarification if there was an error on...
Un chargeur en français, c'est chargeur.
A chargeur in French is a cartridge magazine. In French, it's called a charger.
Okay, it was coming through, thank you, as charger.
Okay.
So it's meant cartridge.
Okay.
Thank you.
Mr. Julian, on the same point of order?
Juste pour dire qu'on a des...
I just wanted to say that we would have assurances from the minister that this will be part of the regulatory framework. That's very important. I think the committee's message was very clear on that.
Thank you. I don't think we can't commit the minister in such a way, but we can certainly carry the message back. I'm sure Madame Ms. Demoff will...
Can I just respond to that?
Sure, on the point of order.
Oh, just very, very briefly, Chair. Madame Michaud very kindly read what was said, and I certainly will give commitment on behalf, I can't speak on behalf of the minister, but I will certainly speak on behalf of our side of the table and reiterate what the minister said. And absolutely, we will be doing regulations on the exact issue that Madame Michaud has put forward. So it's in the record, and it is absolutely something we're committed to doing.
Okay. Fairly loose process here. We're going to... it'll get tighter later, but anyway, so on y va maintenant.
Now we'll go to BQ9. Thank you, Mr. Chairman. BQ9 is an amendment for concordance on cartridges. I won't repeat what I just said, but I do want to say it to some extent because I was surprised that a Conservative colleague was offended by an amendment for concordance about cartridges, whereas they voted on all amendments about that and all concordance amendments. So I hope that colleagues will be consistent with their votes from yesterday. So it amends Clause 26 so that it's consistent in the Act, that you need a valid permit to acquire these cartridges. just like you do for a firearm. So I hope that colleagues will vote in favor. Thank you.
Seeing none, all in favor? Opposed? I didn't see anybody on the line. I think we went too fast. All in favor of block 9? Mr. Miao and Mr. Nur Mohammed, are you? Okay, yeah, there you go. All right, carried. Thank you. That takes us to G43 now. In the name of Mr. Nur Mohammed. Mr. Nur Mohammed, would you like to carry on? T-shirt man, I swear. You're on mute. Try unplugging your headset and plugging it back in. Magic. It's like IT 101. Reboot, unplug it, plug it back in. Mr. Nur Mohammed, if you don't mind, I'll get Ms. Demoff to move it for you. Go ahead.
Thanks, Chair. This is just another, let me just check my handy list, and indeed it is another firearm part coordinating amendment to continue the good work that we were doing last night to make sure that all parts of what we're doing in Bill C-21 are complying with other acts. So this is to do with ghost guns, and let's vote yes.
Okay. Is there any discussion on this amendment? Mr. Shipley, go ahead.
Thank you. We have talked about ghost guns a lot, and I'm just getting back up to speed tonight, Ms. Damoff. So maybe the officials could tell me what this amendment does in real life. How is this going to assist going forward?
Thank you very much for the question. So this motion would impose a requirement on individuals to have a valid firearms license to import a firearm part. And it specifies that an individual must, at the time of importation, have a valid firearms license, and it must be presented to a customs officer in order to import the firearm part, and the license must be shown to a customs officer. It creates a limited exemption to subsection 38(1) for non-residents of at least 18 years of age if they declare the firearm part to a customs officer in the prescribed form, so in the prescribed manner, and that's form and information. And a confirmed declaration would have the same effect as a valid license for the purpose of importing the firearm part. And I will remind that firearm part was defined in earlier motion, can't remember what day now, as a barrel or a handgun slide.
So it's only, this amendment only pertains to bringing it across the border then, is that correct, bringing it in?
Yes.
So would you be able to give me an example of how this amendment would function in real life?
Sure. So, for example, somebody is going to the United States, and when they're in the United States, they go and buy a handgun barrel as a part. You know, for example, they have maybe a specialized firearm and they need a barrel. So as they come across the border, they would declare and say, I am bringing in a handgun barrel. In the same way that if you bring firearms into Canada, you must declare them upon entry into Canada. You would show that you have a valid PAL, your license, and the customs officer would note it, and you would enter.
You got to get on the list or he'll jump you.
Are you finished? Mr. Perkins, go ahead.
Just further on Mr. Shipley's question. So it's only when you physically go across the border? Is it also, what if you're ordering online or mail? Could you describe how that works?
So the same would apply in terms of if you apply by mail, when you go to pick it up, anything that you require a permit for. Let's say you were ordering a firearm online, and when you were to go and pick it up, you would have to show your firearms license. You would have to confirm that you have a valid firearms license in order to pick up your firearm. Same way.
And are the courier companies where you would pick this up trained to ask that? And do you do any spot audits to see of compliance? I know in the retail business, I was in the retail business for many years. We do what's called mystery shopping against standards. Do you do that in this case in order to ensure compliance?
So this would be up for our colleagues at the Canadian Border Services Agency to apply, and they would apply the same process as they do for importation of firearms in terms of verifying that people have a valid license, and it would extend to firearm parts that are defined as barrels and handgun slides.
So, but you haven't seen any reports in the past of to show its effectiveness from this type of thing, or that we are or aren't complying when they come in now?
So I can't comment on the questions of compliance or non-compliance with the CBSA. I can tell you how it would be applied generally, and it would be the same process as for those for firearms.
Thank you.
Mr. Tucker, you have 1 minute.
Thank you very much. Thank you to our fellow members here. I've been watching online, and this is my first time availability to make it down to the committee. On this clause that talks about the border, and that's seemingly a big focus of trying to stop illegal firearms and parts. Would this stop any illegal activity at the border?
So with regards to trafficking of firearms and measures that are included in the bill, I will refer to materials that are available online with regards to measures that are going to strengthen with regards to trafficking. However, this specific motion has to do with addressing the certain firearms parts that go into the manufacturing of illegal firearms or ghost guns. In terms of these are the parts that people don't necessarily make with a 3D printer. They will go and buy these parts and trying to prevent their entry into Canada.
Thank you, Mr. Tucker. Any further discussion on this amendment? Seeing none, I will call a vote. All in favor? Pardon me? A recorded vote? Yes, please go ahead.
Ms. Damoff.
Yes.
Mr. Chan.
Yes.
Mr. Gaye.
Yes.
Mr. Noor Mohammed.
I see a thumbs up, yes.
Mr. Aldag.
Yes.
Mr. Shipley.
Yes.
Ms. Block.
Yes.
Mr. Perkins.
Yes.
Mr. Tucker.
Yes.
Madame Michaud.
En faveur.
Mr. Julian.
Oui, yes.
All in favor, Mr. Chair.
Thank you. So G43 therefore carries. Okay, so that means okay, so it's clause 26 as amended. Shall clause 26 as amended carry? I'm sorry? On division? We're good? I'm sorry, you want to record a division? Okay, we'll have to do a record division. I heard both, but I think recorded division is more stringent.
Ms. Damoff.
Yes.
Mr. Chang.
Yes.
Mr. Gaye.
Yes.
Mr. Noor Mohammed. Mr. Aldag.
Yes.
Mr. Shipley.
Yes.
Ms. Block. Ms. Block.
Yes.
Mr. Perkins?
Yes.
Mr. Tucker?
Yes.
Madame Michaud?
En faveur.
Mr. Julian?
Hello?
Oui, yes.
All in favor, Mr. Chair.
Thank you. Clause 26 as amended carries. Okay, so we are now back to clause 31. So we have clause 31, clause 32, and clause 33. Is it, do we have no amendments for any of these, I believe? Is it the will of the committee to adopt all these three in one, at one time? No? Okay, so shall clause 31 carry? All in favor? I'm sorry? If you need to talk about, okay,
sure.
sorry, I was getting in a hurry. So,
You were trying to get us
Mr.
through
Shipley,
this.
go ahead.
So again, I just got to read some notes here. We're talking about clause 31, correct? Just because we went back, now we're going forward again.
We're talking about clause 31, yes.
So this is where we're making registration certificates expire when their owners cease to own the firearm or when the classification of that firearm is changed by an act of Parliament. Perhaps the officials could just explain what this clause does in real life.
Thank you for the question. So this creates a new paragraph, 66C, that would, third instance in which a registration certificate of a prohibited or a restricted firearm becomes expired when the classification of a restricted or the prohibited firearm changes as a result of, for example, an act of Parliament or a regulation that is made under such an act of Parliament.
So you say expired. That's the registration expired? Maybe is that what you mean?
The registration certificate, yes.
So how long does the original registration last for before it expires?
I will ask my colleagues at the CFP.
So it depends. But in this change, it is specifically to do with if something happens through Parliament that changes the classification of a firearm. Let's just, for example, to a prohibited firearm, that registration certificate would automatically expire.
Okay, and you mentioned if something happens through Parliament. Could you explain what you mean by that and how?
Oh.
Give me an example of that.
So an act of Parliament, so for example, if Parliament changes classifications of firearms that are, for example, restricted and make them prohibited, so if there were a change to the criminal code in terms of how you would define prohibited firearms, then automatically when that provision would come into effect, then the classification changes and automatically the certificate would be expired. The second instance is when there's a regulation that changes the classification of a firearm. In that case, then also it would automatically expire the registration certificate.
Thank you. I think my colleagues have something.
Thank you. So I know, having just spent a modest amount of time in the Finance Committee talking about ministerial accountability, that I'm sure everybody in Canada was watching my discourse. And I'm sure every firearm owner watches intently every comma that happens in a parliamentary change. So how would a legal firearm owner, when their Parliament changes the classification of their previously legal firearm, be actually notified that that they now own a firearm that is no longer lawful? And then secondly, what would then happen to that firearm?
So when it's a registered firearm, the registrar will notify the licensee of the change of classification of their firearm. Yes, and by email if we have the email. So we do dual.
And to my second part of the question, what would happen to the firearm then?
That depends in terms of what was put out in the change of that prohibition, or like, for example, if Parliament or the regulation prohibited the firearm, it depends on whether an amnesty period is given, and then the firearm owner would then have to comply with whatever conditions that had been made either by regulations or by Parliament, in the Act of Parliament.
You done? Mr. Tucker, you have 35 seconds.
Just quickly, how does this make Canadians safer?
I believe that's not a question they can answer. Our witnesses are here to give us interpretation of technical.
Okay, I'll rephrase this. So we have an individual that is unfortunately fallen on hard times, is turned to crime, and they're out on the land. They have their firearms, and this bill goes through. And how does it stop that individual at all, or it doesn't?
So, pardon me, your question is somebody. I'm sorry, I missed the first
So how does
part of
this? So a hypothetical situation where an individual has a firearm, it expires, but they're already down a path of criminal life. How does this actually? How would it stop them from carrying on with their firearm?
So the firearm was one that was already legally registered. It was, for example, a restricted firearm. The Parliament or a regulation under an Act of Parliament changed the classification to prohibited. And they were, I'm sorry, I don't.
They don't turn out. So the
I'm sorry,
it expires, but what do they do?
Mr. Tucker, I think we have to draw a line there.
We can add to our colleagues' comments if you like, that
if you do it quickly.
if a person is in possession of a firearm and it is prohibited, then the possession and use of that firearm would be prohibited. So unless there was an amnesty or other way that the government would allow these individuals to keep them.
So it doesn't keep them safer.
Thank you, Mr. Tucker. Is there any further comment on this amendment? Sorry, clause. Yes, clause. Thank you. Any further discussion on this clause? Seeing none, I will ask for the vote. Recorded division.
Ms. Damoff.
Yes.
Mr. Chiang.
Yes.
Mr. Gair.
Yes.
Mr. Noor Mohamed.
Yes.
Mr. Aldag.
Yes.
Mr. Shipley.
No.
Ms. Block.
No.
Mr. Perkins.
No.
Mr. Tucker.
No.
Madame Michaud.
En faveur.
Mr. Julian.
Oui. Yes.
7 in favor, 4 against.
Thank you. So clause 31 carries. We go now to clause 32. Is there any discussion on clause 32? Mr. Shipley.
Chair. So nice to be back in here again tonight, isn't it? I missed you guys. On 32, just to recap this. This allows the Commissioner of Firearms to renew an authorization to carry a prohibited firearm and outline exemptions to grandfathered December 1998 handguns. My first question is, because some people may not know this, what is a Commissioner of Firearms?
Hi there. Thank you for the question. The Commissioner of Firearms is a statutory office that's created under the Firearms Act, and that term is actually defined in the Act. So I'd refer the committee to Section 2 of the Firearms Act, where there's a fulsome explanation of, or at least definition of, what the Commissioner is.
Is there one in each province, or is one national?
There's one Commissioner of Firearms, and there are potentially many CFOs of jurisdiction. Pardon me, Chief Firearms Officer of jurisdiction.
Sorry, I still have.
Sorry. Mr. Shipley has the floor. Go ahead.
Thank you, and I applaud the keenness of my colleagues tonight. I just had another question, because in Ontario, and I think you caught that at the very end, I'm familiar with the chief firearms officer, but in this clause, we're talking about firearms commissioner or commissioner of
Point d'ordre,
firearms.
Monsieur le Président.
Point of order, Mr. Chairman. Ms. Michaud? I'm sorry. There's a Conservative colleague who put the exact same question to officials. I think it's slowing down our work to always put the same questions that are redundant. I understand that the Conservatives relay each other every 15 minutes, but we're here and we'd like things to proceed. It would be appreciated if we could move on.
Understand, I think that is a fair point of order. I mean, the standing orders certainly do discourage repetitive and sorts of things. Mr. Julian on a point of order, and then Mr. Perkins on the same point of order.
Just following on Mme Michaud's comments. I mean, the reality is there has been a tremendous amount of repetition from the Conservatives asking the same questions over and over. Now, it's true that the people change, but it's up to Conservatives to actually brief their incoming people to make sure that the work of this committee isn't sabotaged. And the fact that we had to start late because Conservatives insisted in having 4 identical votes in the House that took an hour of House time to delay this committee, I just find it disquieting that on an issue that is so important that there seems to be so many delaying tactics. As you recall, Mr. Chair, I asked numerous times for us to meet more often as a committee. Conservatives always refused that permission. They really need to be working hard on behalf of their constituents, and that means not being repetitive, coming well briefed, and having read the legislation as well, because we've had indications that there are members of the Conservatives that haven't even read the bill when they come forward to this committee. So I hope that'll stop and that they'll work cooperatively with everybody so that we have the best possible legislation moving forward.
Thank you, Mr. Julian. I would point out that the longer this kind of stuff takes, the longer we're here in the morning. Mr. Perkins on the same point of order.
Thank you, Mr. Chair. I'd say to MP Julian, the Deputy Liberal House Leader, that it is not anti-parliamentary to
Perkins,
hold votes in the House of
Perkins, we're not allowed to disparage people, and calling Mr. Julian Deputy Liberal House Leader is.
He did sign a supply arrangement.
Excuse me, the chair has the floor. So I urge you to maintain your discourse in a respectful manner. So carry on, if you will.
Sorry, I thought that was his official title. But I think when you go through clause by clause, to MP Michaud's point, when you go through clause by clause, members of Parliament have a right to ask the question about particular elements.
Yeah.
And it's not repetitive when you're asking about different clauses.
So
you may not like the fact that
I think we're in.
parliamentarians
I think
feel
we've gone
like
to debate
they
now.
need to ask questions about their
Point of order.
jobs.
Point
But
of order, Chair.
I'm sorry, that's
sorry,
not your
Mr.
role.
Perkins. We're going to debate. The point of order is closed. Mr. Tucker, do you have a new point of order, or is it the same point of order?
It's relative to it. So the officials had to pause and talk to themselves to figure out the proper answer to the question. So it can't be repetitory if the witnesses don't even know. And it refers to the act, and their answer was that it refers to the act, but in that clause, there's no reference to the act. And we have highlighted
Okay,
it is these
thank you. I think we have
commissioners from
enough
provinces.
information. I think we are getting into argument. No more. This point of order is over. I'm sorry? A new point of order for Mr. Shipley.
Thank you.
Go ahead.
Thank you, Chair. Just a couple quick things. First of all, many times in this committee, Chair, you have mentioned that you don't want us to go back and discuss things in the past. We need to keep working forward. You've said that to us many times. My friend down the end here just mentioned votes that took place earlier, and he was more than allowed to mention things that happened in the past. And I believe that Standing Order 18 prohibits reflecting on the decisions of the House. So
That is
how
correct.
that allowed?
It's a valid point, and I encourage us all to maintain a forward perspective on this, and thank you. And if that being the case, we're on Clause 32, and I believe Mr. Shipley was speaking on Clause 32.
And I hate to do this to Ms. Michaud, but I wasn't here earlier, and I agree there was some delay, so I have to answer. I need to know. I want to know what the difference is between the Commissioner of the Firearms and the Chief Provincial Firearms Officer for a province, and how they differentiate. That's where we left off last time. Thank you. officials, if you could just get into those details for me.
So if we refer to Section 2 of the Firearms Act, a chief firearms officer is defined, and the commissioner of means the commissioner of firearms appointed under Section 81.1, and currently the commissioner of firearms is the commissioner of the RCMP.
So that's the Commissioner of Firearms. How are the Chief Provincial Firearms appointed then provincially? Who appoints them? Or are they appointed? Are they appointed? You guys got anything here?
In accordance with Section 2 of the Firearms Act, a chief firearms officer is either designated by a provincial minister, and if the provincial minister chooses not to designate, the federal minister will designate a chief firearms officer.
Mr. Tucker, did you have your hand up?
Yeah, just a clarification on the commissioners and the order of appointments. And does the federal government fund all the offices in the same way then? Like each province, each commissioners, how is that funding determined? Because it's the minister that appoints the provincial, but who actually funds it? Is it both or just the federal?
So there's only one commissioner of firearms, but if you're referring to the chief firearms officers of each province, it depends on whether they're provincial or federally appointed, designated. And if they are provincially designated, there are contribution agreements that are drafted and signed off by the minister of the province and the federal minister, and it comes to an agreement on funding to administer the Firearms Act.
It refers to the December 1998 handgun. It cut off my version. This was when they transferred to restricted firearms, correct? Handguns? And we were supposed to...
Correct, that was through Bill C-68.
And that was to address rising crime rates with the handguns, I believe, right? So it was before I got
Was
here.
to create a licensing regime in the Firearms Act and to do some transfers of responsibility between the firearms program and criminal law policy section, policy sector.
But was that the creation of the restricted firearms? Or the RPEL?
In Bill C-68, I believe that was when the categories changed, and there was grandfathering at the time of the 12.6, I believe.
Thank you,
Because
Mr. Tucker.
Since 1998,
Mr. Tucker, your time's up. Madam, sorry, Ms. DeMoff, please. Oh, sorry. Okay, is there any further discussion on Clause 32? Your time's up. In that case, we'll call a vote on that. I assume we want to roll recorded division. Please go ahead.
Ms. Damoff.
Yes.
Mr. Chiang. Yes. Mr. Gahir.
Yes.
Mr. Noor Mohamed.
Oui.
Monsieur Chifquier.
Oui.
Ms. Block. Sorry, Mr.
Yes.
Yes. Mr. Shipley.
Yes.
Mr. Perkins.
Yes.
Mr. Tucker.
Yes.
Madame Michaud.
En faveur.
Mr. Julian.
Oui, yes.
All in favor.
Thank you. Clause 32 carries. Brings us to Clause 33. Is there discussion on Clause 33? I have Mr. Perkins followed by Mr. Shipley.
Thank you, Mr. Chair. On the previous clause, it was mentioned that the Commissioner of Firearms is the Commissioner of the RCMP. Is that correct?
Yes.
So at the testimony from the recently retired Commissioner of the RCMP before the Mass Casualty Commission in Nova Scotia, when asked about her knowledge as the Chief Commissioner for Firearms, at that said she didn't know the difference between prohibited and restricted firearms and that she hated to admit that. So my question is the current acting commissioner, I believe it's an acting commissioner of the RCMP, familiar with the difference between prohibited and restricted? And if you're don't know the difference between prohibited and restricted as commissioner of the RCMP, how do you carry out your duties?
Chair, this has nothing to do with Clause 33, and officials are not here to talk about the commissioner of the RCMP. We're talking about a bill that's before us.
I take your point. I believe it's a valid point on relevance, and I would urge the member to...
The relevance is this is giving specific powers
Please don't
to the
interrupt the
commissioner.
chair, please. I would urge the member to stick to the thing. I assume you're going to get to it at some early point.
The commissioner of the RCMP is given specific powers under this clause, additional powers. So in exercising those powers, I just want to understand if the commissioner, in exercising those powers, is required to actually know the differences between prohibited and restricted, since the previous one admitted she didn't.
All right, so thank you
Read
for
the testimony.
So thank you for the question. The motion, or the Clause 33, proposes a few changes. It proposes to replace the heading to add the words "and suspension," as well as require a CFO to refuse a license to individuals who are not eligible, and allows the CFOs, the Chief Firearms Officers, to refuse an authorization to carry or authorization to transport for sufficient reason.
Okay.
Thank you, Chair. I was just waiting for my light there. Could the officials indicate to me this clause states for any good and sufficient reason? Could you give some examples, concrete examples, what is a good or sufficient reason to clarify that, please?
Thank you for the question. So an example would be, there's many examples, but the one that comes to mind is if there's a suspicion of, sorry. 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 I'm sorry. So yellow flag, so one of the situations that comes to mind is if a CFO, something is flagged to the CFO that there might be straw purchasing involved, so multiple purchases of firearms. So to allow the time necessary to do an investigation, this is something that would be used to make sure that they have the time to stop any further purchases, but to allow for an investigation to be done.
And thank you for taking your time on that, because these answers are important, so we want to get it right the first time. You mentioned when something is flagged. Just the word "something" is a little vague. I'm sorry. Can you just explain to me what you mean by something is flagged?
Yeah, that's okay. So there's various forms of flags that come in. Someone could call, a meeting of business could call in this situation. It could be a flag from police. Maybe they got stopped. Maybe there was something in that description of that incident, the flag that they had multiple firearms. So it could come in from various forms.
Thank you. And the other thing you mentioned in that answer was multiple purchases. I wasn't clear on that. So someone can't purchase multiple at the same time or over a length of time, or when does that start to get flagged?
I'm just using
or notified, if that's
I'm
the
just
term.
using it as an example.
Yeah, no,
There's
that's
not a maximum today, but if a business, if I'm going into the business and I've gone there, I don't know, I go there every week for a month and I'm buying a couple of firearms, then that business may flag that. They may call the chief firearms officer and say, hey, like this person seems to be coming in a lot and buying more than I've seen. Or it could be an association of businesses and they've seen Kelly Piquet go to all these various stores. So that kind of information will drive something like this to trigger off an investigation.
So I think I'm going to have to cut you off there. Okay, good. Is there any further discussion on Clause 33? Seeing none, I'll ask the clerk to conduct the vote.
Ms. Damoff.
Yes.
Mr. Chiang.
Yes.
Mr. Gair.
Yes.
Mr. Noor Mohammed.
Yes.
Mr. Shifke.
Oui.
Mr. Shipley.
Yes.
Ms. Block.
Yes.
Mr. Perkins.
Yes.
Mr. Tucker.
Yes.
Madame Michaud.
En faveur.
Mr. Julian.
Oui, yes.
All in favor.
Thank you. Therefore, Clause 33 carries. This brings us to Clause 34. We start with CPC 19, and I would note that if CPC 19 is adopted, NDP 4 cannot be moved due to a line conflict. Mr. Julian.
Thank you, Mr. Chair. I'll be voting against CPC 19. I do agree with the spirit of the particular motion that the CPC has offered. I think the NDP 4 goes in the same direction. So in spirit, we're aligned. I just feel.
I'm sorry, Mr. Julian. I'm ahead of myself. I didn't give a chance for the motion to be moved.
Absolutely.
So, Mr. Shipley or Mr. Perkins, would somebody like to move this motion?
You can move the motion. I'll move the motion.
Okay.
Okay.
Did you wish to speak to the motion as you move it?
No, but I'd like to read it out if I could, please.
Okay, go ahead.
That Bill C-21 in Clause 34 be amended by replacing line 30 on page 22 with the following. Have collected or received from a member of the immediate family of the holder of a license or a person who resides with the holder or an organization authorized to submit an application on their behalf, a peace officer or medical professional that the hold. That's it. That's correct, right?
Thank you. Any further?
Yeah, just briefly, we would like to narrow the use of any person to immediate family medical professionals in this amendment.
Thank you. So, Mr. Julian, we'll start you over.
I'll just say I agree with the intent of CPC 19. I believe NDP 4 is better, so I'll be voting against CPC 19, not because I have anything against my Conservative colleagues, but I feel NDP 4 is stronger and more effective in this clause.
Thank you. Is any, Ms. Damoff, please.
Agree with my NDP colleague.
Madame Michaud.
Je pense que la question de
I think it's a matter of reinforcing this tool with other amendments that will follow. Unfortunately, this one weakens the measure, in my opinion, so I will vote against it.
Merci.
Thank you.
On this amendment. Mr. Shipley.
One quick question, then. If it stays as this, maybe the officials could tell me what any person, the definition there, what that would encompass, any person.
I think I would use the ordinary dictionary sense of any person.
Okay. That's pretty vague.
Okay. Seeing no further discussion, I shall call the vote on CPC 19. And you want to record division? Please conduct the vote.
Ms. Damoff.
No.
Mr. Chiang.
No.
Mr. Gahir.
No.
Mr. Noor Mohammed.
No.
Monsieur Shifke.
No.
Mr. Shipley.
That Shifty and Shipley in a row is a little difficult. Yes.
Ms. Block.
Yes.
Mr. Perkins.
Yes.
Mr. Tucker.
Yes.
Madame Michaud.
Contre.
Mr. Julian.
No, contre.
4 in favor, 7 against.
Thank you. The amendment is defeated. We go now to NDP 4. Mr. Julian, if you please.
Thank you, Mr. Chair. So what NDP 4 seeks to do, and you'll recall this is recommended both from Doctors for Protection from Guns and the Canadian Association of Emergency Physicians, both believe this measure would be appropriate. They feel that they need to have protection under the law, not to be found in violation of doctor-patient confidentiality. So this particular amendment would ensure doctors can report when a person may be a danger to themselves or others. In the same framing as Mr. Ruff's amendment that we adopted earlier, that was an excellent amendment. What we're doing is just providing additional supports and protection. I think that is something that we can all get behind. What it would do is replace line 30 on page 22 in the clause with the following statement: have collected or received from any person, including a psychologist, a psychiatrist, a nurse practitioner, or medical practitioner. That the hold, and then it continues as listed in the clause. So hopefully we'll have a consensus around this, as we have through most of this exercise. This is an important additional level of protection for people, and it goes in the same sense as Mr. Ruff's amendment.
Thank you, Mr. Julian. We go to Mr. Shipley, then Madame Michaud.
Thank you, Chair. And while I appreciate what took place earlier with Mr. Ruff's amendment, and I think that was a good amendment, I'm feeling that this NDP 4, the term any person is a little vague, so I won't be able to support this amendment.
Thank you, Mr. Shipley. Madame Michaud, allez-y, s'il vous plaît.
Ms. Michaud, go ahead, please. Thank you, Mr. Chairman. I have a question, in good faith, about the need for the addition any person, a psychiatrist, psychologist, a nurse practitioner. These are people, so it's already included. If we say any person, it doesn't give them more power necessarily. So I'm wondering about the need to add that. I understand the intent, but does it really give these people more power? I don't think so. No. And I think that the question of immunity, I don't want to talk about going against their code of conduct or code of ethics. That's provincial, and I couldn't answer that kind of question.
Mr. Julian, go ahead.
Just un dernier point.
One last point about that. The testimony we heard mentioned, especially outside Quebec, the code of ethics in Quebec is already covering those cases. But the fact that doctors and emergency physicians all said that this was an important aspect, I think that indicates the importance of this measure.
Thank you, Mr. Julian. Is there any further discussion? Seeing none, I'll ask for the vote. Recorded vote.
Ms. Damoff.
Yes.
Mr. Chiang.
Yes.
Mr. Gaye.
In favor?
Mr. Noor Mohamed.
Yes.
Monsieur Chiltier.
Oui.
Mr. Shipley.
No.
Ms. Black.
No.
Mr. Perkins.
No.
Mr. Tucker.
No.
Madame Michaud.
En faveur.
Mr. Julian.
Oui, yes.
7 in favor, 4 against.
Thank you. NDP 4 carries. That brings us to BQ 11. And if BQ 11 is adopted, NDP 5 becomes moot as they are identical. as far as the effect is concerned. And also, if PV2 is defeated, so is NDP 3 for the same reason. So we go now to BQ 11. Madame Michaud, allez-y.
Ms. Michaud, go ahead. Thank you, Mr. Chairman. The intent here is to strengthen this clause that gives instructions to the firearms office to revoke a permit if ever they have reason to believe that the person is involved in domestic violence. This is a crucial improvement to women's safety because it's asking the controller to refuse or revoke a permit to someone who is involved in domestic violence. What we understand here is they have discretionary power, these chief firearms officers. They have to determine whether there was criminal harassment or domestic violence. That should be circumscribed in these cases. So the intent is to remove that discretion from the chief firearms officer and replace it with the fact that the officer can suspend to must suspend, shall suspend. So in the wording, we would simply, maybe I should read it. It reads as follows. They shall suspend in respect of that license the holders. The chief firearms officer shall suspend in respect of that license the holders' authorization to use, import firearms for a period of up to 30 days. That would be replaced by shall suspend, and it says for up to 30 days. So we're just displacing that 30 days period. As I said, it just removes the discretion from the chief firearms officer. We heard testimony from women's shelters, from various groups that represent women, that could improve their safety if there's less discretion on the part of the chief firearms officer. So I think that would have a positive effect. I hope my colleagues will support this amendment, which is the same as NDP 5, as you said. So I suppose my NDP colleague feels the same way I do. Thank you. Thank you.
Followed by Mr. Shipley, followed by Mr. Perkins.
Thank you, Chair. And I'd like to first say that we support the intent of the change and do think it's important to change the word to shall. I would like to offer a sub-amendment to the amendment, Chair, to change the word suspect to believe. It's a small change. I'm not a lawyer, but my understanding is that it's a slightly higher burden of proof, but not a significantly higher burden of proof. So if we are requiring that the license shall be suspended, I think we should be using just a slightly higher burden of proof in the law. It would still mean that if there were reasonable grounds to believe that a number of people would still have their licenses suspended, and I hope colleagues will support that small change, maintaining the change that Ms. Michaud has put forward, which would change it to shall. So, as I said, in the law, this is just slightly higher burden of proof. It's not significant, though.
I'm not on the same page here. So you said suspect. There's no suspect in this amendment?
No, there is. Reasonable grounds to suspect. Is there not?
BQ 11 says the bill C21 in clause 34 be amended by replacing line 32 on page 22 with the following, that they shall suspend in respect of that license the holders.
I've got the wrong one. Sorry, Chair.
Or I've got the wrong one.
No, I think it's me. You're right.
Okay.
You're right.
So we'll withdraw your suggestion. Okay.
Yep.
We go now to Mr. Shipley, followed by Mr. Perkins.
Thank you. My first question was going to be, what's the difference between suspect and believe, but we don't have to, maybe later when we get into that. Maybe the officials could tell me on this amendment what this amendment does.
Thanks, Chair, for the question. So this is with regards to the yellow flags. It's not labeled like that in the bill, but these are the yellow flag provisions where if there is, as my colleague Madame Paquette was mentioning, there's concerns with regards to any number of questions of eligibility of the individual, then somebody could flag to the CFO, use the yellow flag and say, hey, I don't really think that this person should have and detail the reasons. Like these are not necessarily taken frivolously. Somebody would call in, whether a business, whether it be a health practitioner, and say, this person for these reasons perhaps should not be acquiring firearms and be able to suspend their license after kind of taking down the reasons. And that 30-day period that's proposed in the bill gives time for that CFO to do the investigation to see what further actions are necessary.
Yeah, thank you. Oh, no, sorry. I had one more. Did you? Sorry about that. I just have a question as to why is the French version a lot longer than the English version? Is that just a straight translation, or is there something different?
So in terms of the use of words in French, the way we formulate ideas in French versus in English is different. We use different words, sometimes multiple words, to say what one word in English will do. It's not unusual. You'll see that throughout the text there are different number of words that are used to convey the same idea.
Thank you for that. I just noticed this one was more so than others, so thank you for that answer. I'll pass the time to my colleague.
Mr. Perkins, followed by Mr. Julian, I believe.
Thank you, Mr. Chair. Just so I'm clear, so the way this works is that an individual can launch a complaint to the Chief Firearms Officer, and that is enough to suspend. So there is no court involvement?
So there's a test that's included in the measure which talks about has reasonable grounds to suspect, and I believe the motion that's on the floor is to change that has reasonable grounds to believe. So it's not just an automatic call that would suspend the license, is that there is a call, there is information that's given, and the CFO has reasonable grounds to believe that the individual, that the holder of a license is no longer eligible. So in terms of we're looking at license eligibility and saying,
All right.
I'm convinced.
I'm satisfied with that. Thank you.
I have Mr. Julian, followed by Mr. Tucker.
I will be supporting this amendment, BQ11. And to my Conservative colleagues, I'd just like to remind them of the famous quip from Steve Martin, that people who speak French have a different word for everything.
Merci. We go to Mr. Tucker.
I'm going to give my time to Doug.
Mr.
Please.
Shipley.
Thank you, because this gets back to, and I'm definitely not an expert in the French language, everybody knows that. I mentioned the differences, but there's a significant difference, and even I can tell with my very, very limited French, that the English one does not mention anything about 30 days, and the French one says 30 days. So there is a difference here in these two.
Monsieur le Président.
Point of order, Mr. Chair. I don't know if I can answer the question from my colleague, but there is a part before what we're focusing on here that references what my colleague just said. So it's just that the change concerns this particular line. And as it was mentioned, there's a different way of expressing in French, but it's exactly the same thing.
I'm going to ask our clerk to advise. You're saying essentially they're the same thing, they're just changing different lines of code. Is that correct? You would agree?
I'm sorry, I know we're running out of time. I don't understand that, because one mentions 30 days and one doesn't. Can someone explain that to me?
So can I read the clause in full?
Yeah.
If a chief firearms officer has reasonable grounds to suspect on the basis of information that they have collected or received from any person, and there are amendments, that the holder of a license is no longer eligible to hold the license, they may suspend, and the proposal is to change to shall, in respect of that license, the holder's authorization to use, acquire, and import firearms for a period of up to 30 days.
That point of order.
It's just that the particular line that's being amended in the English doesn't affect the 30-day part, whereas the line that's being amended in French has to deal with that. Who else was speaking on this point of order?
Can she read that in French, though? I do want to hear the French read out.
Sure, go ahead.
S'il a des motifs raisonnables de soupçonner, sur la base de renseignements qu'il a reçus d'une personne ou qu'il recueille que le titulaire d'un permis n'y est plus admissible, le contrôleur des armes à feu peut, pour une période d'au plus 30 jours, suspendre relativement
Point
à
of
ce
order,
permis.
the translation isn't working. Yeah, I did want to hear in French, but I would like the translation into English.
Okay.
So it is a point of order that translation services were not working during that.
Okay. Please read it in French and...
The point of order, Mr. Chair. I thought the purpose of the request was that it could be heard in French.
That's what I understood as well. I think we're kind of going into the deep end here with this point of order. I'm gonna bring it to an end, and you have a minute to carry on with your intervention, Mr. Tucker.
On the French portion?
You can use it how you like.
Okay, then back to the actual clause. So what does it change from how the Act reads now? So what is the main difference? Functionality, what does this actually change?
The government is seeking to, when it talks to add a new, it's amending to add a new article or a new section after Section 69 and a yellow flag. So currently, in terms of registration certificates, it talks about refusing to issue registration certificates. In this case, it allows a CFO to suspend the license of somebody if they have reasonable grounds, and there is debate as to what those words will be. If they suspect on the basis of information that they have collected that the holder of a license is no longer eligible to hold that license.
You're done. Thank you. Okay. Are there any further interventions on this amendment, or this clause, or this amendment? Then, let us conduct a vote. Do we have on division? No, on division, okay. On division. I'm not sure what takes priority. I'm sorry? Well, I mean, we have a request on division and generally accepting.
No, that's not how the standing orders work. We should be on.
That was my question, so, yeah. So, we pretty much have to do it. Okay, so on record division, go ahead, please.
Yes.
Mr. Chiang.
Yes.
Mr. Gayer.
Yes.
Mr. Nur Mohammed.
Yes.
Mr. Shifke.
Oui.
Not my strong part.
Mr. Shipley.
No.
Ms. Block.
No.
Mr. Perkins.
No.
Mr. Tucker.
No.
Madame Michaud.
En faveur.
Mr. Julian.
Oui, yes.
Yeas pour 7, nays contre 4.
Thank you. BQ 11 carries. NDP 5 therefore cannot be moved. I spoke earlier of PV2 and NDP3 and so on. That was totally erroneous. It was text that was copied from somewhere else. So anyway, we're carrying now to NDP6.
Very much, Mr. Chair. I'm going to move NDP 6. What it basically does is amend the section in Clause 34 that allows suspension for holders' authorization for a period of up to 30 days. This would allow that suspension to be beyond 30 days. If that is what is required. So it's a relatively simple protection, additional ability to ensure, in this case, that there is an ability of the system to respond, the ability of the Chief Firearms Officer in the case where there's reasonable grounds to suspect what the Chief Firearms Officer can do is suspend beyond that 30-day period. I raise this. We're getting into some very important pieces over the next hour or two, Mr. Chair, and I did want to ask my Conservative colleagues the idea of slowing things down. I don't think is appropriate for these sections. We need to have appropriate conversation, and certainly by UC we can extend time. But the normal path that we take is to move forward. If the parties have clearly indicated, we allow on division and we pass to the next amendment. And I would suggest that we really need to focus to get through these crucial amendments over the course of the next hour or two. So I wanted to flag that with you, Mr. Chair. I move my amendment.
Thank you, Mr. Julian. We go to Mr. Moff, please.
Thank you, Chair. And while I think my honourable colleague's amendment is, I know his intentions are good with this amendment. However, removing the period of 30 days leaves it open-ended. The next clause that we're going to deal with deals with license suspensions, with license revocation. Sorry, it's been a long few days. The 30 days is appropriate for this section of the Act in order to just, so we feel that the amendment to this goes a little bit too far, so we won't be able to support it. While I understand the intent, I will say I agree with my honourable colleague that the next section, we have a number of about 20 amendments here that are dealing with intimate partner violence, and I hope that we will keep our comments focused on the important amendments that we have before us. Thank you, Chair.
Point of order on that, though, just like the change.
So, Mr. Tucker, on a point of order, what is it?
Yes. So the programming motion said that we had 5 minutes per clause. So any deviation from that is not. 5 minutes per party, though.
Could you carry on with your point of order, please?
So we do have 5 minutes, the Conservatives, on each clause. Regardless of other members wanting to group them together, we will have 5 minutes per clause, prescribed in the programming motion.
You have up to 5 minutes per clause, yes, that
Correct.
is true, and up to 5 minutes per amendment, that is also true. It doesn't mean you have to use them, and of course, the more time we spend doing this, the less time we have to debate other items that we will meet going forward. After midnight, there's no more debate, no more time, things just get voted on. So if there are things that you want to have serious debate on between now and midnight, we need to be able to get to them. And so I would advise all members to use the time that is allotted to them very judiciously. So Mr. Perkins, go ahead.
Mr. Chair. For the officials, just so I'm clear, and I share the concern that MP Damoff had about the unlimited nature of this. If this were to pass, Do you think that could withstand a legal challenge, that you could have a suspension of a license indefinitely with no actual
I would suggest
recourse to the
that
courts?
this calls for some conclusions, some speculation, and that's kind of not what our
Well,
officials are here for.
If I could, I would think that the officials are experts on, because I get this and other bills from departmental officials, whether something actually is legal or not.
They may answer,
And
just cautioning you that they might
I
not.
appreciate that. Thank you.
So, though I am not a lawyer, and we cannot provide advice on whether something is meant to withstand a legal challenge.
Maybe I could take it another way. Why choose 30 days?
So the 30 days was meant to, the government intended to sort of have a defined suspension period in which to have a certain amount of time in which an investigation or a determination would be able to be made by a chief firearms officer in terms of whether further actions was necessary, but to sort of include a certain defined period to provide some certainty and not have it last indefinitely.
If I could, I appreciate that. Thank you. So it's felt obviously that you can do, that's adequate time for you to do the investigation into the complaint, if I'm hearing you correctly. Is that based on any sort of sense of the volume of complaints that you might get through this process? Because obviously everything has a limit on resources.
So right now we have an administrative tool at our disposal. It's not a legal one, but we can put a license under review currently to investigate an incident or a complaint. And we use the timeline that generally we take for these types of ones and applied it to this. So,
Experience.
correct.
So
30 days is reasonable.
There is not a calculation in here that if, with this new power, there may be more cases or complaints that come up, and what the sort of resource limits of that might be on you. So it is possible that if the complaints do increase because of the ease with which to get this into the system, that you may not have the resources to go through them in 30 days. Is there any cushion, in other words?
Yeah, I don't have any statistics on that. The 30 days is reasonable based on the
Current
processes we have today.
Thank you.
Is there any further discussion on this amendment? Seeing none, I shall call a vote. Do we a recorded vote? Go ahead.
Ms. DeMoff?
No.
Mr. Chiang?
No.
Mr. Gahir?
Against?
Mr. Nur Mohammed?
Nope.
Mr. Shifke?
No.
Mr. Shipley?
No.
Ms. Block?
No.
Mr. Perkins?
No.
Mr. Tucker?
No.
Madame Michaud?
En faveur.
Mr. Julian?
Oui, yes.
Yeas pour 2, nays contre 9.
The amendment is defeated. We proceed now to Block 12. I'm sorry. That is all about Clause 34. So shall Clause 34 as amended carry? I'm sorry, did you want to speak on the clause? Okay, go ahead.
Thank you, Chair. Just a quick question. Well, actually, it may not be that quick because I'd like a fulsome answer on this. Could the officials just explain in its entirety what this Clause 34 is achieved in its amended new form?
So Clause 34 establishes the yellow flag license suspension regime in which there is a test in terms of when a license may be suspended by a CFO, providing for a notice that the chief firearms officer would give in writing of the suspension to the holder of the license. With regards to creating an exception to paragraph for non-disclosure of information, as well as for the termination of the suspension and a prohibition on the use, acquisition, and importation during the time that the license is suspended.
Okay, thank you. Shall we conduct a vote through recorded division?
Ms. DeMoff.
Yes.
Mr. Chiang.
Yes.
Mr. Gahir.
Yes.
Mr. Nur Mohammed.
Yes.
Mr. Shifke.
Yes.
Mr. Shipley.
No.
Mrs. Block.
No.
Mr. Perkins.
No.
Mr. Tucker.
No.
Madame Michaud.
En faveur.
Mr. Julian.
Oui, yes.
Yeas 7, nays count 4.
Thank you. Clause 34 therefore carries as amended. Brings us to Clause 35. Is there any discussion on Clause 35? Mr. Shipley.
Thank you, Chair. A question for our officials tonight. We've talked about a lot about the words "to carry." Can we get exactly what that entails? The authorization to carry.
Thank you for the question. An authorization to carry is an authorization to carry a restricted or in a prohibited firearm, either in the course of the reasons of employment or for reasons of protection of life, and is defined and described under Section 20 of the Firearms Act.
Thank you for that. And just to clarify, because I'm sure there's some people watching this who aren't really up to speed, it's fairly limited on individuals who have permission to carry, is it not?
Yes.
Could I get Can I get a couple of specific examples? You said for work. I think you said that correct?
So the reasons for employment for carrying a firearm and having an authorization to carry is, for example, security guards carry the armored car carriers. They are often authorized to carry because they are private businesses. The other ones are with regards to, for example, trappers. Will often carry a firearm, a sidearm, as well as their long gun when they're hunting, and they would have an authorization to carry.
Thank you. You mentioned just a very interesting comment, because I asked this back in our witness days a long time ago, too long ago, because we heard from some trappers that they use them quite often to carry, and then I wish I could remember. There was a second individual who said he had never seen that. You just mentioned that trappers do have the right to carry. So do many trappers carry?
I have the statistics to be able to share.
This gentleman does.
Between the working in a remote wilderness area and or trapping, I think the number is currently about 400 ATCs have been issued for those purposes. So it's not a high number.
I guess that's a matter of opinion. 400 seemed like a lot to me. I didn't think it was going to be that high, quite frankly. I don't know if you're going to know this answer. I'm just trying to get a relation. Do you know how many trappers there are? Would anybody of the officials? Because I obviously don't. I'm not a big trapper myself, but no. Okay. I think I'll leave some time for my colleagues. Thank you.
Mr. Perkins, then Mr. Tucker.
Thank you, Mr. Chair. Thank you, officials. this clause refers to the Commissioner of Firearms being able to revoke that. Is only the Commissioner of Firearms the only person who can revoke that?
This is a coordinating amendment with an earlier amendment which would, for reasons for protection of life under paragraph 20A, which is now going to resign the authority to issue authorizations to carry for those reasons under 20 sub A, is going to be with the Commissioner of Firearms, and therefore it's the Commissioner of Firearms that would revoke.
What's the process that happens for that? What would cause somebody to need to have it revoked, and how does that process work as it goes up the chain to what I believe is the, you referred to earlier as the Commissioner of the RCMP, is the Commissioner of Firearms would be the ultimate person that would have to sign off on revoking?
They would no longer need protection of life, so they would no longer meet that threshold.
How would that, where would that request be made, and how would it make its way up to the Commissioner of the RCMP?
There would be a full process. Do you want to explain?
Yeah, so there would be a process that would provide the Commissioner of Firearms the information that the individual does not require the authorization to carry for the purposes of personal protection of life. They may have been issued that authorization to carry because they were not provided the safety by a local enforcement agency, which is one of the reasons that one of those things could be issued, and maybe circumstances changed and therefore were provided to the Commissioner, so the Commissioner would therefore revoke the authorization to carry.
And the Commissioner doesn't have that authority now, or this modifies it in some way?
Currently, the Chief Firearms Officer has that authority, but this amendment provides for that specific purpose the Commissioner of Firearms to have the responsibility of approval and refusal of the authorization to carry for that specific purpose.
So in addition to the Chief...
Thank you, Mr. Perkins. We're done. Okay. Any further discussion on this amendment? Seeing none, let us carry out the vote. I think we should do a recorded division.
Ms. DeMoff.
This is on clause 35, correct? Yes.
Mr. Chang.
Yes.
Mr. Gahir.
Yes.
Mr. Nur Mohammed, sorry.
Yes.
Mr. Shifki.
Oui.
Mr. Shipley.
Yes.
Ms. Block.
Yes.
Mr. Perkins.
Yes.
Mr. Tucker.
Yes.
Madame Michaud.
En faveur.
Mr. Julien.
Oui, yes.
Yeas pour 11, nays contre 0.
Thank you. The clause 35 carries. Thank you all. So we have now a number of amendments on clause 36, starting with BQ 12. Madame Michaud, allez-y, s'il vous plaît.
Madam Michaud, go ahead, please. Thank you, Mr. Chair. So BQ 12 is about clause 36 of the bill, where we are talking about revocation of licenses in case of domestic violence. I think the amendment is better drafted than many other amendments that are seeking to accomplish the same thing. So in NDP 759 and PV 3456 are some. They are seeking to do the same thing in parts and pieces, but BQ 12 brings it all together in the same amendment. So I think it would be a good idea to vote in favor of this. So this is to protect people, victims of domestic violence. This was especially requested for by the National Association of Women and the Law. So the bill, C-21, in its current form, especially this clause, stipulates that the Chief Firearms Officer must revoke the license if they determine that an individual who holds a license has engaged in an act of domestic violence or stalking. So the word in the English version is determine or determines. That might be a bit vague. And what is concerning is that a large discretionary power is being given to the Chief Firearms Officer to revoke if they are convinced that such an act has taken place. So we are again being more cautious and more prudent with this amendment. And the National Association of Women and the Law put it in a very nice way, if you will. It is important to realize that a false negative, so not identifying a situation of family violence or domestic violence and not revoking a license, might have more dramatic results than a false positive. So the threshold is too high and too vague. So here we are adding some elements to 70.1. In the bill, in its current form, it reads as follows. If a Chief Firearms Officer determines that an individual who holds a license has engaged in an act of domestic violence or stalking, and here we are making some additions in the amendment, so it would look like this. If a Chief Firearms Officer has reasonable grounds to suspect that an individual who holds a license may have engaged in an act of domestic violence or stalking, the Chief Firearms Officer must revoke the license within 24 hours. So it reinforces what the Chief Firearms Officer can do in cases of intimate partner violence or domestic violence when they have reasonable grounds to suspect such a situation. This has happened multiple times with this bill, but we have come up apparently with the same idea, NDP, the Liberals, the Greens, but I hope that they will be in favor of this amendment. Thank you.
Thank you for mentioning it. I should have mentioned that if BQ 12 is adopted, Liberal 1, PV 3, PV 4, NDP 7, PV 5, NDP 8, CPC 20, Liberal 2, PV 6, and NDP 9 cannot be moved due to a line conflict. So the other way of looking at that is if we pass this one, we can save all those other ones. Okay, so we go first to Mr. Shipley, then Mr. Moff, then Mr. Perkins.
Well, some good news tonight, Chair. I think we were able to jump ahead then and save some time, which is nice for everyone. I just have a couple. This is obviously a very serious issue. Anytime we're talking about domestic violence, we need to make sure we get this right. It's a serious issue. It needs to be dealt with quickly as we can. My question is to the officers of the table. The Chief Firearms Officer is really not one person. It means the office of the Chief Firearms Officer, I'm assuming. Let me get that part straight first.
There is one Chief Firearms Officer in a province, so it's either federally appointed or provincially, designated. But there is firearms officers as part of that office.
Right, because that's what I mean. And why I'm asking that is just so I'm clear and everybody else maybe is clear, is that there's really not just one person who could revoke the license within 24 hours, because not every one person is available at all times. There's obviously vacation, holidays, weekends away, statutory holidays. That wouldn't affect this. It would still be doable?
Oh, yes. Sorry, yes.
Right. So, and again, I'm not trying to pick hairs here. I just want to be clear when we say then. So it's not literally. It's the. And I want to use the word the office of the Chief Firearms Officer, but it isn't one person. It is an office of to make sure this gets handled properly and correctly is what I'm trying to ascertain here.
Yeah, so in the Firearms Act, it refers to Chief Firearms Officer or Firearms Officer, but there are activities that a Chief Firearms Officer can designate down to their staff.
Okay, great. And that's all I just wanted to clarify to make sure that this can be done and is doable, because we think this is a good amendment. Thank you. That's all I have.
Thank you. Mr. Muff.
No, so definitely supportive of the within 24 hours part of this amendment, and thank you for bringing that forward. My question to the officials is the difference in the wording from the original clause between determines and has reasonable grounds to suspect. My understanding that there's a civil standard of proof that around determines. I'm wondering if you could just explain to us what the difference is with the change that Madame Michaud has proposed.
Thank you for the question, and I think it's actually quite useful in terms of illustrating this difference. So you're quite right that in the context of a revocation of a license, if that were to be, let's say, contested and eventually determined in a courtroom, the standard that would apply would be on a balance of probabilities, which for the layperson is like 50% plus one certainty, so more likely than not. I think that's a good way of understanding what a balance of probabilities means. Reasonable suspicion is a standard that's used throughout the code. It's definitely lower. In fact, it's the lowest known to criminal law. And it really just means, well, there are, first of all, we're talking about evidentiary standards. So with respect to the amount of evidence, obviously it's not just a question of quantity. The nature and quality of that evidence will matter. But effectively what it is, it's a credible possibility that the thing suspected occurred or will occur, depending on how it's directed. But I should note here that it's modified by the subsequent language may have engaged. So that's the thing to be proved. So a mere possibility that a thing may have happened.
So what I'm hearing is that it's still a pretty, the way that the bill was originally worded with determines and may have is still putting, it still offers a number of protections if someone was going to have this happen. Is that what you're saying?
I can say that it would be consistent with other kinds of revocations that occur, you know, be they for public safety related reasons, irrespective of the type of victim, I suppose, or potential victim. So that would be more consistent with what you see elsewhere in the Firearms Act.
Okay, so I'm going to propose a sub-amendment to this, Chair, that would remove has reasonable grounds to suspect and return it to determines, and then change the words may have to has.
Okay. Are we, is everyone clear on this sub-amendment?
So remove the words has reasonable grounds to suspect and change it to determines. That was what I was just asking the official about, and that returns it to the original language in the clause. And then change may have to has engaged. I think we all want to make sure that we're keeping women safe in instances of domestic violence and stalking, but we also have to put reasonable grounds in this bill that align with other parts of the bill and also ensures that there's a balance. The 24 hours, I think, is critical, and I think we all agree on that, or at least I hope we do, that the 24 hours is a really valid addition, that it needs to be done immediately. Certainly there are instances where women have been killed when it hasn't happened quickly. But I'm just asking if we can change those wordings to as the official talked about, the balance of probabilities and something that is in other parts of the Firearms Act. Thank you.
Thank you. So the discussion now goes to Mr. Moff's sub-amendment. Mr. Julian, go ahead.
Thanks, Mr. Chair. I wanted to thank Madame Michaud for bringing forward this amendment, which is really a consolidation of a series of other amendments and puts it all in one place, and that is very helpful. But the recommendation itself comes from the National Association of Women in the Law. And you'll recall, Mr. Chair, when they came forward to this committee, they were very clear that we need to ensure the chief firearms officer can intervene when he or she has reasonable grounds to suspect. And if what we are talking about is ensuring swift action in a dangerous situation, of which we have far too many examples, it seems to me that standing to the level of what the National Association of Women in the Law would be really important. So I will be, though I completely understand Ms. Damoff's attempt and the spirit with which she offers the sub-amendment, I'll be voting against the sub-amendment and voting for BQ12. I think that is certainly what we're seeing from organizations that are concerned about domestic violence, is that we need to make sure the chief firearms officer can intervene when there's reasonable grounds. And so I prefer to stay with the wording that is in BQ12.
Mr. Perkins.
Thank you, Mr. Chair. And I appreciate everything that our colleagues around the table have said on this very important amendment and the offer. And totally agree on the 24 hours. So my question really, and I'm not sure who's the best to answer it out of the amendment, or sub-amendment, I guess, to the amendment and the subsequent ones that the chair said would, if any of this passes, we would not consider. I guess I have two basic questions. Which offers the best protection and is most likely to stand up in any kind of challenge in court in terms of its ability to survive this? Because we don't want to have to come back and try and amend the act again.
So on the second part of your question, I think I'm going to take direction from the chair. As I think the chair alluded to earlier, I can't really answer questions as to legal validity or viability in a challenge. But I'd like to try to answer the first part of your question. So could you give it to me again, please?
The first part of the question is, I'm just trying to figure out which one of these amendments provides, I guess, greater certainty that any act of violence can be dealt with quickly in the wide variety of types of violence that could happen, that one of these isn't sort of narrowing, that it's broad enough to cover circumstances that we might see or not foresee that allow this to happen within 24 hours, the sub-amendment or the amendment.
So, I mean, I don't think I can speak to the circumstances in which it would come about, but I think I want to clarify that this is the administrative revocation of a license. It's not a mechanism of emergency intervention.
But you have to have reasonable grounds, or Ms. Damoff's determines. So just trying to understand the difference. I think you said it, but from the official's perspective of which one is.
Say which it provides better protection. I can describe what they are in law, which is they are evidentiary standards or standards of proof. Determines is a bit higher than, I would say, a fair bit higher than reasonable suspicion. In fact, if it's helpful, I'll just quickly plot them on a range. Reasonable suspicion is the lowest. Reasonable and probable grounds is slightly higher than that. And balance of probabilities is slightly higher than that. So if that helps.
Determines is balance of probabilities.
Determines, yes, has been interpreted by the courts as meaning a balance
Mr.
of probabilities.
Perkins. Yeah, that's it. Okay, so is there any further discussion on the amendment of Ms. Damoff? Seeing none, let us have the vote on division. I'm good with that. I'm sorry.
Pardon me, Mr. Chair, you're saying that the sub-amendment would pass on division or be defeated on division?
Well, that's a good point. Mr. Shipley proposed to pass this on division. The sub-amendment. The amendment, Ms. Damoff's amendment.
Mais je vais laisser ça, Madame.
I will leave this to Madame Michaud, but it might require a recorded division.
Madame Michaud?
Can we have a recorded division, please, Mr. Chair?
Let's have a recorded division. Thank you.
Ms. Demoff.
On the sub-amendment, correct?
This is on the sub-amendment.
Yes?
Mr. Chang.
Yes.
Mr. Gahir.
Yes.
Mr. Nur Mohammed.
Yes.
Mr. Shifke.
Oui.
Mr. Shipley.
Nay.
Ms. Block.
Nay.
Mr. Perkins.
Nay.
Mr. Tucker.
Nay.
Madame Michaud.
Contre.
Mr. Julian.
Un gentil contre, moi aussi.
Yeas pour 5, nays contre 6.
The sub-amendment is defeated. We go back now to the main amendment, and is there any further discussion on the amendment? Seeing none, I suggest we call the vote. Madame Michaud.
Est-ce qu'on peut avoir un vote?
Can we have a recorded division, please?
This is on the.
I realize that, Chair. If this is defeated, can we then move Lib 1?
Yes, if it
Okay.
passes, that whole list is gone.
Okay. All right. So then, no.
Mr. Chang.
No.
Mr. Gahir.
No.
Mr. Nur Mohammed.
No.
Mr. Shifke.
No.
Ms. Block.
Yes.
Mr. Perkins.
Yes.
Mr. Tucker.
Yes.
Mr. Shipley.
Yes.
Madame Michaud.
Oh.
Mr. Julian.
Yes, oui.
Yeas 5, yeas 6, nays contre 5.
So the amendment passes. That means that Liberal 1 cannot be moved. Cannot be moved. PV3 cannot be moved. PV4 cannot be moved. NDP 7 cannot be moved. PV 5 cannot be moved. NDP 8 cannot be moved. CPC 20 cannot be moved. Liberal 2 cannot be moved. Cannot. PV 6 cannot be moved. NDP 9 cannot be moved. Well, that was very efficient use of our time. A break? Absolutely. Okay. So it's been about 2 hours since we had a break. I'm proposing, at the suggestion of our esteemed colleagues on my left, not that you're left-leaning, 15-minute break. Suspended for 15 minutes. We need to get back to it here, guys. What did we forget? That'd be the Ghost Shipley. Ghost Shipley. Amazing. We need to get this meeting back underway. So before I officially resume the meeting, I'll just point out that we will have some pizza coming on in about an hour, and from Gabriel's, which I think is the best in town. But and that's thanks to our esteemed clerk. So, well, I'm not saying we're going to have a chance to take a break. We may have to eat on the fly, but anyway, I call this meeting back to order. So we are at this point at CPC 21. Carrying on with Clause 36. So CPC 21, who would like to move that? Mr. Shipley.
Thank you. I would like to move CPC 21. This is a very important piece. This is what we feel will define domestic violence. So I'd like to read this into the record, Chair. I almost called you your worship. I know, that's all, you caught that, eh? That Bill C-21 in Clause 36 be amended by adding after line 37 on page 23 the following. 2, for the purpose of subsection 1, domestic violence means conduct, whether or not it constitutes a criminal offense by a family member towards another family member, including conduct by or towards an intimate partner that is violent or threatening, or that is part of a pattern of coercive and controlling behavior, or that causes that other family member or intimate partner to fear for their safety and for the safety of another person, and includes A, physical abuse, including forced confinement, but excluding the use of reasonable force to protect themselves or another person, B, sexual abuse, C, psychological abuse, D, financial abuse, E, threats to kill or cause bodily harm to any person, F, threats to kill or harm any animal or damaged property, G, harassment, including stalking, H, the failure to provide the necessities of life, and I, the killing or harming of an animal or the damaging of property. As I said, I won't say any more to this. I think this is an important amendment, and we'll see what my colleagues and roommates in here will feel about this themselves.
Okay. We'll go to Ms. Demoff and then Madame Michaud.
Thank you. And thank you for putting this forward. It's very similar to the amendment that we've put forward and others, and is reflective of
Actually, let me interrupt you. I apologize. I forgot to mention that there are conflicts. If this passes, then BQ 13, Liberal 3, PV 7, NDB 10, they all deal with the same subject matter. So anyway, I'm sorry. Please go ahead.
That's fine, Chair, because I think it actually reflects, and I just want to note that Ms. May from the Green Party is here with us, and I want to thank her for the work that she does, particularly when it comes to domestic violence and firearms. We've worked on this issue in the past, and I think it's reflective. The CPC have put forward this amendment, but so have the Bloc Liberals. and Green Party and New Democratic Party. So we will be supporting this amendment. It's a good one, and it's an important one, and it's nice to see all parties coming together when it comes to issues of domestic violence.
Madame Michaud, allez-y.
Ms. Michaud, please go ahead. Thank you, Mr. Chair. My comments will be in the same vein. BQ 13 has the same exact intention of defining domestic violence, as has been requested from us by multiple groups that appeared before us in this committee. Police au Soutien is one of those groups, for instance, among others. So I also am very happy to see that there is unanimous will, if you will, around the table, because the different parties are proposing the same amendment on this very important question. The Bloc Québécois will vote in favor.
Thank you. Is there any further discussion on this amendment? Mr. Julian.
I think this will be adopted unanimously, Mr. Chair, and I thank the Conservatives for bringing this forward.
Do we have unanimous support for this bill, or for this motion? The bill. Thank you. Carried unanimously. Yes, so BQ 13 is moved, okay. And Lib 3, I understand, is being withdrawn. Is that correct?
And PV 7 and NDP 10.
Right, okay.
So now we're at 14. 14, yeah.
Okay. Right, okay. So we are indeed at BQ 14. Madame Michaud, if you will. S'il vous plaît.
Thank you, Mr. Chair. This amendment again modifies our clause 36. It refers to delivering to a peace officer any firearm that they possess, and there's also the introduction of a time period of 24 hours in exceptional circumstances. But I will not move this amendment. The following amendment, Lib 4, has about the same intention, but it's more severe, if you will. So I am not going to move the BQ 14 amendment.
Very well, thank you. BQ 14 is withdrawn. That takes us to Lib 4, and rather than do it after, I should be doing it first. If Lib 4 is adopted, PV 8, NDP 11, BQ 15, and Lib 5 cannot be moved due to a line conflict. And also, if Lib 4 is defeated, so are PV 8, as they are identical. Madame Demoff, please.
Thank you. And again, we're talking about cases of domestic violence. Predominantly, although that's not the only situation. But this change that we're proposing is really important in terms of ensuring that things happen in a timely manner. So ensuring that the 24 hours is included here, unless it's impossible. So the example that was given to me was, for example, the 24 hours is not possible because the owner is in Italy. So the CFO could determine that 24 hours was impossible for them to meet. So I do think it's an important amendment to ensure that these firearms are turned in a very timely manner, because we know that the most dangerous time for a woman when she leaves a domestic violence situation is within that first very short time period. And it's happened time and time again that a woman is killed within that first time frame. So I'm hoping that colleagues, and I thank Madame Michaud for withdrawing hers to support Lib 4. Thank you so much for this and all your work on this bill. So I'll leave it there, Chair.
Thank you. I'll not make the comment about speaking through the chair in that case.
Oh, yes.
Is there any further discussion on this amendment? No discussion? Shall we have a vote on this? Pass on division. On division? On division. So, so Lib 4, wait a minute, that passes. So, PV 8 cannot be moved. NDP 11 cannot be moved. BQ 15 cannot be moved. Lib 5 cannot be moved. All right, so that brings us to PV 9. I'm going to ask, so the rules are, I'm not quite sure what the rules are here. I'm going to ask for unanimous consent for Ms. May to speak to her.
Sorry,
her.
Mr. Chair, that's not necessary.
It's not necessary?
No, because this committee passed a motion which set out the terms, which forced me to be here because my rights in report stage are removed, and my rights to participate are not really, well, it's a long story, but if you check the motion this committee passed, you'll find it sets out that I have a right to speak for a reasonable amount of time to any of my amendments, and that's the only time I'm allowed to speak, and generally that's seen to be 1 minute.
I was kind of referring to the marching orders from the House from Tuesday night. That
I don't think that affects. I'm sorry, sir. But check your.
Anyway, if we could get unanimous consent from Ms. May to speak to her motion, it would be good.
Mr. Chair, if helpful, I'm happy to cede my 1 minute of time to Ms. May.
Okay, absolutely. Go ahead.
Thank you, Mr. Chair. I do think it's important to emphasize that because these rules were in the motion that governs all of this committee's work at clause by clause, it wouldn't be changed by the motion that was passed in the House. But I appreciate everyone's goodwill, and just to say that this motion is to ensure that if a license is revoked, all firearms are delivered to a peace officer, and that is it's the same. It's virtually the same, except it removes the lawfully disposed of language, and I hope that this will be acceptable. Thank you.
Thank you. Is there any discussion on this matter? Madame Michaud.
Merci, Monsieur le Président.
Thank you, Chair. I might have missed a bit. Did you say that BQ 15 could not be moved? Because we passed Lib 4? Because I'm under the impression that I was trying. Well, in the Liberal amendment, can I still move my amendment? It's the same as PV9, in fact.
You can't move it, right? I think that's correct. We can't. It conflicts, right?
Chair, how could that conflict and not PV9?
It could be I'm making a mistake, so let me just find out what's going on here.
This is a really important amendment.
Right.
So whether it's Ms. May or the block or us.
So, as noted for, if Lib 4 passes, there's a line conflict with BQ 15.
PV9 as well.
Okay. BQ 15 cannot be moved due to line conflict. And I apologize to Ms. May, PV 9 cannot be moved due to a line conflict. And NDP 12 cannot be moved for line conflict.
So, just a point of order, Chair, that might have changed how we dealt with the previous amendment had we known that PV 9 could not be moved, because this is a really important change. And had we known that, we might have done something differently on the previous amendment. So I
did mention it before we...
You didn't say PV 9, Chair. You said that you stopped, when you went through the list, you stopped at Liberal 5.
I'm sorry, give me a minute. So when we talked about BQ 14, this whole long list, that same long list does not occur in my notes for Lib 4. However, I believe it is still affected by Lib 4. Did you want to...
Point of order.
On a point of order?
Yes, Chair. If you review, I believe you did include PV 9 in your description. If you had asked the clerks to review the video, we could find out if you said it or not.
I'm not inclined to do that. We don't need to go. We just need to sort this out. So, my understanding is that since we passed Lib 4, we cannot pass PV 9. We cannot pass BQ 15. If we want to do something else, we'd have to have unanimous consent to do so.
But my point is that had we known that PV 9 could not be moved, I suspect that Madame Michaud or Ms. May or someone would have amended Lib 4 to ensure that we did get or otherwise lawfully dispose of, because that is an extremely important part of what we are trying to change in this.
I understand. I'm only going from my notes trying to...
I realize that.
So my point here is that we have passed Lib 4. If we want to go back and revise it, we require unanimous consent to do so. Mr. Tucker.
Yes. Regardless of what the video is showing that you did include PV 9 in it, I think it's just been a long day, and I would move adjournment of the committee.
Thank you, but our instructions about the House don't allow us to adjourn at this time.
Adjourn.
We're not going to get into
Okay. All right.
Okay. And that wouldn't solve our problem either. So, I'm sorry? Okay. Let's suspend for a minute or two and get ourselves squared away here. Mr. Lloyd, Mr. Cram. Mr. Ellis. Okay, I call this meeting back to order. Okay, the situation with Liberal 4 it cannot be resolved at this point. So what is going to happen is the changes that need to be made in respect of these other amendments will be made at report stage in the House. Yeah, we can't move them now, so there will be. That was something that will be taken up at, you know. Okay. You'd have given it though, right? Yeah. Okay, so that brings us, Madame Michaud.
Merci, Monsieur.
Thank you, Mr. Chair. On that, it's a shame that we cannot modify, but I do understand the reason. So the way it's drafted, it's written right now, it gives other options other than submitting it to a peace agent. So we wanted to get rid of that ambiguous situation and make it clear what needed to be done. So I think we could suggest an amendment at the report stage.
That is my understanding of the best way to go forward on this. Thank you. So I believe we can now proceed with BQ 16. And I will note that with respect to BQ 16, if it is adopted, Liberal 6, PV 10, and NDP 13 become moot as they are identical. Also, if BQ 16 is defeated, so are Liberal 6, PV 10, and NDP 13 for the same reason. Madame Michaud, c'est de vous, BQ 16.
Ms. Michaud, you have the floor. Thank you, Mr. Chair. So at this point in the bill, there's a reference to reasons that might exempt a person from a revocation of their license, and the amendment has the objective of excluding employment as justification. This has been requested by multiple groups, especially by the Battered Women's Support Services, Police Se Souvient as well, and many women's organizations have expressed concern about this. For instance, a violent partner who happens to be a police officer, so that they get to keep their firearm, whereas they are being targeted by a protection order. So we're just trying to avoid additional violent incidents or situations. So we are once again trying to display an excess of prudence with this amendment. I know that there are other amendments which are very similar or even identical. It seems to me that there is a willingness around the table to remove this employment justification, and I hope that colleagues will vote in favor. Thank you.
Merci. Mr. Lloyd.
Just want to ask the officials about this because I like the intent of this, but and we did have some witnesses who said this was concerning to them. But just because a CFO has the ability to use this as a reason to grant somebody a permit doesn't mean that the CFO is required to grant that person a permit for this reason. Is that correct?
Correct.
Does the CFOs generally use a balance of probabilities to, judge whether the person is a threat versus their need for a vocational livelihood? And in those cases, if they are a threat, I would assume that the CFOs wouldn't give them a permit for this case. Would that be correct?
I would assume the same, yes. They have a variety of tools at their disposal.
Okay. And I think generally I trust the CFOs because I think they always err on the side of public safety. I've yet to see any evidence that CFOs have been granting licenses for the purpose of the vocations to people that have been a danger and have committed, committed terrible acts, but I mean, it just seems to me that that it's prudent to, give the CFOs the discretion to decide whether or not, somebody is a risk. If it's something that's important for their job and their livelihood. We're talking about people's livelihoods. And I think somebody at the committee said, well, they can just get another job. And I thought that was a little bit flippant of somebody to say because, it's a tough economy out there. And especially for older people, it's very difficult to retrain, especially when you've been doing a career your whole life. And to just say, well, they can just find another job. It really ignores the reality of many people's lives. And of course, if they are a genuine threat to public safety, as the officials have said, the CFOs will not be granting this permit to people that are a threat to public safety. And so generally, I would trust our public safety officials to make the right calls on these matter unless I see strong evidence to prove otherwise. Thank you.
If I could just add just a point of clarification, because police officers were used as an example, this is only with regards to authorizations under the Firearms Act that this would affect. Police officers hold their service arms under not the Firearms Act, but under their enabling legislation. If they hold firearms privately, this would be affected, but not their service arms.
Thank you. Is there any further discussion on this amendment?
Do I have more time?
You have 2 minutes and 13 seconds.
I want to kind of get back because was that indeed one of the justifications that were made? That this was a means to, prevent somebody from being a police officer because they wouldn't be able to carry their firearm? That seemed to be what some of the testimony was saying. And what you've clarified here, I knew that because, military members and police members, they are not required to have authorizations to carry. It's just part of their job. And so we're not talking about police officers and taking away police officers' handguns here. If they're a danger, there's other processes to remove them from the force. And so I think I would trust the CFOs in this case to make the right decisions. And taking away this tool, I just don't think is going to enhance public safety. Thank you.
Thank you. Any further discussion on this amendment? Seeing none, let us conduct a vote. On division? A recorded division? Okay.
Ms. DeMoff.
Yes.
Mr. Chiang.
Yes.
Mr. Gahir.
Yes.
Mr. Nur Mohammed.
Yes.
Mr. Shifke.
Oui.
Mr. Lloyd.
No.
Dr. Ellis.
No.
Mr. Cram.
Against?
Mr. Hoback.
No.
Madame Michaud.
En faveur.
Mr. Julian.
Oui, yes.
Yeas 7, nays compte 4.
The BQ 16 carries. That means that Lib 6 cannot be moved. PV 10 cannot be moved. NDP 13 cannot be moved. And that brings us to shall clause 6 carried. Is there any discussion on clause 36? On division? Mr. Lloyd.
Just quickly, can the officials quickly explain what the impact is on this, of this clause? For the folks listening at home.
Thank you. The Clause 36 establishes a new license revocation scheme related to domestic violence and protection orders, going from the revocation in situations of domestic violence, revocations in cases of protection orders, notices, the requirement for disposal of firearms, and other references, or sorry, no, I'm in the wrong, conditional notices and the conditional licenses.
Like in cases if somebody's been convicted of domestic violence, the CFO doesn't have the authority to revoke their license or their
It
access.
expands on the current revocations that are in place for revocation of licenses.
Okay. On division.
On division. Okay, so Clause 6 carries on division. Sorry, Clause 36. Don't go back. Forward, always forward, yes. Clause 36 carries, okay. That is, as amended, Clause 36 carries on division. Let's go on now to Clause 37. We have Block 17, a new Block 17. And if BQ 17 is adopted, Liberal 7 cannot be moved. PV 11 cannot be moved. NDP 14 cannot be moved. BQ 18, Lib 8, PV 12, and NDP 15 cannot be moved due to a line conflict. Madame Michaud, BQ 17.
Thank you, Mr. Chair. BQ 17 is about the return of the firearm. It's very similar to Lib 7, has the same intention with different wording. So I prefer not moving BQ 17 and vote in favor of Lib 7.
Very well. BQ 17 is withdrawn. Okay, that takes us to Lib 7. If Lib 7 is adopted, PV 11, NDP 14, BQ 18, Lib 8, PV 12, and NDP 15 cannot be moved due to a line conflict. So, Madame Demoff, Lib 7, if you please.
Thanks, Chair. The clerk was, there was an error in the, Garnet? I'm sounding too mom-like here. There was an error in the amendment that was distributed, and in the French version, it says page 25, and it should say page 24 under C. So it's a typo that was done when it was distributed. So this, in essence, is ensuring that the 24 hours, or if that's not possible, that it's an extended period established by the Chief Firearms Officer. So we want it returned as quickly as possible. However, if the CFO determines that someone is out of the country, they can extend that time within something as reasonable. I do have a question for our legislative clerks, though, because one of the amendments later on that will not be able to be moved is dealing with that same question of otherwise lawfully dispose of. So BQ 18, Lib 8, PV 12, and PV 15, which will not be able to be moved. Can a colleague amend Lib 7 to include those words in this one? So the amendment that is in BQ 18, can Madame Michaud sub-amend Lib 7 to include that?
I'm not sure if how the wording would work, but in theory you can sub-amend.
Well, the problem was the last time we were told that there was a line conflict. So I don't want to get into the same, I don't want to ask for unanimous consent again, and I suspect that if you seek it, you would find that Madame Michaud would love to sub-amend my amendment to remove the words "or otherwise lawfully dispose of."
So you wouldn't need unanimous consent for that. She would just have to move it, I believe. But before we do that, you made comment about some errors in the text that distributed around Part C of the French. Could you?
That's correct.
What should it be?
25 should be 24.
So page 24. Okay.
That's correct.
Okay. Okay. So you've moved Lib 7. Is there any discussion on Lib 7? I'm going to ask if Madame Michaud would like to speak and potentially move a sub-amendment.
Oui, merci.
Yes, thank you, Mr. Chair. I would like to move a sub-amendment. Ms. Demoff, can you please repeat what you alluded to in terms of the sub-amendment?
Essentially, you would be putting the wording from BQ 18 into this if it's allowed. So the words "or otherwise lawfully dispose of" would be removed from A and B, unless the legislative clerk says, no, you can't do that.
The clerk would need a little bit of time to look at it, so how about we suspend for a few minutes to... it turns out pizza's arriving, so it's really a good time for a brief suspension. So I'll we're suspended. The pizza's arriving. So the meeting is resumed. Thank you. So there have been some discussions around the amendment. Madame Michaud, you voulez, do you want to move the amendment?
Merci, Monsieur.
Thank you, Mr. Chair. We had a discussion with the legislative clerk. So English versus the French was the issue. So what we will do is that we will propose an amendment, move an amendment at the report stage. It will be just about coordinating things. So Ms. Demoff can move her amendment without a sub-amendment coming from me for this at this point in time. Thank you.
See. So, Madame, Ms. Dancho, Ms.
Still
Demoff.
on that side.
So
I've moved Lib 7,
Okay.
and I spoke to it, Chair, so it's on the floor. We'll just leave it at that. Thank you.
Any further discussion on Lib 7? Mr. Lloyd.
Now, I noticed Mr. Demoff was saying a reason was somebody was out of the country. Is that the only reason why a CFO might need more than 24 hours? What's the context of this change? And what is the current rule like right now?
So I can speak in terms of maybe the first part of your question, and then I'll hand it over to my colleague to answer the part. The other question would be is that maybe, especially in very remote and rural regions, maybe far up north, is that they can't deliver to a peace officer or to a chief firearms officer within that 24-hour period. So then, there could be an extension to give them just sufficient time to be able to deliver it.
Extension prescribed in other parts of legislation, or is it really just up to the discretion of the CFO?
Right now, it would be at the discretion of the CFO.
And this amendment doesn't change that discretion?
It would not change that.
Okay. Thank you.
Is there any further discussion? Is it the will of the committee to adopt this motion? On division? Adopted. On division. Okay, so that means that PV 11 cannot be moved. NDP 14 cannot be moved. BQ 18 cannot be moved. Liberal 8 cannot be moved. PV 12 cannot be moved. NDP 15 cannot be moved. Shall Clause 37 carry? On division? Carried on, I'm sorry? Mr. Lloyd requests a recorded vote.
Ms. DeMoff.
Yes?
Mr. Chang.
Yes.
Mr. Gahir.
Yes.
Mr. Nur Mohammed.
I'm replacing him, actually, Madam Clerk,
Oh,
right now.
I'm sorry.
And I vote yes.
Mr. Shifki.
Oui.
Dr. Ellis.
Yes.
Mr. Lloyd.
Yes.
Mr. Cram.
In favor.
Mr. Hoback.
Yes.
Madame Michaud.
En faveur.
Mr. Julian.
Oui, yes.
Yeas pour 11, nays contre 0.
Clause 7, as amended, carries. Thank you. It takes a team to make it happen. Clause 37, as amended, carries. Shall Clause 38 carry? Mr. Lloyd has a question.
Can the officials tell us what the effect of Clause 38 is for the people back home watching?
Thank you for the question. These provisions establish the record-keeping requirements of the CFO with respect to licenses that are suspended further to a yellow flag regime or revoked as a result of a protection order. These provisions have been amended to require the CFO to keep track of changes and variations to prohibition and protection orders. Previously, this provision obligated the CFO to keep records of only prohibition orders and their issuance rather than the variants or revocations.
Okay.
On division.
On division. So Clause 38 carries on division. Thank you all. Shall Clause 39 carry? On division?
Ask the officials what the impact.
Mr. Lloyd has a question.
Can the officials give us an explanation on Clause 39? Yes, Clause 39.
Yeah. Thank you very much. So this provision authorizes the Commissioner, the Registrar, and the CFO to disclose specific personal information to law enforcement agencies if there are reasonable grounds to suspect an individual is using or has used a past or current license to purchase a firearm for illegal trafficking purposes. The provision also, in the spirit of transparency, outlines what specific information may be shared.
Now, is this the police going to the CFO saying, we require this information, you give it to us? Or is this when the CFO suspects that something is happening and they're calling the police and giving this information?
It's the latter.
The CFOs.
That's right.
And what are the investigatory powers of the CFOs to determine this is happening? Like, how did this get flagged to the CFO?
So in terms of, sort of general trafficking, so my colleague, Ms. Paquette, earlier spoke about questions of if they were seeing large number of purchases, unusual purchase patterns or registration patterns that they could sort of say, well, perhaps we'll share this with local law enforcement for investigation purposes.
Thank you. I appreciate that. We can do on division.
39 carries on division. Okay. Shall Clause 40 carry? On division? On division. Brings us to Clause 41 and CPC 22. Note that if CPC 22 is adopted, BQ 19, Lib 9, PV 13, and NDP 16 cannot be moved due to a line conflict. Mr. Lloyd, if you want to move CBC 22.
Happy to move this one forward on behalf of Ms. Dancho, who's not here at the moment. Inform within 48 hours of protection order.
Okay, is there any discussion on CPC 22? Madame Michaud.
Merci, Monsieur.
Thank you, Mr. Chair. I appreciate the amendment from our colleagues, but I have an amendment that goes in the opposite direction a bit. It refers to a shorter time frame, so I will be voting against.
Thank you. Is there any further discussion on this amendment? Seeing none, we'll have a recorded division, please.
Madame Demoff?
No.
Mr. Chiang?
No.
Mr. Gahir?
No.
Mr. Blois?
Contre.
Mr. Shifke?
Contre.
Mr. Lloyd?
Yay. Yes.
Dr. Ellis?
Yes.
Mr. Cram?
In favor.
Mr. Hoback?
Yes.
Madame Michaud?
Contre.
Mr. Julian?
No, contre.
Yeas pour 7, yeas pour 4, nays contre 7.
Thank you. The amendment is defeated. This brings us to BQ 19. In the name of Madame Michaud, note that if BQ 19 is adopted, Lib 9, PV 13, and NDP 16 cannot be moved due to a line conflict. Madame Michaud, allez-y, s'il vous plaît.
Ms. Michaud, go ahead, please. Here, well, our colleagues suggested 48 hours, and here in this amendment, the time frame is 24 hours. And this is the time frame to inform the Chief Firearms Officer when it comes to the protection order. And I asked the question to Ms. Martin, and she was saying that replacing this with "without delay" would be a bit vague, and that there was need for precision. Ms. Reando from a women's organization defended this idea of 24 hours, and she says that the information should be circulated quickly, otherwise this leaves too much time to a spouse or a partner to take action. So this, again, is to ensure a higher level of safety for women who are victims of violence, and I hope colleagues will vote in favor. This is the same as Lib 9, I believe. So that's it. Thank you.
Merci. Mr. Lloyd?
I want to ask the officials, not sure which official would have the best experience with this particular case, but what is the common practice right now for the amount of time it takes when a protection order is issued and the CFO being informed?
I'll start, and then maybe I'll hand it off to my colleague. But there is varying degrees of processes throughout the country. Some provinces actually receive these orders electronically, and they're able to process them very quickly. Others don't receive all of them at all. Some of them receive that actually have to go to, is it provincial court? I think I'll hand it off to Rob McKinnon right now.
Yeah, just to follow up on Madame Paquette, there are variations across the country based on volume as well as the means in which they receive the orders. They are prioritized, obviously, within CFO offices now, so there would be an amendment to our current standard operating procedures in order to meet this requirement.
And slipped my mind for a moment here, but so these orders, sometimes they're immediate, but sometimes, oh yeah, the question is, like, why, so there's different processes across different provinces. Is this a provincial responsibility currently? Is that why?
Yes, and all provinces have different systems, so they're not a common system.
So is there like a constitutional concern here that, I agree with the sentiment behind it. We had our own amendment to say 48 hours, so obviously we're not against it, but is there a constitutional, provincial, federal, can the federal government dictate to provincial courts that they need to do something within a certain time period?
You'll see timing standards throughout the criminal code. The criminal code is largely administered by provinces and applied by courts, so my answer is yes.
Okay, thank you.
Thank you, Mr. Lloyd. Any further discussion on BQ 19? Seeing none, pass on division. On division? Okay. So therefore, Lib 9 cannot be moved. PV 13 cannot be moved. NDP 16 cannot be moved. And that brings us to that brings up to shall clause 41 carry. On division? Carried on division?
Nope. This is
Mr.
clause
Lloyd has a question.
41, correct?
I'm sorry?
Clause 41, correct?
Sorry, 41 as amended, and Mr. Lloyd has a question. Thank you.
Can the officials explain what the impact is of clause 41 for the folks at home?
Thank you. So the amendment would amend Section 89 of the Firearms Act from every court, judge, or justice to every competent authority that makes, varies, or revokes. So it's just a changing of the libellé, like the labeling, and then there's a timing requirement that has been changed through an amendment with regards to CFOs informing without delay, or in this case 24 hours, of a protection order being either issued, varied, or revoked.
Now, what is the distinction being made between the courts and the competent authorities? Like, what competent authorities are we talking about?
Earlier this evening, we talked about, or the committee talked about, questions of prohibition, various prohibition orders and the definitions that they can be issued by entities other than the courts. And so in terms of this is a broader language that would encompass courts as well as other competent authorities that are not courts.
Okay. Thank you very much.
Any further discussion? Shall clause 41 as amended carry? On division? That brings us to clause 42. Shall clause 42 carry? On division? On division. That brings us to clause 43. BQ 20. So if BQ 20 is adopted, BQ 21, NDP 17, CPC 23, NDP 18, and NDP 19 cannot be moved due to line conflict. Madame Michaud, allez-y, s'il vous plaît.
Ms. Michaud, go ahead, please. Thank you, Mr. Chair. If you allow me, I'm not going to move BQ 20. I will rather move BQ 21.
21, sorry, BQ 20 is withdrawn. BQ 21, if BQ 21 is adopted, NDP 17 cannot be moved due to a line conflict. Madame Michaud, allez-y, s'il vous plaît.
Ms. Michaud, go ahead, please. Thank you, Mr. Chair. So we are at clause 43, the infamous exception for handguns. So here we are strengthening the measure by introducing the same requirement that is in place in Quebec at the moment. So this letter that needs to be sent by a national or provincial sports shooting organization, this letter should be sent annually. So we're simply adding annually. The word annually is being added. So I believe this reinforces the bill. When it comes to the exceptions regarding competitions, the requirement of an annual letter, as well as the eligibility to possess a restricted firearm, and there will also be a requirement to show membership to a sports shooting club. And this condition is limited at the time when the demand is made. And once the restricted firearm is purchased, that requirement actually stops, and that doesn't really make sense. In Quebec, there's a law that introduces this requirement. Such holders are required to demonstrate that they are actively continuing to engage in sports shooting for the time, for the duration of them possessing such firearms, or prove active membership to a sports club, sports shooting club, including Olympic disciplines. This might be later in the text. So I hope that colleagues will be in favor of this amendment, which requires that a letter must be provided annually. There are similar ideas later on, I think. Some of them may be more restrictive, but annual requirement might be a reasonable compromise.
Merci. We'll go now to Mr. Muff, then Mr. Julian, and then Mr. Lloyd.
Thank you, Madame Michaud. This is a strong addition to the bill, and we will be voting in favor.
Thank you. Mr. Julian.
Merci beaucoup.
Thank you very much. And thank you, Ms. Michaud, for your amendment. I would like to move a sub-amendment that is in relation to NDP 17, because we have the same beginning, if you will, with reference to this annual requirement, but phrasing from NDP 17, it says meets the prescribed criteria, including respecting the minimum participation requirements. So with that, the amendment would read, meets the prescribed criteria, including respecting the minimum participation requirements, and provides annually a letter. So in this manner, because there will be other amendments that will follow, so the threshold is going to be higher, and as suggested by Ms. Michaud, an annual requirement will be introduced. So this will be a strict framework, but still offers the possibility for people to participate in the sport with these highest criteria.
We're going to Mr. Lloyd, and we're speaking to the sub-amendment at this point.
Is that 5 minutes? And then point of order, is that 5 minutes for the sub-amendment and 5 minutes for the amendment?
5 minutes, all of the whole.
Well, I just think, like, this seems like a ridiculous exercise. I mean, we know that licensed, vetted handgun owners are not responsible for almost all handgun crimes, violent handgun crimes that are committed in this country. And these paperwork requirements that we're just adding on are doing nothing to improve public safety. We're talking about, okay, if somebody doesn't go to a range in a year, over a period of a year, now they've had their, ability to own a handgun revoked if they can't provide this annual letter, which now we're, as a government, micromanaging what this letter has to say, So now we're putting this huge paperwork requirement on all of these clubs and all these sporting associations across the country to deal with tens of thousands or hundreds of thousands of members. And then who's receiving these letters? Is it the chief of firearms officers who will be receiving these letters? And we already have a huge backlog, or we have had backlogs in the past with, getting people's possession, acquisition licenses and other things. Now it's going to be the CFO's office's job to review hundreds of thousands of letters on an annual basis, all so that we can prove whether or not somebody's shown up to a club anytime in the past year, and whether they've met these prescribed minimum requirements. This just seems like we're making rules for the sake of making rules and making it look like we're doing something when there is absolutely no evidence to prove that providing this annual letter, and the NDP were originally proposing providing this every 6 months, is actually improving public safety in any way. But just to answer my question, maybe the CFOs can answer my question. Presumably, it would be your job to review these letters, would it not?
Maybe just before my colleagues answer, I just want to clarify. So the requirements with regards to having to do with when you register a handgun or when you're asking for an authorization to transport, 12.2 and 19.1 of the Firearms Act. So in other words, it's at the moment that you would seek to, it's an exception in order to allow the registration of a handgun for those that participate. So there's not a question of continual eligibility. It's a question of when you are transferring, acquiring, or transporting it.
Annual letter. It's an annual letter in that terminology.
Right. So, the question is I'm just sort of pointing out is the question of you were asking about who's going to be reviewing an annual letter in the requirements with regards to the national handgun freeze that is proposed in the bill have to do with at the moment of acquiring a handgun, people that are there's a class of individuals that are exempt, so it has to do at the moment of transfer. So a question of continual eligibility through a letter, unless there's a transfer happening, there, it's not that people, once they have the handgun, they get to keep it.
Okay, so this is when they're getting into the sport shooting. So I was confused. I thought we were talking about every single registered firearm owner across the country having to provide an annual letter, which would just be a huge paperwork exercise for everyone involved for very little. But even we're talking about, like when we're talking about Olympians, we're talking about half a dozen people that have would require these letters.
So the class of individuals that are described in the measure talks about people that are training, coaching, competing in a discipline that is at the discipline of the sanction, I believe the language is, on the program of the IOC, the International Olympic Committee, or the International Olympic Committee. So it does include people that are coaching, training in those disciplines. So it's more than just participating at the Olympics or at the Paralympics.
Thank you.
Thank you, Mr. Lloyd. Madame Michaud.
Oui, monsieur.
Thank you, Mr. Chair. I would like to thank Mr. Julian for the addition he suggested. I would be in favor, but I don't think it's so ridiculous. This already applies to sports shooters in Quebec in response to Mr. Lloyd's comments. So this functions very well in Quebec, so it should function as well in other provinces too. Thank you.
I would simply ask, and thank you, Ms. Michaud, for that comment. Is there any evidence from the exercise in Quebec that it has reduced crime, which it is purported to do? Because certainly, as we look at many of the proposals, they're lacking the evidence to suggest that it will actually accomplish what it's purported to.
Thank you. I don't know if that was a question for the officials. You have 12 seconds left. Anyway, is there any...
Unfortunately, I can't comment on any of the results of provincial legislation.
Okay, Mr. Muff.
Thank you. On the sub-amendment, I believe Mr. Julian is adding, it would be meets the prescribed criteria respecting the minimum participation requirements. Could someone define for me what participation requirements are?
I believe that, do the officials have an answer for this?
So just looking at it, it sounds to me like it would be something that would be defined in the regulations. And so the regulations, the normal regulatory process in terms of engagement with appropriate stakeholders and defining and proposing regulations and then coming back for finalization.
Okay, so we don't really know what the criteria would be. I have concerns without knowing what prescribed criteria are with supporting this, because I know Mr. Julian and I disagree on how much we should open up the handgun freeze, which is fine. This is a good thing when we have disagreements. We can't agree on everything, but I do have concerns that this could open it up beyond just the Olympic stream, which was what we are proposing in the bill.
Thank you. Please.
Thank you, Mr. Chair. There's a later amendment that would give the regulatory powers to the government. So we're not talking about a huge open door, but rather the possibility of some flexibility, as this committee has heard from sports shooters. And I should say we provided in other areas like airsoft some regulatory ability for the government. So I would suggest that that's entirely appropriate and within the government's purview.
Thank you, Mr. Julian. Any further discussion on sub-amendment? Madame Michaud.
Merci, Monsieur le Président.
Thank you, Mr. Chair. If Mr. Julian could clarify the intent, because I am also concerned that this might open a door with unknown consequences. So could he maybe clarify the intent behind his addition so that I'll have a better understanding on his sub-amendment?
Mr. Julian, if you wish.
Yes, thank you very much, Mr. Chair. So here the regulation will introduce certain rules when it comes to minimum participation. This offers greater flexibility for the government. It's the same framework of the bill that applies, but it gives the possibility to the government to introduce regulations, including minimum participation requirements.
Mr. Muff.
The government already has regulatory powers on this, so we don't need this amendment in order to be able to create regulations around handguns and the Olympic stream. That's already the intent, that there will be regulations around that. So we don't need to add this to it. I do like Madame Michaud's idea of providing a letter annually to ensure that you are part of that stream, but we won't be supporting it.
Thank you, Ms. Demoff. Any further discussion? Seeing none, I think we'll need to raise all in favor of the sub-amendment, please raise your hands. I'm sorry? Can't do a hybrid? We do it. So we got 6 over here, and opposed to close. So we have Mr. Blois, I can't see your hand.
Request a recorded vote.
I think maybe that's wise. Thank you. Let's have the vote.
Ms. DeMoff?
No.
Mr. Chang?
No.
Mr. Gahir?
Nope.
Mr. Blois?
Against.
Mr. Shifke?
No.
Mr. Lloyd?
In favor?
Mr. Couric?
In favor.
Mr. Cram?
In favor?
Mr. Hoback?
Yes.
Madame Michaud?
Contre.
Mr. Julian?
Yes, we.
Yeas pour 5. Nays contre 6.
The sub-amendment is defeated. So this goes back to the amendment, the main amendment. Is there any further discussion on the amendment? Seeing none. All in, on division? On division? Okay. Carried on division. Okay. So BQ 21 means that NDP 17 cannot be moved. Okay. That brings us to CPC 23. In the name of Ms. Dancho, I believe Mr. Lloyd might wish to move this.
Yep, happy to move it, Mr. Chair. Would you like me to speak on it?
Before you do, I should note that if CPC 23 is adopted, NDP 18 cannot be moved due to a line conflict. Go ahead.
We thought based on, we had a lot of testimony from a lot of shooting groups. So the original bill included an exemption for Olympic shooting, but it became very clear to us that there's a very vibrant culture of responsible handgun sport shooters, cowboy action shooting, IPSC, Paralympians, amongst others. And they were not being adequately covered by this legislation. And so understanding that, sometimes prescribing things in legislation is not the best way to govern or legislate, we have proposed adding a handgun shooting discipline as wording to allow some flexibility in determining, which, handgun disciplines or sporting activities would be legitimately allowed for getting a restricted license or a registration for a handgun. So that's why we're moving forward with that. Clearly, this is this is an important part of culture, particularly in Western Canada, and I think it's important that we not sterilize something that has not. Nobody's provided any evidence that these people conducting these activities have an increased threat to society, and so we should always err on the side of liberty, unless there's evidence to prove otherwise. Thank you. Maybe there's some other conservatives who have something to say on this, but
they can put their hand up and get on the list. At this moment, it's Mr. Couric.
Thank you very much, Mr. Chair. And certainly I think that one of the concerns that I've heard from a number of constituents, and quite often it's a surprise. I received a phone call from a retired elementary school principal that had taken up a type of sport shooting with a handgun and was truly distraught. They certainly are not Olympic sports, but it's something that he and his wife, after retirement, had taken up and found a great deal of joy in retirement in doing this. So I think that to complement Mr. Lloyd's point, I think that it's really unfortunate that there's such a narrow prescription here. and that really misses much of those who have been engaged in the handgun shooting more broadly, and certainly without acknowledging that is putting at risk of what was described, and I would agree, a very vibrant subset of Canadian culture. And certainly that is no more evident than in Western Canada, whether that be rodeo and the culture associated with that, whether that be there's Indigenous sport shooters as well. That it's not like they necessarily have IOC designations or prescriptions to how they do things. So to ensure that there's an expansion to include the full creativity of what these individuals' experiences might be, and to not limit what that should look like. I think it's common sense. I think that it's something that acknowledges that the understanding of a few here in the nation's capital prescribing across our country is certainly not what's best for this space in Canada.
Thank you, Mr. Moff.
Just briefly, Chair, this is one of the central pieces of Bill C-21. It's a policy difference that we have with the Conservative Party of Canada, and it's something that we are quite proud to be introducing. We won't be supporting this. It's, I think, something that we, as a policy, are deciding to take and move forward on. So we won't be supporting this amendment.
Thank you. Any further discussion? You have 1 minute and 14 seconds, Mr. Cram.
Okay, thank you, Mr. Chair. I think this seems like a very reasonable amendment by the simple fact that the number of sports at the Olympics is always changing and tends to be expanding every 4 years. Like I remember there was a time in my lifetime when curling was not even an Olympic sport yet, and that raises the question, if we ban these activities that are not yet Olympic sports, how are these activities and these sports ever going to evolve into Olympic sports if people don't have the opportunity to participate in them? So I think it's very reasonable to broaden the scope of this particular clause, and let's allow people to train and hone their skills, and when these activities do become Olympic events, we'll have a leg up and some extra medals for Canada at Olympic time. So thank you very much, Mr. Chair.
Yeah, that's a good point.
Thank you. Any further discussion? I'll call the vote on CPC 23. All in favor? Recorded division? Very well.
Mr. Moff.
No?
Mr. Shine.
No.
Mr. Gahir.
Nope.
Mr. Bloth.
I'm gonna abstain.
Mr. Shifke.
No.
Mr. Keurig.
Oh, it's me first now. Okay.
Oh, I'm sorry.
I'm in favor.
Mr. Lloyd.
In favor.
Mr. Cram.
In favor.
Mr. Hoback.
Yes.
Madame Michaud.
Contre.
Mr. Julian.
No, contre.
Yeas pour 4. Nays contre 6.
The amendment is defeated. That brings us to NDP 18. In the name of Mr. McGregor / Mr. Julian.
Thank you very much, Mr. Chair, and I would like to shout out to Alistair McGregor for his work on this committee, of course, you know, and in drafting important amendments. This is an important one as well, I would say, and as we get to the end of the amendments, I think the committee has worked really effectively together. The reality is the clause in the bill as it currently is stated does shut down the possibility of people who are engage in a rigorous and disciplined sport. And so what this amendment would do is expand from the International Olympic Committee and the International Paralympic Committee and include the International Practical Shooting Confederation and the Single Action Shooting Society. The International Practical Shooting Confederation, as you're aware, has a number of members in Canada. It is part of an international sports shooting association. There's about over 100 members countries, and many of those member countries include countries that have implemented handgun bans, and that is including the United Kingdom, New Zealand, and Australia. All of those countries, even after putting in place handgun bans, do allow members to train and compete in the International Practical Shooting Confederation events. So I voted against the Conservative amendment because it did open the door widely. The current law is very restrictive. This represents, I think, an ability for some people who engage in sports shooting in a very rigorous discipline to, as part of the International Practical Shooting Confederation, still participate in that sport. And it's potentially, those are future Olympians as well. So this is a narrow focus. We've already passed amendments that allow for a rigorous criteria. What this would do is allow those members that are part of the International Practical Shooting Confederation to participate. And Alistair McGregor, of course, has been a proponent for having a disciplined and a very rigorous application of the law, but allowing for those future Olympians and those who train to very rigorous standards through the International Practical Shooting Confederation to participate. So I would suggest this is in the same way that with airsoft we found a way through. We've ensured that the bill does comply with the highest standards, but with airsoft we have allowed for the government to set some regulatory framework. We've just adopted another amendment that allows the government, as Ms. Demoff has explained, to apply regulations. I would suggest that this amendment makes some sense. It doesn't open the door wide in any way, but it does allow for those who are part of a rigorous discipline sport to continue to participate. And as I mentioned, some of them may well be the Olympians of tomorrow. And when we look at other countries that have handgun bans in place, they have created an exemption for the International Practical Shooting Confederation. That seems to me to be a best practice that we can follow.
Thank you, Mr. Julian. Mr. Moff.
Thank you, Chair. So I mentioned before that this is a policy area where the New Democratic Party and ourselves, and I know the Conservative Party, don't agree with. We had Ken Price from the Danforth families here, and I remember Ken saying it's a decision about how you want to move forward as a country, and so the Liberal government has put forward a bill that will freeze handguns. We haven't banned them. We have put forward a freeze, and in fact, I will say, and I will give credit to Ken Price, because I remember very distinctly having a meeting with him, Chair, where he said, "Look, I would love to have handguns banned tomorrow. We had too much devastation on the Danforth, but maybe we freeze them, and it takes them out of circulation eventually." So the amendment put forward by the New Democratic Party would open up. We've already allowed an exemption for a pathway for potential Olympians, but even the International Practical Shooting Federation themselves have said that they expect their membership to grow considerably if there was an exemption that allowed them. And the concern, of course, is that people who want to get around the handgun freeze will join IPSC. And so the intent of being allowed to have an Olympic stream opens it up far too broadly. So I know that the New Democratic Party and Mr. McGregor in particular felt quite strongly about this. But, you know, it's something we feel very strongly about. Ken Price said when he was here at committee, I'm just going to quote him, in terms of a control measure or being able to say what kind of guns should be used or not, or there being a risk with the number of those guns will grow because suddenly somebody is an IPSC elite shooter. We're just very skeptical that that could be managed. We think it undermines an objective that we have. So thank you to Mr. Julian for the work that he has put in on this committee and on this bill. But on this particular amendment, it's not one that we're going to be able to support. I would also remind colleagues that handguns are not something that I think the vast majority of Canadians, when they're polled, support what we're doing in Bill C-21. I see Mr. Kirk doesn't quite agree with me there, but that's the truth. That when you ask Canadians whether they support a freeze on handguns, they do support this. The idea that we need to expand what's in the bill after doing review within government as to the best path forward, we could have chosen a path that didn't allow this Olympic stream, but we decided that we would put this in there. There will be regulations developed over how that path moves forward, but it's very important that we move forward with this, that we decide what kind of country that we want to be, how safe we want to be. And while I know my Conservative colleagues don't agree with me on that, we feel that this is in the interest of public safety. And I think if you listen to what the Danforth families have said and listen to what they went through with a gun that was in a gun shop in Saskatchewan when it was stolen. This isn't a gun that was smuggled across the border. Sorry, how much time have I got, Chair? I've just realized I'm...
31 seconds.
Okay. It was a gun that was in Canada. So I will leave it there for now, Chair. Thank you.
Thank you. So, Mr. Blois, you have 15 seconds left.
Mr. Chair, I just, if I had more time, I would have given the perspective from rural Canada, from where I sit on this particular issue, but I probably have just a few more seconds. So unfortunately, I'll have to save that for third reading in the House. Thank you.
Unanimous consent to let him have some more he has to say?
Give him more time.
Yeah. There is a request for unanimous consent to give to give 5 minutes more time for another round, I guess, of questions, of answers.
Yeah, Mr. Chair, the way it works is it's another 20 minutes
right.
By UC. I'm certainly willing to provide it.
I'm only asking for 5 minutes for Mr. Blois.
Well, it works, as Mr. Julian said. So do we have unanimous consent to extend another 20 minutes? No? Okay. That being the case, is there any further discussion on Mr. Please.
Well, I, for one, was very interested in what Mr. Blois had to say. A Liberal perspective from rural Canada is an increasingly rare thing to hear these days in the halls of Parliament, and I thought hearing something like that would have been truly a very interesting thing to hear, but unfortunately the Liberal Party would not they muzzled their own member, wouldn't let him speak, but we are where we are. You know, this is not a move about public safety. You know, I understand the Danforth families, and I feel for them, and Ms. Demoff was correct. I mean, firearm stolen, a legal firearm in the hands of a killer, It was stolen from a gun shop. But we have an epidemic of smuggled firearms on the street. If it hadn't been a gun stolen from a gun shop, it would have been a gun smuggled in from the United States. These criminals are determined to get these firearms, and despite our best efforts, they are getting them, and more needs to be done. And, you know, Mr. Chair, am I able to offer my time to Mr. Bloy?
I don't think that's within the spirit of the motion from the House.
Okay, well, I'll just continue on with what I have to say. Yep. Point of order. Is there anything, does the clerk have any perspective on that?
Well, it requires unanimous consent of the House order to extend debate on an amendment.
Give our time. Can we cede our time? Yeah. Like a minute of our time. We quite often share during committee questions.
Just ask the advice.
With unanimous consent, we can do pretty much anything. So, do we have unanimous consent for some of the conservative time to be used by Mr. Blaze?
Could we just suspend for a couple of minutes, Chair?
Sure. We'll suspend at the call of the chair for a few minutes. question is, the Conservatives have offered to give some of their time to Mr. Blois, and I believe if we have unanimous consent, we can do that. Do we have unanimous consent to do that? Agreed? Agreed. So, Mr. Blois, welcome, and you have 3 minutes and 52 seconds to speak.
Thank you, Mr. Chair. And as you recognized, I'm not a permanent member of this committee, so I don't have the benefit of hearing all the testimony that the members would have heard throughout the study on C21 and, of course, the proposed amendments. But I do want to give a perspective from my writing, and I certainly appreciate where Ms. Damoff is coming from and the idea that if we open up exemptions too far, it could undermine the government's policy intention. And I recognize it and I appreciate it. And I embrace the fact that we come from different parts of the country with different lived experiences, where we may approach this issue differently. Let me be very clear. This bill has a number of really important measures, and we need to get this through Parliament because it is going to make a difference for public safety. But I would be remiss without speaking to Mr. Julian's amendment, because I do think there is merit, whether or not in this amendment, but I hope that the government will consider ways to allow those who are competing competitively in other disciplines that are not Olympic sport shooting, such that there is recourse. I'll give you an example. Our former warden in the municipality of East Hants is Jim Smith. He actually appeared before this committee. He represents Canada and will participate around the world in IPSC-related events. One of his colleagues actually was just representing Canada and lost a handgun when Air Canada, the airline, actually lost the gun. Right now, there's no recourse for that gentleman to be able to actually obtain a new handgun and continue to compete. So I can actually, there's a tension on both sides of this, where I hear about the idea of a pile-in, and I think that that is legitimate, and I think that that has to be examined before we could move forward. But at the same time, as Mr. Julian had talked about, this is an internationally federated body. If there was one organization outside of the Olympic shooters that I think that this committee and indeed this government should consider, I think it's IPSC. And Mr. Julian went to great lengths, I think borrowing from some of the work that Mr. McGregor had done to highlight that
I'm here. Stop the time. We seem to have a technical difficulty here. I'm sorry? Cliffhanger. I wonder what he was going to say.
Stay tuned next season.
Yeah.
Well, how much time? I could just pick up.
We may have to do that. I think we've lost him. Okay. Mr. Blois, you're back. So you have 1 minute and 20 seconds left.
The Tories are going to have fun with this one. They're going to make it look like somehow that my video get cut. No, but look, Mr. Chair, I just want to make sure that it's on the record. I appreciate where the government's trying to go with some of these elements, but I do think this is something that has to be examined. It'll be interesting to see as this goes back to third reading in the House, or whether or not it can be a regulatory measure. I don't want to penalize those that are actively competing or have a situation, whether or not it's a lost gun. You can appreciate these folks that actually shoot quite often. Sometimes their gun will actually just wear down and break. We have to have a provision for those who actually are gun owners today that are continuing to compete, that if something happens, they have some recourse. And I don't know the bill to that extent. I look forward to studying it prior to third reading at greater extent once we get through the amendments. But I want to make sure that perspective is on the table. And again, I brace it. I'm part of the team. I like what the government's doing on a lot of measures, but on this one, it is a bit difficult. And I do hope that moving forward, there can be a recourse, as Mr. Julian talked about. Thank you.
Thank you, Mr. Blois. So, Conservatives, you have 10 seconds left.
I just want to say that Mr. Blois brought up some very good points, and yes, I mean, this is a very punitive measure by the government, and if indeed we pass this motion or this amendment by Mr. Julian, and we find in a year or two that this is being used by criminals to threaten public safety, then let's revisit this. But at this time, there is no evidence that this is a threat to public safety, and so Conservatives will be in support of this amendment.
Thank you, and okay. Oh, Mr. Julian, go ahead.
How much time do I have left, Mr. Chair?
56 seconds.
Okay. 2 points. First off, the next NDP amendment prescribes minimum participation requirements for training, competing, and coaching in these disciplines, so a tight framework around this. Secondly, we are talking about a handgun freeze that is being put into place. A handgun ban in other countries is still allowed for participation from IPSC. So I would suggest we're not at the standard of countries like the United Kingdom, New Zealand, Australia, who have handgun bans, and yet they have found provisions for an exemption for IPSC. So I understand the arguments against. I think we have to go with best practices, and I think countries that have put into place a ban, which Canada is not doing, have allowed for exemptions for IPSC. I think that is a best practice that makes logical sense to follow.
Thank you, Mr. Julian. Okay, I believe there's no more discussion. So let us call a vote. All in favor? Well, actually, yeah, record division.
Ms. Demoff.
No.
Mr. Chang.
No.
Mr. Gahir.
Nope.
Mr. Blois.
I'm going to abstain.
Mr. Shifke.
No.
Mr. Keurig.
I'm in favor.
Oh, I'm sorry. Mr. Lloyd.
In favor.
Mr. Cram.
In favor.
Mr. Hoback.
Yes.
Madame Michaud.
Contre.
Mr. Julian.
Yes. I guess that goes to you, Mr. Chair.
Well, that's unfortunate. So the chair will vote with.
Do you want
I'm sorry? I think, I know the tradition is the chair votes to extend debate, but I'm not really sure how that works in this case. So I'm going to vote no.
Yeas 5, nays 6.
So the amendment is defeated. That takes us to NDP 19. Mr. Julian, if you please.
Thank you, Mr. Chair. Well, heeding the words of Mr. Blois, the idea of having prescribed minimum participation requirements for training, competing, and coaching in these disciplines, as I've mentioned, other countries have exemptions for rigorous participation in sports shooting. Those countries have handgun bans. We have a handgun freeze. And so it seems to me to have the government hear what Mr. Blois and others have been saying about the possibility of putting in place regulations that allow for those future Olympians to participate makes sense. So I would suggest that NDP 19, we just had the closest vote on this issue that we've seen throughout this entire saga of now a year for C21, right? A tied vote that you had to break. Mr. Chair, and I'm sure it was a difficult position that you were in. But I think that is a message to the government. What this amendment would do is provide for some framework around the government to potentially look at the message that they are receiving from the committee tonight, from 3 of the 4 parties, or members of 3 of the 4 parties. So I would suggest that adopting NDP 19 does allow for that rigorous framework, but also allows for the government perhaps to examine through regulation how they might look at some of the issues that have come up around sports shooting.
Thank you, Mr. Julian. Is there any discussion on NDP 19? Mr. Moff.
Chair, we won't be supporting this amendment for the same reasons as I said before.
Mr. Lloyd.
I'm a bit confused because I actually thought that this amendment it needed the previous amendment to pass in order for this amendment to apply, but this is a standalone amendment, Mr. Julian, and I'm just wondering how this is a standalone amendment achieves what it's trying to achieve.
Mr. Julian, if you wish to respond.
Well, it opens the door for the government to look at regulation prescribed on minimum participation requirements.
Yeah, so I think you're giving a great deal of deference to the government to decide, which you would think the government would be willing to give itself the power to decide. I always think that prescribing these things in legislation is kind of a clumsy way of doing things because, as we know, things don't always play out cleanly when they're written down. Situations change, the names of organizations change. Mr. Cram was just talking about how Olympic sports will change over time. But I think generally, conservatives aren't against this amendment, and so we'll be we will be voting in favor.
Any further amendments? Sorry, any further discussion on this amendment? Seeing none, I guess we shall conduct a vote. I'm told that a hand-waving vote doesn't really work. It's kind of against the House rules that we set up way back when. So we're going to do a voice vote, I think. I have to figure out. Actually, can we? I think we'll have to have a vote on this. A recorded division. I'm sorry?
Point of order.
A point of order, Mr. Carrick?
So it's somewhat a point of information. I know we've found a great deal of success at other committees that if it doesn't pass on division, you just go to a recorded vote.
Well, that's a good approach. Right now, I think we'll just go to a recorded vote because I think we're going to need it. So please call the roll.
Ms. DeMoff.
No.
Mr. Chang.
No.
Mr. Gahir.
No.
Mr. Lightbound.
No.
Mr. Shifke.
No.
Mr. Lloyd.
In favor?
Mr. Keurig.
In favor.
Mr. Cram.
In favor.
Mr. Hoback.
Yes.
Madame Michaud.
Contre.
And Mr. Julian.
Oui, yes.
Yeas pour 5, nays contre 6.
Thank you. The amendment is defeated. That takes us to shall clause 43 as amended carry? On division? On division? Okay. That takes us to clause 44 and CPC 24. Go ahead, Mr. Lloyd.
Yeah, I'll move this on behalf of Ms. Dancho. So I believe it's in the bill. There was concern about advertising of firearms, and there was some concern by the government that this was somehow leading to violence. And I think Conservatives just wanted to put forward this amendment because we don't want to have any unintended consequences. We wouldn't want to penalize, the film industry, for example. There's certainly images in the film industry of people getting shot and advertising of that. And the Canadian Forces or public safety personnel. I'd be interested to hear what the government has to think about that.
Mr. Moff?
Thanks, Chair. Overall, we support it. I just wonder if the Conservatives would consider an amendment that would just say, I'll just read the whole thing, Chair. It's adding the words "in their usual course of business." So it would say subsection 1 does not apply to persons or businesses that advertise in their usual course of business directly to or on behalf of the film industry, the Canadian Forces, or the public safety personnel.
Okay, there is an amendment on the floor. Is there any discussion on this amendment?
So if I'm hearing it right, it's the usual course of business is what you've requested to be added? And what do you mean by usual course of business? I'm sorry to ask you, but...
I think the thinking that I had with that was, you mentioned the film industry, for example. So if there's a company that is advertising to the film industry, it would be during the normal course of business to be advertising to the film industry. If it was just Joe that set up to advertise something, it's not his normal business, then he wouldn't be allowed to advertise. So it would be a company that would normally be in this business. I don't think it weakens it at all, Dane. I think it's just clarifying that this is their normal business, that they're advertising to the film industry or to the Canadian Forces or public safety. It's not somebody that sells widgets and decides to just do the advertising. So it's meant to clarify, not to weaken it in any way at all.
Okay, well, this might be the only Conservative amendment that gets passed, but I will support this. I think it could be a friendly sub-amendment, and I guess we'll see how it plays out in the legislation should it pass.
Madame Michaud, allez-y.
Thank you, Mr. Chair. Maybe the officials could let me know how we can interpret in the French version in their normal course of business. How would that be rendered in the French version, in your opinion? I think I would say something along the lines of persons or companies in their normal operations. But we will need to have a discussion on that.
Madame Michaud?
I'm just trying to clarify the legislative clerk when there are punctuation issues, they can modify that. But in this situation, would we need to know right away what the wording in French will have to be? No, we can have the translation tomorrow. You have my full confidence, Mr. Clerk.
Okay, is there any further discussion on the sub-amendment? Which is really an amendment. Anyway, never mind. We won't get into that. All in favor of the amendment, the sub-amendment? And Mr. Schiffke and Mr. Lightbound? Mr. Gahir already raised his hand. We're not getting a vote from. There we go. I'm told that that's not proper procedure when we're on Zoom, but we'll try and correct our errors and not do this anymore. Anyway, as I counted it, that was that was in favor and against. Who's no against? So I think that's unanimous, I believe. Okay. we'll sort that out. Anyway, so the amendment, the sub-amendment carries. So now we go back to the main amendment by Madame Michaud. Did you wish to speak again on this? Yes.
Oui, merci.
Oh, sorry. But Madame Michaud wished to speak to it. Yes.
Merci, c'est en effet la...
Thank you. Yes, I'd like to thank the Conservative colleagues for having moved this amendment, and this could have had a significant impact on the cinema industry and even public safety institutions or organizations that could have been impacted by this. So I will be voting in favor of this amendment.
So any further discussion on the main amendment as amended? Seeing none, shall we pass this unanimously? I believe it's unanimous.
I'll report this to the stand. Displeased. Should have had more conflict.
Oh, I'm sure we'll have other opportunities. Okay. So that brings us to shall clause 44 carry as amended. On division, okay. That brings us to clause 45 and NDP 20. Mr. Julian, if you please, in the name of Mr. McGregor.
Thanks very much, Mr. Chair. I believe this is consequential to the adoption of NDP 1 that we came back to. We adopted last night, came back to earlier this evening. What it would do, because we defined the protection order, what it would do is simply remove lines 9 and 10 from page 29 that talks about defining the expression protection order for the purposes of this Act.
Thank you, Mr. Julian. Mr. Moff.
A question for officials. Is this just a coordinating amendment, or what impact will this have? Because we want to make sure that the government can consult with provinces, territories, Indigenous stakeholders, and be able to develop regulations. Could you let us know what the impact of deleting this would have?
So thank you. So I believe earlier this afternoon, or at the beginning of the session today, there was a sub-amendment that was made to NDP 1, which reinserted the regulation making authority for the government. So therefore, you may want to consider keeping the regulation making authority for protection orders.
So to clarify, if we delete this, we're removing the regulatory ability?
It's an important coordinating amendment to keep both of them. So in the beginning, in the definition, I believe, and I'd have to go back and look, and perhaps the legislative clerk could read out again. It talks about means as prescribed, I believe it was, and so it would be important to kind of list them in both places.
Well, in that case, Mr. Chair, I'll ask through you for unanimous consent to withdraw it.
Absolutely. I think we have that consent. That brings us to G44. In the name of Mr. Nur Mohammed, Mr. Moff, would you like to move this?
I would be happy to move it, Chair. And you know, before we started this bill many, many months ago, I did a handy-dandy little cheat sheet of my own with all the ghost gun amendments, and G44, I believe, is the last coordinating amendment that will add, I would think it's firearm parts. Yes, indeed it is. So much like the previous 40 amendments, this is adding 2 words to this particular clause. It's a coordinating amendment that is married to the amendments that we passed last night. I think all of us are losing track of which day we are in, but it was last night that we passed. Or maybe even the day before. It might have been the day before. Yes, Mr. Lloyd, I think, is right. So anyway, I trust that, like all of the other firearm parts amendments, that we can pass this unanimously.
Is there any further discussion on this amendment? Seeing none, do we have unanimous consent to pass this motion? Agreed? Carried. So that brings us to BQ 22. In the name of Madame Michaud. Madame Michaud.
Ms. Michaud, go ahead, please. Thank you, Mr. Chair. BQ 22 has the intent of regulating airsoft for transport, storage, and use, but we decided to withdraw airsoft from the bill, saying that the government has the option of regulating that, so I'm not going to move this amendment.
Okay, BQ 22 is withdrawn. All right. That takes us to BQ 23. Again, Madame Michaud, allez-y.
Ms. Michaud, please go ahead. Thank you, Mr. Chair. BQ 23 is the second to last coordinating amendment for magazine cartridges for colleagues who were not here with us. For almost all amendments on magazine cartridges, everyone was in favor. So this is just about coordination, so that there's a requirement of a valid license to acquire a magazine cartridge, the same as ammunition. So I hope that everyone will vote in favor. Thank you.
Thank you. Is there any discussion on BQ 23? Seeing none, do we have unanimous consent on division? On division? Okay. That brings us to BQ 24. Madame Michaud, allez-y.
Ms. Michaud, please go ahead. Thank you, Mr. Chair. Well, this is the last coordinating amendment on cartridge magazines. This way, the whole bill will hopefully be coherent when it comes to the requirement of a valid license to acquire cartridge magazines. I will ask that colleagues will vote once again in favor of this amendment.
Thank you. Mr. Lloyd.
Just a quick question to the officials. Is cartridge magazine the appropriate terminology?
Yes, it's actually defined in the criminal code.
Okay, thank you.
If I may, though, I just have a quick question, is that you're regulating the import and the export. Réglemente, mais est-ce que vous, je pense...
You are regulating the import and export, but I thought that you also had the intention of regulating acquisition. So just to make sure that you have the regulatory authority to do that. In all the amendments I've presented to coordinate with the first one, BQ3, this was based on the recommendation of the Legislative Council. But do you mean to say that there would be something missing? Thank you. We will, I think, just consult to make sure that it's not in the criminal code that the necessary regulations are.
Did you require some time to consult, or is that what I just heard?
I think if we can, maybe just not now, but I think we'd go back and kind of look at this, because I think there's a few others that you're talking at report stage, and this might be something that you can do at report stage.
Okay, very well, thank you. Is there any further discussion on this amendment? Mr. Moss.
Just to clarify what you were saying there, you think there may be other places where we need to add magazine? Is that what you were saying?
Thank you for the question. So because you are changing K1 with regard to respecting the importation, exportation, and then you're adding cartridge magazine, I just have just a little moment of doubt to just make sure that if there is regulation making authority that you want to do for acquiring, because the intent is to require a license to purchase a magazine, and I I would just want to make sure that that's absolutely clear.
Okay, thank you.
Any further discussion? Mr. Holmbeck?
You're unsure about, is this something we should park, or should we actually deal with it at this point in time?
So I think there's different ways you could look at this, and it could be a coordinating amendment that you do at report stage, as others that the committee has decided to park.
I think if this can be dealt with, if it becomes an issue, if it can be dealt with at report stage, I think it would be best, because we're going to be running out of time to get back to things we've parked. Okay. So I propose that we proceed to a vote on this amendment. Do we have unanimous consent on division? That brings us to shall clause 45 as amended carry. On division?
No, I want to discuss this one, actually.
Okay, Mr. Lloyd, go ahead.
I'm wondering to the officials, like, does the government currently have the capability of the governor and council making regulations for the repurchase? I mean, I kind of have a problem with the term repurchase because it wasn't the government that sold the firearms in the first place. Like, so I think a better term would be purchase of handguns by the minister. But can the officials, like, is this something that we need to actually put in law in words when I think, like, doesn't the minister already have the authority to do this?
So I'm sorry, you're saying that the government has the authority to repurchase? I don't see that written in the clause.
Point of order, Mr. Chair. I think Mr. Lloyd he was already looking at BQ 25 instead of referring to clause 45, but I haven't moved BQ 25 yet.
My apologies, I withdraw.
Okay, so shall clause 45 as amended carry. On division. This brings us to clause 45.1 and BQ 25, and I'm advised by our legislative clerk that Madame Michaud, please move it.
So you're giving me allowing me to move it?
Allow it, but you have to move it before I can disallow it.
D'accord. Merci, monsieur.
Okay, thank you, Mr. Chair. I understand what's about to happen, what you will say, Mr. Chair, but this amendment is about the repurchase of firearms, because it's been a long time. For a long time, the government has been promising such a program, but the details, we haven't had them just yet. So this creates stress among firearm owners about when their arms will potentially be illegal or prohibited, and they don't know what will happen to these firearms. Will they be able to sell it back to the government? So this amendment was intended to incite the government to take action rapidly, but I don't think that it will be deemed to be acceptable.
So, thank you. So the problem is, in the opinion of the chair, under my advice, the amendment proposes a new scheme which would impose a charge on the public treasury. And an amendment may not infringe upon the financial initiative of the Crown. So it's inadmissible on that basis. So, unfortunately, it's inadmissible. So we carry on to...
Merci, c'est gentil, mais non.
Thank you. That's very kind of you, but I do respect the chair's ruling.
And if we did manage to pass it, the speaker would yank it out quicker than you can think. Unless we give him some of this pizza. So, okay. So BQ 25, BQ 25 point, sorry, BQ 25.1, BQ 25.2. Do you wish to move them so that I can rule them also inadmissible?
Mr. Chair, I had more hope for the next two, but I do understand your intent. I will talk about my intent with these amendments, though. This is just to introduce a safeguard. For instance, if the government decides to change the category of a firearm, but this is about making it harder to do the opposite, taking a firearm from restricted to non-restricted. So this was the intent, just some additional protection. But what I understand is the following: when a regulation is done by the minister, we at the committee receive information about that, and we can ask the minister to appear before the committee. So it's about reviewing, for instance, an act or a law, the rather NCCOP's report, I wanted to say, which could be studied, which can be studied by the committee. That's how I approached it. But in any case, that was the intent, just to introduce a safeguard for the declassification of firearms. But I will leave it in your hands, Mr. Chair.
All right. So I had thought this was also imposing a charge on the Treasury, but it's not. It was, the notes say that it's admissible. It would be inadmissible because it goes beyond the scope of the bill. However, the House has given us kind of enormous more latitude and scope. So I think we'll debate this and let it, consider it admissible at this point.
Merci beaucoup, Monsieur le Président.
Thank you very much, Mr. Chair. I appreciate the decision. If colleagues have questions, I'll be looking forward to the questions, but for now, that's it from me.
Ms. DeMuff.
Thank you, Chair. So this is the amendment that would refer regulations to the committee, correct? Perhaps the officials could tell us what the process is now for regulations that are passed, because I think that would be helpful in understanding that it's my understanding that I'll let you explain it. You'll do better than I will.
Thank you for the question. I'll actually just start in French to clarify some of the points that Madame Michaud made. Vous avez parlé.
So you spoke about when the government resorts to regulation to change the classification of firearms. I will add that when the government resorts to regulation to change classifications, these are not done in regulations that are under the Firearms Act. The classifications are in the criminal code, so the regulation that changed the classification would fall under the scope of the criminal code, but these are not referred to committees at this point in time. So this request cannot be made that such regulations be brought before the committee. Thank you, Mr. Chair. Based on this answer, I understand that I should have maybe moved these amendments when we were talking about the criminal code, and that they don't really apply here. And it is also very out of the ordinary in the normal regulation process that the instrument authorizes the Governor and Council or refers the Governor and Council.
Normally, in legislation, regulation-making authority is given to the governor and council. It goes, the government uses those authorities to propose regulations, goes to Canada Gazette Part 1. Canadians are consulted, have a chance to make comments, and then it goes back for approval. In the case of the Firearms Act, any regulations that are made under the Firearms Act are actually required to be not only tabled in Parliament, but also referred to committees of both houses of Parliament. The amendments that are proposed here proposes to change it to not both houses of Parliament, but just the House of Commons. And the current regulation-making powers in the Firearms Act requires the regulations to be referred to committee, and after 30 sitting days can be made. And so it's up to the committees to whether to decide or make any interventions with the government. The change that is proposed here would require the approval of the committees, of this committee, because it's only the House of Commons that is included in this proposed amendment.
You may carry on, I believe.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Since we don't have much time left and also a few amendments, I would like to withdraw this amendment and the next one so that we can maybe save some time.
This amendment and the next one? Okay. Okay. So shall clause 46 carry? On division? Shall clause 47 carry? Question on clause 47.
Yeah, can the officials just give us an explanation on the impact of this clause?
Thank you for the question. So with regards to clause 47, this provision specifies that individuals who would not be eligible to acquire handguns under the proposed restrictions, i.e. non-exempted persons, would still be able to acquire any handguns that they purchased in the period between the tabling of the bill and its coming into force date. And so it's just basically a clarification. However, I will note that the government did bring into force regulations last fall in October of 2022, which brought into effect the restriction on handgun transfers.
So what is the relation between the regulation that was in place in October and this amendment?
So in terms of the, I'm not sure which one would apply first. Maybe I could lean on my colleagues here from Justice.
I mean, again, with respect to clause 47, it's transitional with respect to what's in the Firearms Act. Basically, if you've initiated that process in advance of the coming into force date, that process should continue in the sense that the new provision that comes into force while that process is underway wouldn't apply. But I think what my colleague is referring to is that as of the institution of the regulatory handgun freeze, there won't be a lot of those cases.
So this is not going to retroactively punish anyone?
No.
Okay.
No.
I can go on division.
So clause 47 carries on division. Very well. Shall clause 48 carry on division? So for clause 49 and for a while, we have the availability of the nuclear people, the, I'm sorry, what's the name of the organization? CNSC. So if they would like to join us at the table, I believe we have some, they have been waiting. These guys have been waiting for months, right? So we have, if my notes are correct, from the Canadian Nuclear Safety Commission, we have Pascal Bourassa, Acting Director General, Directorate of Security and Safeguards. We have Pierre Daniel Bourgeot, Council Legal Services. So that brings us now to Clause 49. Shall Clause 49 carry?
I'd like to ask the witnesses here who've been watching this whole time, is there anything that they'd like to say about this clause and what will be the impact on their sector?
Thank you for the opportunity for the Canadian Nuclear Safety Commission to respond to your questions. So I'd like to make a general statement with respect to the proposed amendments to the Nuclear Safety and Control Act. This is to put in place better clarity on an already existing scheme that we have in place for the security of nuclear facilities across Canada. So basically, it's bringing two major or two changes, giving the Commission the opportunity to designate peace officers for our nuclear security officers, as well as give the provisions to authorize our licensees, designated licensees, to be able to purchase arms. So this is the gist, if you want, of the amendments that are being proposed with these amendments. Thanks.
Thank you. And before I turn over to my colleague, use up all the conservative time, I worry that this amendment, which I think is positive, I worry about where these members of yours are going to be able to purchase any firearms in this country after this bill passes. But we'll see. Maybe there'll be a specialty store just for nuclear safety personnel. Thank you, and pass that on.
Mr. Carrick, go ahead.
Thank you, Chair. How much time is left? Just
3 minutes, 37.
Okay, thank you. You know, just to make a general comment, I find it really ironic and somewhat troubling, quite frankly, that you know, we're having to see carve-outs for, in this case, a federally regulated space, justifiably so, that would allow for, you know, firearms to be purchased. It's troubling that the government seems to be carving out these things, and of course, we in this place and the security personnel that I know we all appreciate very, very much, our peace officers that work diligently on our streets, and I know the tragedy that was faced by one earlier today. There's a whole host of concerns, but we're telling Canadians that they cannot use firearms or handguns. But we're expecting and anticipating and even carving out areas of society where we expect them to protect us. The irony is rich, and I think very, very unfortunate, and speaks to some of the flawed logic and ideology to which is driving this legislation, and leaves a certainly sour taste in the mouth of so many of my constituents, and I would suggest many across the country, including in many Liberal ridings as well. And it's not, you know, it's surprising, Mr. Chair. And then I do have a question for these folks, because I've heard from, ironically, when I get an email from somebody in Toronto asking me to fight on their behalf because their MP won't even return their emails or calls, man, it's quite a situation, and because they're a sports shooter, or because they're a collector, or because they fall within this designated category that the Liberals have said you're no longer acceptable to be able to practice your sport, whatever the case is. And I think that's really, really unfortunate. I would, Mr. Chair, ask the question just in relation to the constitutional provisions that dictate the responsibility of firearms to provinces. Just wondering if our folks from the Nuclear Commission, and maybe our departmental officials as well, can just comment as to where this overlap between provincial licensing versus where the carve-out for nuclear facilities and designating peace officers would be.
Thank you for the question. So nuclear installations are federally regulated, and hence why we're proposing amendments that will allow this federal approach to ensuring that the nuclear installations, high security sites across Canada, are have efficient and effective nuclear security programs in place. And so because it's federally legislated, then we apply this federal approach.
Thank you. And just to follow up, if I could, Chair,
Seconds.
Okay, thank you. So the peace, are there currently peace officer designated law enforcement personnel on these federally regulated facilities currently? And if so, what level of government are they certified under?
So there are some nuclear security officers that do have peace officer status in some provinces at the provincial level. And what we're trying to achieve here is to have this consistent federal uniform approach so that all the installations that are across Canada will have peace officer status at the federal level.
Can you list the provinces where this would currently apply?
No more time. Go to Mr. Julian, then Madame Michaud. Mr. Julian?
Thank you, Mr. Chair. As we talk about this clause, I just wanted to thank you and thank all members of the committee. We've gone through almost all the amendments, half a dozen minor amendments to come, and an important one upholding the rights of Indigenous peoples that I'm sure will be accepted unanimously. So that's been quite an endeavor over the last couple of days. You've led us brilliantly, Mr. Chair. And I'd like to thank the officials as well, that we got through all the volume. We had 178 pages when we started this yesterday, and we've gotten through everything. It's quite remarkable. So as we consider this one of these last clauses, I wanted to thank everybody for working together really effectively. I think this is a good indication of how strong our democracy is. When we work together, and most of the amendments that were adopted with the support of all four parties, that shows real cooperation and engagement in making the bill better. The bill coming out of committee is much better than the bill coming in.
Thank you, Mr. Julian, and thanks on behalf of everyone you thanked. Madame Michaud, allez-y, s'il vous plaît.
Ms. Michaud, please go ahead. I'm actually just going to thank colleagues and officials especially who have been with us for many days, technicians, interpreters, clerks, analysts who have been here with us hours on end. That has been extremely valuable. So thank you.
Thank you. Madame Mr. Moff.
You almost did what Mr. Ruff did there, didn't you? So Mr. Julian started some thank yous, and I know when we get to midnight that the way we're doing this is going to change a little bit. So we won't get an opportunity to speak to the amendment in the bill that ensures that we're not derogating Indigenous Peoples Section 35 charter rights. But mostly, I just wanted to say thank you to our colleagues, to the chair, to the clerks, to the legislative clerks, but to the officials who've been so kind and so patient and so incredibly knowledgeable guiding us through this. And it's a long time that we've all been sitting here, and we are eternally grateful to the dedication as public servants and what you do for our country. So thank you for helping guide us through this bill.
Thank you. And it's great to hear these sentiments. It's kind of feels like we're done, except we're not. We have miles to go before we sleep. So let us go back to the business at hand. Shall Clause 49 carry? On division. Shall Clause 50 carry? Mr. Lloyd.
Thank you, and I didn't want to be the only party that didn't get to say anything. I do want to thank the officials. I know it's been a bunch of late nights. It's been many months of engagement on this, and I want to thank our able committee staff for your dedication and the late nights and all the requests that we make. I know it's not easy, and the interpretation staff as well. I know a lot of these are very highly technical terms, but I don't think we've had a single, well, maybe not many serious translation problems, and so I want to say that's a testament to the professionalism of the translation staff. I mean, one thing I will say is, there were some things in this legislation I just don't believe that that this was the best way to get through this. This is a very complicated piece of legislation, and a lot of these things are going to impact people in very serious ways. And we're talking about changes to the criminal code. We're talking about changes to the Firearms Act that carry criminal penalties, and to speed through these things in 5 minutes. I mean, it's certainly efficient as the government wants it, but we're trying to build legislation for a country, and it's serious legislation that has a serious impact on folks. And so as Conservatives, I think we came here with a genuine desire to try to make, despite opposing the overall agenda of the government on this front, we came forward with a desire to try to mitigate any of the damage to law-abiding firearms owners in this country. And I don't think we were overall successful, but this will continue. And I look forward to future debates because I think there's a lot of improvement that needs to be made. And with that, I do want to thank our colleagues, from all parties. It's been a lot of long nights together and a lot of strong disagreements on things, but a lot of people, email our offices. I'm sure we all get them and said, why can't you guys all get along better? And I say to them, I said, this is what parliamentary democracy is about. It's not about everyone agreeing about everything. It's about everyone standing up for what they believe in, pushing up against each other in debate. And the country gets not the perfect thing, but and certainly Conservatives think that this legislation is far, far, far from perfect. But you get something that has some semblance of the will of the nation. And so I do appreciate the exercise that we've done here today. Unfortunately, it was time allocated, so we weren't able to, give the time needed to make this legislation, improve this legislation in a way that we would have wanted. But I do appreciate the opportunity to be here, and it's a real privilege to be a member of Parliament with this team of extraordinary people from across the country. And with that, I'll close my remarks. Thank you, Mr. Chair. And thank you, Mr. Chair, to you and all your hard work.
Thank you. And you magically brought us to the witching hour. It is 11:59. There you go. Shall Clause 50 carry? On division. Okay, so we've reached the point where there's no further debate. I propose that, given there are no amendments for Clause 51 through 69, that we have unanimous consent to carry them all?
No. Chair. We want to move through each clause.
All right. Shall Clause 51 carry?
On division.
On division. Shall Clause 52 carry? So for Clause 52, and I would thank the members from the CNSC for joining us. Theoretically, at this point, we have the members from CBSA here as well. We can't ask them questions, of course, but I would certainly like to. I will. So we have, from the Canada Border Services Agency, we have Mr. Jeff Robertson, who has valiantly stuck around for these many hours and days even. Thank you for coming. Mr. Robertson is Manager, Inadmissibility Policy Unit, Strategic Policy Branch. Unfortunately, there is no more debate, so thank you.
Point of order, Mr. Chair.
I'm sorry?
Point of order.
Quick point of order.
Just to note that we have a witness before the committee who, by nature of the motion that was passed in the House, is not allowed to give testimony.
Thank you for point of order. Okay. So shall Clause 52 carry? On division. Shall Clause 53 carry? On division. Shall Clause 54 carry? On division. Shall Clause 55 carry?
Recorded vote.
Recorded vote on Clause 55, please.
Ms. DeMont.
Yes.
Mr. Chiang,
Yes.
Mr. Gahir,
Yes.
Mr. Nur Mohammed,
Yes.
Mr. Shifke,
We.
Mr. Lloyd,
Favor.
Mr. Couric,
Yes.
Mr. Cram,
In favor.
Mr. Hoback,
Yes.
Madame Michaud,
En faveur.
Mr. Julian.
Oui, yes.
Yeas pour 11, nays contre 0.
Thank you. Clause 55 carries. Shall Clause 56 carry? Recorded division. Please conduct the division.
Yes.
Mr. Chang,
Yes.
Mr. Gahir,
Yes.
Mr. Nur Mohammed,
Yes.
Mr. Shifke,
Oui.
Mr. Lloyd,
Yes.
Mr. Couric,
Yes.
Mr. Cram,
In favor.
Mr. Hoback,
Yes.
Madame Michaud,
En faveur.
Mr. Julian.
Oui, yes.
Yeas pour 11, nays contre 0.
Clause 56 carries. Shall Clause 57 carry?
Recorded vote.
A recorded vote.
Ms. DeMont.
We'll go through a fast stretch after
Yes.
this one.
Mr. Chang,
Yes.
Mr. Gahir,
Yes.
Mr. Nur Mohammed,
Yes.
Mr. Shifke,
Oui.
Mr. Lloyd,
Yes.
Mr. Couric,
Yes.
Mr. Cram,
In favor.
Mr. Hoback,
In favor.
Madame Michaud,
En faveur.
Mr. Julian.
Oui, yes.
Yeas pour 11, nays contre 0.
Thank you. Clause 57 therefore carries. Shall Clause 58 carry? I'm sorry?
Point of order. Do the officials still need to stay since we cannot ask them questions?
Send them home.
I think that's a valid point.
We're just keeping track.
I'll keep track.
Yeah.
we allowed to stay?
You are absolutely allowed to stay.
Thank
We
you.
welcome your company. We appreciate your company. But I think it would be the sense of the committee that if you wish to leave, you're free to do so. Thank you. And again, we really do appreciate all the time you've spent. And, you know, we're going to have a reunion one of these days. Yes. Okay. Not at midnight.
But not doing this, Mr. Chair, please. Doing something else, perhaps pizza.
Yeah. I've been to a gun range. I've had fun. So we're on 57, are we?
58.
58. Shall Clause 58 carry? On division. Shall Clause 59 carry? Shall Clause 60 carry? Okay. Shall Clause, it'll be in the minutes, I'm sure. Clause 61, shall it carry? On division. Shall Clause 62 carry? Shall Clause 63 carry? On division. Shall Clause 64 carry? On division? There we go. Shall Clause 65 carry? Recorded vote. Just keeping us on our toes.
Well, no, this one, yeah. I want it
Okay.
recorded, so.
65 record division, please.
Ms. DeMoff,
Yes.
Mr. Chang,
Yes.
Mr. Gahir,
Yes.
Mr. Nur Mohammed,
Yes.
Mr. Shifke,
Oui.
Mr. Lloyd,
No.
Mr. Couric,
No.
Mr. Cram,
Against.
Mr. Hoback,
No.
Madame Michaud,
En faveur.
Mr. Julian.
Oui, yes.
Yeas pour 7, nays contre 4.
Thank you. Therefore, Clause 65 carries. Shall Clause 66 carry?
Recorded division.
Recorded division.
Ms. DeMoff,
Yes.
Mr. Chang,
Yes.
Mr. Gahir,
Yes.
Mr. Nur Mohammed,
Yes.
Mr. Shifki,
Oui.
Mr. Lloyd,
No.
Mr. Keurig,
No.
Mr. Cram,
No.
Mr. Hoback,
No.
Madame Michaud,
En faveur.
Mr. Julian.
Oui, yes.
Yeas 7, nays, contre 4.
Thank you. Therefore, Clause 66 carries. Shall Clause 67 carry?
Division.
On division. Shall Clause 68 carry? On division. Shall Clause 69 carry? Recorded vote.
Ms. Demoff,
Yes?
Mr. Chiang,
Yes.
Mr. Gahir,
Yes.
Mr. Nur Mohammed,
Oui.
Mr. Shifki,
Oui.
Mr. Lloyd,
Yes.
Mr. Keurig,
Yes.
Mr. Cram,
Yes.
Mr. Hoback,
Yes.
Madame Michaud,
En faveur.
Mr. Julian.
Oui, yes.
Yeas pour 11, nays contre 0.
Therefore, Clause 69 carries. Brings us to Clause 70. We have 4 amendments. CPC 25. Recorded vote on CPC 25. Go ahead.
Madame Demoff,
No?
Mr. Chiang,
No.
Mr. Gahir,
No.
Mr. Nur Mohammed,
Nope.
Mr. Shifki,
No.
Mr. Lloyd,
Yes.
Mr. Keurig,
Yes.
Mr. Cram,
Yes.
Mr. Hoback,
Yes.
Madame Michaud,
Contre.
Mr. Julian.
Oh, contre.
Yeas pour 4, nays contre 7.
Therefore, CPC 25 is defeated. We go now to CPC 26. Recorded vote.
Madame Demoff,
No?
Mr. Chiang,
No.
Mr. Gahir,
Nope.
Mr. Nur Mohammed,
Nope.
Mr. Shifki,
No.
Mr. Lloyd,
Yes.
Mr. Keurig,
Yes.
Mr. Cram,
Yes.
Mr. Hoback,
Oh, yes.
Madame Michaud,
Contre.
Mr. Julian.
No, contre.
Yeas 4, nays contre 7.
Thank you. Therefore, CPC 26 is defeated. Next, we go to CPC 27 on division. Hold up. I think we need a recorded vote on this.
Let's try.
On which?
27.
We should have saved it for the whole bill.
It was nicely done, though.
We almost got away with it, too.
Please conduct a vote.
On?
27.
We're going back?
CPC 27. We didn't actually vote on it.
Yeah.
We almost did on division, but I don't think that was quite accepted.
Ms. Demoff,
No.
Mr. Chiang,
Nope.
Mr. Gahir,
Nope.
Mr. Nur Mohammed,
Nope.
Mr. Shifki,
No.
Mr. Lloyd,
Yes.
Mr. Keurig,
Yes.
Mr. Cram,
Yes.
Mr. Hoback,
Yes.
Madame Michaud,
Contre.
Mr. Julian.
No, contre.
Yeas 4, nays contre 7.
Thank you. CPC 27, therefore, is defeated. CPC 28.
Recorded vote.
Recorded vote.
Ms. Demoff,
No?
Mr. Chiang,
Nope.
Mr. Gahir,
No.
Mr. Nur Mohammed,
No.
Mr. Shifki,
No.
Mr. Lloyd,
Yes.
Mr. Keurig,
In favor.
Mr. Cram,
In favor.
Mr. Hoback,
Yes.
Madame Michaud,
Contre.
Mr. Julian.
Contre.
Yeas pour 4, nays contre 7.
Thank you. Therefore, CPC 28 is defeated. Brings us to shall clause 70 carry. On division? On division? Okay. Brings us to clause 71. CPC 29. Unrecorded vote on CPC 29.
Ms. Demoff,
No?
Mr. Chang,
Nope.
Mr. Gahir,
No.
Mr. Nur Mohammed,
Nope.
Mr. Shifki,
No.
Mr. Lloyd,
Yes.
Mr. Kirk,
Yes.
Mr. Cram,
Yes.
Mr. Hoback,
Yes.
Madame Michaud,
Contre.
Mr. Julian.
No. Contre.
Yeas pour 4, nays contre 7.
Therefore, CPC 29 is defeated. We go to CPC 30 next. Recorded division?
Madame Demoff,
No?
Mr. Chiang,
Nope.
Mr. Gahir,
Nope.
Mr. Nur Mohammed,
Nope.
Mr. Shifki,
No.
Mr. Lloyd,
Yes.
Mr. Courig,
Yes.
Mr. Cram,
Yes.
Mr. Hoback,
Yep.
Madame Michaud,
Contre.
Mr. Julian.
Contre.
Yeas pour 4, nays contre 7.
Therefore, CPC 30 is defeated. We go to CPC 31. I expect we need another recorded division.
Madame Demoff,
No?
Mr. Chiang,
Nope.
Mr. Gahir,
Nope.
Mr. Nur Mohammed,
Nope.
Mr. Shifki,
Nope.
Mr. Lloyd,
Yes.
Mr. Courig,
Yes.
Mr. Cram,
Yes.
Mr. Hoback,
You bet.
Madame Michaud,
Contre.
Monsieur Julian.
No. Contre.
Yeas pour 4, nays contre 7.
Therefore, CPC 31 is defeated. Shall clause 71 carry? On division? On division? Okay. I'm
Point of order,
sorry.
Mr. Chair?
Go ahead.
Did we miss one? 44.1?
44, that's clause 72.1, so.
Okay.
Thank you for
Wouldn't
keeping-
want to miss that
For
one.
keeping us awake here. Shall clause 72 carry? On division?
What happened to clause 71? Did we pass that?
I thought we passed that on division, did we not?
We did? Okay.
Okay. That brings us to new clause 72.1.
Recorded division?
Well, firstly, we have motion G 44.1. So record division on G 44.1, please.
Wait a second. Just a sec. We didn't do, we didn't do 72. We're going to do 72 first, no?
I think we did clause 72 on division.
Okay. We didn't, no. Okay, we're good.
We're good? Okay. So we're on G 44.1. We need a record division, please.
Ms. Demoff,
Yes.
Mr. Chang,
Yes.
Mr. Gahir,
Yes.
Mr. Nur Ahmed,
Yes.
Mr. Shifki,
Oui.
Mr. Lloyd,
Yes.
Mr. Courig,
In favor.
Mr. Cram,
Yes.
Mr. Hoback,
We.
Madame Michaud,
En faveur.
Monsieur Julian.
Oui. Yes. Here.
Yeas pour 11, nays contre 0.
Excellent, thank you. So that brings us to Clause 73 and Amendment G45. If G45, is it withdrawn? Was it? Okay, I'll buy that.
But it's withdrawn.
G45 is withdrawn.
Oh,
I thought that was 46 that we
yeah,
were.
we are withdrawing it. I'm sorry.
It's withdrawn.
G45 is withdrawn.
Okay. We now have G45.1. Record division, okay?
Mr. Moff.
Yes?
Mr. Chang.
Sorry, Ron.
Yes.
Ron?
Mr. Gahir.
Sorry about that.
Yes.
Mr. Nur Mohammed.
Yes.
Mr. Shifki.
We.
Mr. Lloyd.
No.
Mr. Courig.
No.
Mr. Cram.
No.
Mr. Hoback.
No.
Madame Michaud.
En faveur.
Mr. Julian.
En faveur.
1, 2, 3, 4, 5, 6. Yeas 7, nays contre 4.
Thank you. Therefore, G45.1 carries. It brings us to PV 14, which is deemed moved, and of course, and I'm sorry? It cannot be moved.
It's related to section 1, and part of section 1 was...
Okay, PV 14 cannot be moved due to a conflict.
It's related to another clause that was repeated before.
Okay. PV 14 is blocked, moved. Okay. Shall clause 73 as amended carry on division?
Recorded vote.
Recorded vote, okay.
Ms. DeMoff. Yes. Mr. Chang.
Yes.
Mr. Gahir.
Yes.
Mr. Nur Mohammed.
Yes.
Mr. Shifki.
We.
Mr. Lloyd.
Nay.
Mr. Courig.
Opposed.
Mr. Cram.
No.
Mr. Hoback.
Opposed.
Madame Michaud.
En faveur.
Mr. Julian.
Oui, yes.
Yeas pour 7, nays contre 4.
Thank you. Therefore, clause 73 as amended carries. New schedule G46 has been withdrawn. So we get to the good stuff now. Shall the title carry?
Division.
Record division? Absolutely. Record division on the title.
Ms. DeMoff.
Yes.
Mr. Chang.
Yes.
Mr. Gahir.
Yes.
Mr. Nur Mohammed.
Yes.
Mr. Shifki.
Can I abstain? I'm just kidding. I voted for
How's he?
Shifki.
Mr. Shifki.
in favor.
Mr. Lloyd.
No.
Mr. Courig.
No.
Mr. Cram.
No.
Mr. Hoback.
No.
Madame Michaud.
En faveur.
Mr. Julian.
Oui, yes.
Yeas pour 7, nays contre 4.
Therefore, the title carries. Shall the bill, as amended, carry?
Division.
Recorded division. Okay.
From my
Carry on.
dead hands.
Ms. Demoff.
Absolutely, yes, we.
Mr. Chiang.
Yes, for me.
Mr. Gahir.
Yes.
Mr. Nur Mohammed.
Absolutely, yes.
Mr. Shifki.
100% yes.
Mr. Lloyd.
Point of order. No, sorry, he said 100% yes. Okay, never mind. Wasn't sure if it 100% no or something like that. Negatively no, nay.
Mr. Courig.
On behalf of millions of firearms owners, no.
Mr. Cram.
Never.
Mr. Mr. Hoback.
Absolutely no.
Madame Michaud.
En faveur.
Mr. Julian.
Oui, yes.
Yeas pour 7, nays contre 4.
I wish you could be more assertive in your voting, but anyway, the bill as amended carries, in fact. Shall the chair report the bill as amended to the House? On division?
Vote.
Recorded vote, okay.
It's your last chance to stop this thing.
There's actually one more chance.
Ms.
Go
DeMott.
ahead.
Yes.
Mr. Chiang.
Yes.
Mr. Gahir.
Yes.
Mr. Nur Mohammed.
Yes.
Mr. Shifke.
Yes.
Mr. Lloyd.
No.
Mr. Courig.
No.
Mr. Cram.
No.
Mr. Hoback.
No.
Madame Michaud.
En faveur.
Mr. Julian.
Oui, yes.
Yeas pour 7, nays contre 4.
Thank you. So the chair shall report the bill as amended to the House. Shall the committee order a reprint of the bill as amended for the use of the House at report stage? On division. I'm sorry, recorded vote? Okay. This is your last one, though. That's the last one I'm giving you.
Oh, we have to go back to clause 6.
Oh, there you go. Go ahead, please.
Ms. DeMoff.
Yes.
Mr. Chang.
Yes.
Mr. Gahir.
Yes.
Mr. Nur Mohammed.
Yes.
Mr. Shifke.
Yes.
Mr. Lloyd.
No.
Mr. Courig.
No.
Mr. Cram.
No.
Mr. Hoback.
No.
Madame Michaud.
En faveur.
Mr. Julian.
Oui, yes.
Yeas pour 7, nays contre 4.
Well, thank you. It has been a long, winding road that leads us to this point. And I'd like to thank you all. It's been, we all have the bruises, I know. I'd like to thank all of the committee staff in all their various shifts, our many, many clerks and legislative clerks, our ever-patient witnesses, and all of our staff. Thank you all, and good night.